Ladies and gentlemen, may I have your attention, please? From 10, we will begin the opening ceremony of the International Court Conference. So please, may I kindly ask all participants who are in the hall to take your seats. Please enter the hall and take your seats. Thank you. And to avoid disruptions, please kindly put your phones on vibrate or silent mode. We have simultaneous interpretation for the opening ceremony. Korean is channel number 1, English is channel number 2. The 2022 International IP Court Conference is being streamed live on YouTube channel, and please check the channel for your language of preference for the simultaneous interpretation.
이제 행사를 시작하겠습니다. 모두 착석하여 주시면 감사하겠습니다. 이제 바로 행사를 시작하겠습니다.
We will begin the conference.
Good morning, everyone. Welcome to the 2022 International IP Court Conference. 안녕하십니까? 2022 국제 특허법원 컨퍼런스에 오신 것을 환영합니다. I am 성진구, Judge of Patent Court of Korea. I'll be leading you through today's program. This year marks the 8th anniversary of the International IP Court Conference, and it's a great honor and pleasure for me to welcome all of you here. 저는 오늘 개회식 사회를 맡은 구성진 판사입니다. 올해로 국제특허법원 컨퍼런스가 제8회째를 맡게 되었습니다. 이렇게 큰 국제 행사에 이 자리에서 여러분을 뵙게 되어 영광입니다. The conference aims to serve as a venue for judges and IP experts around the world to share their expertise and enhance mutual understanding. In particular, we came up with various sessions to discuss major IP issues, in-depth understand of theme of court IP and new practice as we are moving on from COVID-19. 본 콘퍼런스는 세계 IP 전문 법관과 전문가들이 경험을 공유하고 상호 이해를 촉진하기 위해 마련되었습니다. 올해는 Court IP and New Practice라는 주제하에 코로나19 극복 과정에서 지식재산권에 관한 실무를 심도 있게 토론해보고자 여러 세션을 구성하였습니다. Today we are joined by the most prominent judges and experts in the field of IP litigation. Judges and IP experts from 7 countries are joining us. 오늘 이 자리는 특허 소송 분야에서 가장 명망이 있는 법관과 전문가들이 함께 하였습니다. 전 세계 7개국에서 온 법관과 IP 전문가들이 참석해 주셨습니다. I'd like to ask for your kind understanding for not introducing each of participants due to time constraints. 시간 관계상 일일이 소개해 드리지 못하는 점을 양해해 주시기 바랍니다. On behalf of the Patent Court of Korea, I'd like to extend my deepest gratitude to all speakers and participants for joining us this morning. 주최 측을 대리하여 오늘 이 자리에 함께해 주신 발표자분들과 참석자분들께 깊이 감사드립니다. Now I would like to invite Honorable Chief Judge Yong-seok Kim of Patent Court of Korea, the hostess of this event, to deliver his opening speech. 다음은 본 컨퍼런스를 주최하는 한국특허법원의 김용석 법원장님의 개회사가 있겠습니다. Please welcome him with a big round of applause. 김용석 법원장님을 큰 박수로 모시겠습니다.
네, 여러분 안녕하십니까?
Good morning, everyone.
2022년 제8회 국제 특허법원 콘퍼런스에
I would like to
참석하신
thank
여러분을
everyone for taking
환영합니다.
part in the 2022 8th
본행사를
International
전적으로
IP
지원해
Court
주시며
Conference.
축하 영상을 보내주신 김명수
First of all, I'd like to
대법원장님,
thank Chief Justice
귀중한
Kim Yong-soo
시간을
for his
내어 본 행사
congratulatory
현장에
video, and
직접
also
참석해 주신
I'd like to thank
세계
Professor
특허법과
Hwang
추진위원회
Young Lee, the joint chair of the Global
대표님,
Patent Hub Committee, for
평소
taking time out of your
지식재산권의
busy
발전을
schedule
위해
to be
많은
with us
노력을
today.
아끼지 않으시고
And
오늘 행사를 위해 동영상으로
I would
축사를
also like
보내주신
to thank
국제지식재산권기구의
WIPO's
조진슨 사무차장님,
Jorgensen Deputy Secretary General
국제라이센싱협회의
and the
나카토미
President
회장님,
Nakatomi of LESI and President Okuyama from AI, PPI, and President Pistolesi of FIC-IP, and President
아울러
Vink,
멀리서
President
이번
Vink of
콘퍼런스에 직접
INTA
참석하신
for
캐시비
your
큰
congratulatory
판사님,
messages.
제임스 멜러
In
판사님,
addition, I would like to
우리코
thank Judge
가츠마다
Kathy
판사님,
Vissoon and Judge
데이비드
James
번슈타인
Weller,
변호사님,
Judge
사샤
Kumiko
프레스
Katsumata,
변호사님을
Judge
비롯하여
David Bernstein,
온라인과
and lawyer
동영상으로
Sasha Press,
참석하시는
as well as
지식재산
all the
전문
IP specializing
법관님들과
judges and practitioners
실무가들께도 깊은
taking
감사의
part
말씀을 드립니다.
via online.
올해로
This
제8회를
year
맞이하는
marks
국제
the 8th
특허법원
year of the
콘퍼런스는
International IP Court
세계
Conference.
지식재산권법
It is
전문가들이
held to allow for
다양한
in-depth
쟁점들을
discussions
심도
on
있게
various
논의하는
issues surrounding
국제
the global
학술 교류 행사로
IP
자리 잡았습니다.
litigation field.
이번 컨퍼런스 대주제는
This year's conference
Court
theme is
IP
Court IP and New Practice.
우리가
We are
코로나19를
in the
힘들게
process
이겨나가고 있는
of
상황입니다만
overcoming
이번 컨퍼런스에서는
COVID-19,
일부 해외
and
패널을 직접
we have
현장에
invited
초청하였습니다.
some of our
또
overseas
최신
panels to
IP
Korea
동향,
this year.
부정경쟁 방지법,
Also, the recent IP
성격법,
trends,
손해
the
산정의
Unfair
세션에서
Competition
새로운
Prevention
논의를
Act, the
진행해
Trademark
깊은
Act,
토론을
and
합니다.
the session on
이를
calculating
바탕으로 한 모의
damages.
중재를 진행하여
All of these
구체적인
will be
사건에서
subjected to
적용되는
in-depth debate
국면을
as well.
살펴봅니다.
Based on this, we'll conduct a moot trial and
뉴
apply what we
프랙티스라는
have learned.
대주제에 걸맞게
In keeping with the
지적재산권에
theme of
관한
new
새롭고
practice, we have
심도 있는
organized
논의를 하기
today's
위하여
conference format
내용과 형식을
as
구성하여
such.
보았습니다. 올해 콘퍼런스는
In this year's
미국,
conference,
영국,
judges
독일,
and lawyers from the
일본,
US, UK,
중국,
Germany,
호주,
Japan,
한국
China,
등
and
여러
Australia
국가의
and Korea
법관들과
will gather together to
전문가들이
benefit
한 자리에
from this
모여
precious
지혜와
opportunity
경험을
to
나누는
share our
소중한 기회가 될
knowledge
것으로
and
기대합니다.
insights.
또
Also,
국제특허법원
I hope
컨퍼런스가
that this
지식재산 전문 법관과
conference will serve as an
전문가들
opportunity to
국제
further
네트워크의
strengthening
중심으로
the international
계속
network
발전해 나가기를
among
소망합니다.
IP judges and experts
이번
from
행사를
across the
위해
world.
헌신적으로 발표를 준비해 주신
I would like to once again express my deep gratitude to the moderators of each sessions and presenters for all the efforts you have put into today's event. And also my thanks goes to all the participants who have taken time out of their busy schedules to be with us today. Thank you very much.
네, 법원장님 감사합니다.
Thank you
Now
for
we are
your
going to watch
remarks.
a congratulatory message from Honorable Chief Justice Myung-soo Kim of Supreme Court of Korea, who is not able to attend due to other commitments. 다음은 오늘 행사를 축하해 주시는 김명수 대법원장님의 축사가 있겠습니다. 대법원장님께서는 일정상 참석하지 못하셨지만 이번 행사를 축하하는 마음을 담은 동영상을 보내주셨습니다. 함께 시청하도록 하겠습니다.
이는 전 세계 지식재산권법 분야의 발전을 위해서도 매우 뜻깊은 일입니다. 이번 컨퍼런스에서는 코로나19 극복 과정의 일환으로 해외 패널 중 일부는 현장에 직접 참석하고 있습니다. 멀리서 오신 미국의 캐시 비순 판사님, 영국의 제임스 멜러 판사님, 일본의 쿠미코 카츠마타 판사님, 미국의 데이빗 번스타인 변호사님, 독일의 사샤 프레스 변호사님께 깊이 감사드립니다. 그리고 온라인으로 참가하는 호주, 중국, 영국, 독일, 일본, 미국의 법관들과 전문가들께도 감사의 말씀을 드립니다. 아울러 알차고 유익한 행사를 마련하기 위하여 애쓰신 특허법원 김용석 법원장님을 비롯한 관계자 여러분의 노고와 헌신에 경의를 표합니다. 제가 한때 몸담기도 했던 특허법원은 공정한 재판을 통한 지식재산권의 실질적 보호를 사명으로 하는 곳입니다. 지식과 상상력이 경쟁력의 원천이 되는 지식기반 사회에서 과학기술의 발전에 따라 지식재산권의 중요성도 점점 커지지만 분쟁도 나날이 복잡해지고 있습니다. 이러한 분쟁 해결을 위한 지식재산권 재판은 그 특성상 과학기술에 대한 깊은 이해는 물론 사회 현상에 대한 통찰력과 함께 비교법적인 연구도 꼭 필요합니다. 여러 국가의 훌륭한 법관과 전문가들이 탁월한 식견과 풍부한 경험을 공유하고 활발한 토론과 교류를 하는 이번 행사의 결과물은 각국에서 더 좋은 지식재산권 재판을 위한 초석이 되리라 확신합니다. 코로나19의 위기에도 계속된 국제특허법원 컨퍼런스는 올해 IP, Court and New Practice라는 주제를 제시하였습니다. 코로나19 극복 과정에서 과학기술과 법에 관한 깊은 성찰을 토대로 실무에 실질적 도움이 되는 주제를 대상으로 지식재산권에 관한 새롭고 심도 있는 논의를 하는 것은 내용과 형식 면에서 새로운 방향을 제시하는 것입니다. 더욱이 세계적으로 사상 유례없는 고난과 역경을 초래하던 코로나19 대유행의 종식이 조심스럽게 전망되기에 이른 이 시기에 부정경쟁 행위와 상표 사건의 각 주요 쟁점들, 특허권 침해로 인한 손해액 산정 방법과 절차 등 구체적이고도 실무적인 주제에 대한 이번 논의는 코로나19로부터의 회복과 새로운 시대로의 준비를 위한 매우 시의적절하고 유익한 것이라 생각합니다. 독립된 법관이 공정하고 충실한 심리로 정의로운 결론에 이르는 좋은 재판이 대한민국 사법부의 헌법적 사명이자 국민의 신뢰를 얻는 유일한 길입니다. 이는 다른 나라도 다르지 않다고 믿습니다. 한 가지 소리는 아름다운 음악이 되지 못하고 한 가지 색은 찬란한 빛을 이루지 못하며 한 가지 맛은 진정한 맛을 내지 못한다는 고대 언어 철학자의 말이 있듯이 현장과 온라인 등 지리적 거리와 참가 방식에 구애받지 않고 전 세계 법관과 전문가들이 모여 진행하는 이틀간의 이번 학술 대회를 통해 지식재산권에 관한 좋은 재판을 구현하기 위한 다양하고 많은 지혜가 모아지길 기대합니다. 저는 여러 나라에서 찾아와 준 법관과 전문가 여러분을 따뜻한 우정으로 환영합니다. 이번 국제 컨퍼런스를 통하여 서로가 뜻을 나누는 친구가 될 것으로 확신합니다. 앞으로 국제 특허법원 컨퍼런스가 더욱 발전하여 세계 지식재산 전문가들의 교류와 소통의 중심이 되기를 희망합니다. 다시 한번 2022년 국제 특허법원 컨퍼런스의 성공적인 개최를 축하드리며 이번 컨퍼런스에 참가하신 여러분 모두의 건강과 행운을 기원합니다. 감사합니다.
네, 감사합니다. Today we are joined with distinguished guests Kwang-hyung Lee, President of Korea Advanced Institute of Science and Technology, has attended. He is also President of Preparatory Committee concerning turning Korea into a World IP Hub. 오늘 귀한 손님께서 행사를 축하해 주시고자 참석해 주셨습니다. 이광영 카이스트 총장님의 축사가 있겠습니다. 이광영 총장님은 현재 세계 특허허브 국가추진위원회 공동대표이시다 하십니다.
Good morning. I am Lee Kwang-hyung, President of KAIST. I extend my deep congratulations on the opening of the 8th International IP Court Conference, a venue to discuss main issues in the global IP law arena. I have been taking part since the very first conference. I didn't miss a single one. So it has a very special place in my heart. Under today's theme of court IP and new practice, we are joined by IP field judges and practitioners from around the world. And I thank Chief Judge Kim Yong-seok of the Patent Court of Korea for putting together such a meaningful event to discuss IP. IP is the source of business competitiveness and an essential asset of the national economy with great significance. I am personally deeply invested in IP. Since about 8 years ago, I have been part of the National IP Committee and Supreme Court IP Hub Court Committee, National Assembly Global IP Hub Nation Committee, and the Patent Court Judicial Administrative Advisory Committee. Through such activities, I have contributed to establishing jurisdiction consolidation of patent cases, international tribunal, punitive treble damages system, and order to produce documents, and I take great pride in that. Today, in fact, we are seeing much difficulty in activities of our hub committee due to COVID pandemic. And some are concerned that proceedings cannot be conducted well during the pandemic, and we have vowed to improve the situation. Today, from 7 countries, including the US, UK, Germany, Japan, China, Australia, and Korea, we have IP judges and leading practitioners at today's conference, and I hope this time will serve to enhance our IP-related capabilities and expertise. I hope the IIPCC will continue to serve as a venue for global networking where countries gather to share IP-related wisdom and experiences. Once again, deep congratulations goes to the opening of the 8th International IP Court Conference. Thank you.
좋은 말씀 감사합니다. The Patent Court has received several videos of congratulatory remarks from the heads of prestige IP institutions around the world, wishing us a successful event out of their busy schedule. 다음으로 세계 유수의 여러 지식단체장님으로부터 축하 영상을 시청하시겠습니다. 다들 바쁘신 일정에도 불구하고 이번 컨퍼런스의 성공적인 개최를 희망하는 마음으로 영상을 보내주셨습니다. Without further delay, we are going to watch 5 videos. First, let's listen to the remarks of Lisa Georgeson, Deputy Director General of WIPO. 먼저 와이포 사무차장님의 축사를 시청하시겠습니다.
Honorable Chief Judge Yong Sok Lim, Professor Kwang Hyung Lee, distinguished judges, dear friends. It's a great honor for me to address you at this 8th edition of the International IP Court Conference, and I would like to sincerely thank the Patent Court of Korea for the invitation. Addressing the members of the judiciary is always a humbling experience, and as the functioning of any intellectual property system is relying principally on courts and the judges that sit on the bench. After all, IP rights are nothing more than a promise from the government that in case of unauthorized use of the subject matter under protection, be it an invention, a distinctive sign, or a work of art, the right holder will be in a position to seek judicial remedies. This is not to say that the job of IP offices administering the rights is not equally important, and statistically speaking, the number of litigated cases are by nature lower than that of processed applications of granted rights. Yet, courts represent the safety valve of the system, without which IP rights would simply not work in the intended way. All the functions of the IP system, including fostering creativity and innovation, disseminating technological information, providing a competitive edge, and a means for businesses to thrive, as well as serving as a legal vessel for technology transfer. All these functions presuppose that the exclusivity conveyed by IP rights is guaranteed by the courts. Consequently, the crucial role of the judiciary comes with great responsibility. Judges need to strike the right balance between the interests of right holders and the general public. While doing so, a remarkable degree of adaptability is called for. Working at the forefront of cutting-edge technology requires utter circumspection and an understanding of the wider policy implications of deciding a case one way or another. Allow me to begin with a short account of the refocusing of priorities that WIPO is going through. As the UN Agency for Innovation and Creativity, WIPO's mission is to support all of our 193 member states to use IP as a powerful catalyst for jobs, investments, business growth, and ultimately, economic and social development. That is why we are transforming our work to go beyond the technical aspects of IP to encompass the developmental aspects of IP. In accordance with our global partners, we are building a more inclusive IP ecosystem that engages not just with IP experts and professionals, but also with women, youth, entrepreneurs, startups, SMEs, researchers, indigenous peoples, and other communities around the world. A couple of words on the innovation landscape. Today's market is marked by the globalization, economic integration, and digitalization of innovative and creative activities. Value chain and distribution networks, digital and otherwise, are permeated by cross-border movement of intangible capital, notably in the form of IP-protected technology, design, branding, and cultural works. According to the World Intellectual Property Report released by WIPO in April this year, digitalization is the new big innovation revolution. Digital innovation quadrupled in the 20 years up to 2020, when it represented 12% of all patent applications with a 13% annual growth rate. New technologies are leveraged to achieve economic development at a large scale. This is especially true in Asia, which is now the main engine of global IP growth. By 2020, Japan-based innovators held 25% of the world's ICT-related patents, followed by the Republic of Korea with 18% and China at 14%. At this point, let me also congratulate the fantastic city of Daejeon, the venue of today's event. According to the recently published Global Innovation Index for 2022, it has been ranked number 3 in the list of global science and technology clusters, which is an amazing achievement and surely the result of sound innovation and intellectual property policies in the Republic of Korea, as well as the hard work of the stellar researcher community. There is a multitude of factors that cause radical changes in the world we are living in. Some of those, such as scientific breakthroughs and emerging technologies, offer new possibilities. On the other hand, many of those are posing challenges for the entire humanity. Think of climate change or health-related crises, such as the latest COVID-19 pandemic. The good news is that new challenges bring about new solutions as a result of the inherent nature of humankind to innovate. Such new solutions, in turn, may pollinate other technologies and bring about solutions to problems that had not been able to be tackled before. Just think about it. Vaccine development for the prevention of the spread of the COVID-19 pandemic may be the cradle of a host of new medicinal products against very different ailments. Intellectual property is supposed to incentivize innovation. At the same time, global challenges spur new discussions, and the discourse around the IP system has surely changed over just the last few years. With a sharpened focus on fair access to life-saving technologies and the public funding of seminal research projects, IP rights need to showcase another aspect that is often overlooked: its potential to become a vehicle of technology transfer and a sharing of knowledge in a manner most conducive to the public good. This is a balancing act between keeping the reward mechanism functional while encouraging socially beneficial openness in many regards. Perhaps not surprisingly, courts have a seminal role in breathing life into the policy choices made by legislators in the individual countries. WIPO is an exceptionally good place to serve as a convener and a neutral forum for discussions aiming at the progressive development of the international IP system. Recognized by the international community as such, its various bodies, including the Standing Committee on the Law of Patents, facilitate the discourse around clusters of interlocking issues on both a practical and on a policy level. On top of that, as shown by your own example today, WIPO is also ready to partner up with relevant organizations in the promotion of a balanced intellectual property system around the world. For centuries, keeping sensitive information confidential has been a known feature of business life and a means of protecting intangible assets. In recent decades, trade secrets have evolved to become an important element in innovation and knowledge sharing through their legal protection. Factors such as the globalization of R&D and supply chains, the development of collaborative innovation models, and continued digitalization have moved trade secrets much closer to the center of our economies and growth strategies. The protection of trade secrets has its roots in the area of preventing unfair competition, a theme of this conference. Maturing into a form of intellectual property, trade secrets have earned their place in the ranks of important business assets. Their subject matter and legal protection may have different characteristics than those of patents, yet these two tools may complement each other well when it comes to building an IP strategy for a modern world enterprise. In the meantime, on a policy level, there needs to be a realization that a strong regime of protection for undisclosed information is essentially a judicial means against misappropriation of confidential information. This in turn entails, to a certain extent, counterintuitively, that robust trade secret protection systems may indeed facilitate smoother knowledge sharing between parties, contributing to effective technology transfer and open innovation. After organizing the second symposium on trade secrets and innovation in May of this year, WIPO will continue to offer an international forum for deepening a global conversation on trade secrets and innovation, which is expected to be a topic that will gain even more attention around the world from all business sectors. At the same time, the innovation ecosystem is coming under increasing stress. This includes the judiciary, who plays an important role in the IP ecosystem by providing predictability for market structures and alleviating commercial uncertainties. Let me share some illustrations of this. First, the rapid technological change raises questions on the boundaries of innovative activities as patentable subject matter. The World Intellectual Property Report states that computer and related innovation tripled in 35 years through 2000, when the sector represented 24% of all patents. This resulted in courts around the world engaging in reflections on fundamental questions regarding invention and computerization, and the application of legal tests to the question of patentability of computer-implemented inventions. Now, with the rapid growth of artificial intelligence, or AI, technology, courts are faced with cases in which patent protection is sought for inventions deemed to have been generated autonomously by AI, thus requiring judges, in their role of reviewing the decisions of IP offices, to examine the fundamental boundaries of inventorship in their national patent law. Second, courts face similarly difficult considerations when deciding on alleged patent infringements involving technologies that were not foreseen at the time the patent was filed. This phenomenon requires rigorous application and interpretation of the doctrine of equivalence and sufficiency of disclosure. Third, IP disputes frequently involve complex issues cutting across multiple legal domains, and the multi-territorial nature of technology exploitation increases tension with the territorial nature of intellectual property rights, as well as the principle of domestic judicial resolution. These areas of tension are particularly exposed in disputes involving standard essential patents. To a growing extent, the global market of technology products is affected by a web of territorial patent rights, covering inventions without which standard compliance cannot be achieved. The licensing framework of such patents inevitably brings about aggregated rates and cross-border issues. We are seeing a significant number of lawsuits filed in multiple jurisdictions with an overlap of rights invoked. These proceedings do not only involve patent law, but also need to balance considerations of competition law, contract law, and more for the courts to decide. Additionally, the judicial trends and practices applied by the different jurisdictions are now being scrutinized through the lens of international trade law. WIPO is currently closely monitoring the lay of the land in the SEP domain and the developments in its member states. At the same time, it is working on identifying those areas where WIPO may serve an important function as a global and neutral body with a central role at the heart of the international patent system. In these times, where innovation takes place at an accelerating speed and courts stand at the frontiers of law, judges and courts may benefit from engaging in cross-border judicial dialogue to garner ideas and insights from their judicial peers in other jurisdictions and at international meetings, such as this IP Court Conference. Such cross-pollination of judicial approaches will not only help in finding commonalities, but also in understanding differences. WIPO, as the global and neutral forum for intellectual property, is committed to facilitating such free exchange of experiences, expertise, and perspectives. WIPO looks forward to continuing its collaboration with the Patent Court of Korea and all other IP stakeholders participating at the conference in driving the development of a balanced and inclusive global IP ecosystem. Thank you for your attention, and I wish you informative and inspiring discussions over the next 2 days. Thank you.
네, 감사합니다. Next video is from the President Ichiro Nakatomi of LESI. 다음으로 국제 라이센싱 협회 나카토미 회장님의 축사를 시청하시겠습니다.
Hello, I'm Ichiro Nakatomi, current president of Licensing Executive Society International, LESI. It's my pleasure to address the judges and attendees of this year's International IP Court Conference hosted by the Patent Court of Korea. Your theme this year is called IP and New Practice. It's a particularly unique time for all of us to discuss these issues as many countries continue to recover from COVID-19 pandemic. In the past few years, we have witnessed some fundamental shift in how business operate and look at the future. This has affected how people connect, travel, and prioritize their work. It has also affected some companies' investment in technology, what partners they choose to collaborate with, and how they might value for their intellectual property. There are some topics that we have discussed at LESI and among our members throughout the world. I thought I might introduce you to organization and some of the activities we support. LESI is a global network of licensing professionals established in 1973. We are celebrating our 50th year of convening our members and the public to discuss, to create, protect, and commercialize innovation. In doing so, LSI advances the business of intellectual property to enable investment in new technologies and bring those technologies to the marketplace. Our experts can discuss the finer points of IP business and the value of IP from negotiation to dispute resolution. LESI consists of 6,500 individuals members from 33 societies in 90 countries, largely from Americas, Europe, and Asia regions. Thailand has recently joined, and Vietnam is expected to be established in the coming year. LSI is governed by 12-member board member of directors, 2 legal counsel, and executive director. My theme this year as LSI president is sustainable innovation and sustainable collaboration to support IP business goals. This means that no matter how good a discovery or technology is, it will not last without collaboration. This is core to work that all LES members globally engage in and is even more important as a result of the pandemic. We witnessed incredibly fast development of vaccines and distribution methods to address the COVID-19 pandemic. This global response could not have been accomplished without investment in the underlying innovation for years before pandemic and without parties coming together to share and utilize these innovations. IP rights have enabled and continue to enable many of these collaborations by helping parties come together and by mitigating the risk of investors and companies to invest high-risk technology development. For LSI, this also means operating their organization from the business perspectives to drive membership and engagement. Among other things, we are actively promoting collaborations for LSI and local LES societies with external organizations in addition to the internal improvements. I've listed a few of our activities this year. Several new LESI committees have been formed and this year, notably the SDG IP Index committees, ranking of companies based on Sustainable Development Goals, SDG, and Environmental, Social, and Governance Goals, ESGs, do not currently take into account the value of IP, which is an intangible asset that companies rely on. So consistent with my theme for ADSI, we are developing a tool that highlights these points and will announcing this ranking next year at our LESI 2023 annual meeting in Montreal. This year, we are also launching a new initiative, LESI Thought Leadership Program. we're hosting a series of online webinars addressing these specific topics, which then culminates in an annual conference session. The topics of 2022-23 are SEPs, standard essential patents, and automotive industry and dispute resolutions. The first session will address SEP and will occur on October 25. ADSI holds its annual conference once a year in the spring. In 2021, we had hoped to hold our meeting in Seoul, but due to COVID, we hosted a virtual meeting. This year, we are able to return in-person meeting in Venice, Italy. More than 500 people gathered. Just last week, we asked some of our organizers to gather again to provide executive summary of the event. The session allows public and LES members who are unable to join the meeting in person to nonetheless benefit from various conversations. Next year, in 2023, we are in Montreal, Canada, starting April 30th. We are trying to make it accessible to all professionals, scientific universities, industries. So you have the opportunity, please join us. Thank you for letting me introduce LSI to you, and I wish you good luck for successful conference. Thank you for your attention.
네, 감사합니다. 여러 단체에서 축사를 보내주셔서 축사가 좀 많습니다. 많은 축사를 보내주셔서 감사하게 생각하고 있는데
We've received
다음
many
축사를
congratulatory
보시겠습니다.
remarks, so
The next
I'm
video,
very grateful.
The very next video is presented by President Shoichi Okuyama of AIPPI. 다음으로 국제지식재산보호협회 오쿠야마 회장님의 축사를 시청하시겠습니다.
My name is Shoichi Okuyama, President of AIPPI
안녕하십니까. 저는
International.
쇼이치 오쿠야마
I'd like to congratulate
AIPPI
you
회장입니다.
on the
한국
opening
대전에서
2022 International
2022 국제 특허법원 회의를 개최하시게 된 것을 진심으로 축하드립니다.
I also like to thank the
그리고
organizer for
이토록
giving us this
저명하신
opportunity
발표자들과
to
귀빈
speak
여러분들
in front of
앞에서
distinguished
축사를 드릴
speakers
수 있는 기회를
and the
주셔서
audience.
주최 측에게 무척
With the
감사드립니다.
participation of judges,
영국,
scholars and practitioners
미국,
from United States,
독일,
Germany,
호주,
England,
일본, 중국,
Australia,
한국의 판사들이
China, Korea,
참석하여
and
개최되는
Japan,
이번
this is a truly
행사는
international
진정한
event.
의미의 국제적인
As we
행사입니다.
all know, the
법원은 다 아시다시피
courts are the last resort for the
지적권의
proprietors
소유자들이
to
지적권의
obtain legal
침해와
relief
또 부당
against
경쟁 행위에
IPR
대한 법적
infringement
구제를 받을
and
수 있는
unfair
최후의
competition violations.
보루입니다.
The proprietors has to rely on
지적권자들은
the
법원의 소송
transparency
절차의
of court
투명성에
proceedings
의존하고
and also
그리고 법원의
consistency of
일관성
court
있는
judgments
판결을 통해서
to protect their valuable IP assets. The harmonization of IP enforcement procedure and substantive legal standard is of paramount importance for corporations which carry out business without knowing country borders. We are sure that this conference will be successful in exchanging ideas and elucidating differences that proprietors encounter when they conduct cross-border litigation. The audience will learn issues related to damages calculation and also issues related to trademarks and unfair competition. I'm sure this conference will be very fruitful for providing the opportunities, learning opportunities for all the participants. AIPPI has 8,000 members covering more than 130 countries with a history of 125 years. The AIPPI has spearheaded a harmonization effort as a leading international organization of lawyers, patent attorneys, corporate managers, and scholars. For example, this year in San Francisco Congress that was held in September, we studied 4 questions. First, patentability of diagnostic method. Second, protection of trade secret in civil proceedings. Third, trademarks and internet and social media. And fourth, moral rights in copyright law. In the end, we had 4 resolutions as agreed by all AIPPI members. This is a year-long effort on the part of AIPPI. We ask all national and regional groups to submit national reports, and we collect something like 40 national reports. And on the basis of those national reports, we come up with draft resolutions. Draft resolutions are deliberated by different stages and before plenary sessions and made into AIPPI resolutions. AIPPI discusses these resolutions with WIPO, EPO, and EU IPO, as well as with national patent offices. Let us look into some details on these resolutions that are concluded this year. On the issue of patentability of diagnostic method, AIPPI resolved that diagnostic method should be patent eligible, and also noted that the methods and uses involving diagnostic decisions based on 1 or 2 or more biological parameters should also be patentable, with the proviso that some countries may exempt medical practitioners from patent infringement. For the protection of trade secrets during the civil proceedings, while many countries are noted to have some protection over trade secret, harmonization is far from being reached, and AIPPI called for renewed effort towards such a harmonization. In the moral right resolution, AIPPI resolved that moral rights should be available on all types of works, and outlined the recommended nature of moral rights. In the resolution of trademarks and internet and social media, the AIPPI resolved that the use of trademark on the internet or social media should be a use of a trademark. In doing so, metaverse and NFTs were excluded from discussion for now. AIPPI have these and past resolutions made available to the public, and all relevant documents are also available to the public without membership. So please visit our website and click library button at the top of the page. With the very capable renewed function of search, you can find very useful and rich resources for comparative law studies. Well, we hope that this Korean conference will be fruitful for all the participants and also help the users of IP system understand the intricacies of IP infringement litigation. Thank you very much for listening.
감사합니다. President Roberto Pistolesi of FICB also sent us his remarks. 다음으로 국제 변리사 연맹 피스톨레시 회장님의 축사를 시청하시겠습니다.
Estimated judges, first of all, I would like to thank all of you for inviting FICB, the International Federation of Intellectual Property Attorneys, to participate in this International IP Court Conference. My name is Roberto Pistolesi. I am an Italian and European trademark and patent attorney, and I have just been elected president of FICPI during the World Congress that was held in France, more precisely in Cannes, from last 25th to 29th September. This is therefore my first official appearance in this capacity, at least at the time of recording the present message. Consequently, as you may imagine, I am pretty excited and also quite sorry for not being able to attend in person. I would have been, in fact, very interested in physically attending this event, not only because I am now the president of FICPI, but also because, as a patent attorney, I am specialized in chemical and pharmaceutical patents. And in this specific capacity, I am one of the technical experts that are appointed by the IP specialized courts of Milan and Venice in Italy, where I try to assist the local judges in reaching their decisions in patent validity and infringement cases. Consequently, knowing judges' perspectives is clearly very important to me. As many of you probably already know, FICPI is the only international NGO whose membership consists entirely of IP attorneys in private practice. As a result, it is driven by a shared interest among like-minded people to promote common solutions and advocacy for private IP practitioners. Founded more than 100 years ago, the FICPI global community has more than 5,800 members drawn from 86 countries and regions across 6 continents. Therefore, since FICPI represents people from so many jurisdictions, an international IP core conference like the present one is really important for our community. As a matter of fact, harmonization is one of our goals. Harmonization not only, for instance, of patents and trademarks validity requirements, but also of core procedures and doctrine. As just explained, I am specialized in chemistry and in pharmaceutical patents. Consequently, as you may imagine, I am really very interested in the doctrine of equivalence, where harmonization is far from being reached not only from country to country, but also if we consider different courts of the same country. This is something which is creating serious problems to me and to my colleagues, since sometimes it is very, very difficult to provide our clients with good and reliable advice about what they can reasonably do in nowadays global market without violating the patent rights of their competitors. So first of all, I would like to thank you if you were able to consider this aspect, if possible, during this conference. Secondly, I have noted that the theme of this year's conference is Court IP and New Practice. In this connection, the topic that is particularly relevant to the FICPI community and which has been brought to the forefront by the recent pandemic is that of virtual hearings. Sometimes, as in fact in the case of the pandemic, virtual hearings are a necessity, and you cannot do without them. But sometimes they are not. The issue is therefore what to do in the new practice. FICPI has recently taken a position in this sense by filing an amicus brief with the enlarged Board of Appeal of the European Patent Office in case G121. The question that was referred to the enlarged board was essentially whether the conduct of oral proceedings in the form of a video conference is compatible with the right to oral proceedings if not all the parties have given their consent. FICPI position was that the conduct of oral proceedings in the form of a video conference is compatible with the right to oral proceedings as long as attendance in the presence of the members of the division or board is offered to the parties, except, of course, when extraordinary circumstances such as public health emergency or security reasons makes attendance in person impossible. And this because, according to FICPI, a party's right to an in-person oral hearing is a fundamental principle of any judicial system. Consequently, according to FICPI, once the COVID emergency is over, parties should always have the right to attend oral proceedings in person, at least in inter partes proceedings, even if oral proceedings by video conference become a standard option in the future. Therefore, I would thank you if you could consider FICP's position in your future activities. Lastly, I have noted that one of the subjects of this year's conference is distinctiveness by use of a trademark and the descriptive trademarks. In this connection, FICP last year passed several resolutions which address similar topics. For instance, in 2016, it passed a resolution concerning the limitation of use of trademarks and trade dress. In that occasion, FICP urged legislators to respect legitimate trademark and trade dress rights and to avoid imposing limitations on the use of such IP rights based upon the type of product and or service without demonstrating a compelling public interest to do so, which outweighs the rights of owners of such IP rights. And it further urged legislators, where such a compelling public interest is present, to ensure that limitations are neither disproportionate nor unreasonable. In 2018, FICP also passed a resolution urging trademark offices to accept letters of consent and consider them in assessing confusion between marks. And in the same year, it passed another resolution concerning the examination of slogan marks, in which it urged national and regional trademark offices to apply the same examination standards to slogans and other world trademarks. Lastly, during our very recent World Congress, FICP passed a very up-to-date resolution concerning non-fungible tokens, namely the so-called NFTs. In particular, FICP urged trademark offices and legislators to provide guidance on the registration of digital artwork authenticated by NFTs, particularly in respect of ownership and proof of use, and to provide guidance on the classification of NFTs and or virtual goods associated with the NFTs. And finally, to provide guidance on the comparison of virtual goods with the real-world goods during examination, opposition, and cancellation proceedings. This last and very recent resolution concludes my intervention in this important conference. I take this opportunity to let you know that FICP is now organizing its 21st Open Forum, which will be held in London from 4 to 7 October next year. The forum will likely include a session concerning court-related issues. And if this is indeed the case, we might ask some of you whether they would like to join the session as speakers. For the time being, this is all. I wish you all the best for a fruitful and satisfying conference, and I hope to meet some of you in London next year. Good work and thanks.
네. 감사합니다. 장시간 축사를 시청하셨습니다. 이제 마지막으로 국제상표협회 빙크 회장님의 축사를 시청하시겠습니다. The last video is from President Ziegler Vink of the International Trademark Association.
Good day, everyone. Thank you to the Korean Patent Court for organizing today's proceedings, and to the honorable judges from around the globe attending, and to the respected members of the Academy, intellectual property practitioners, to honorable judges from across the world, to respected colleagues and organizers with the Korean Patent Court. Thank you for inviting the International Trademark Association, INTA, to participate in this year's International Intellectual Property Court Conference and provide this message. First, let me underscore the important role of the judiciary and INTA's ongoing work around the globe. INTA works closely with judiciaries, including organizing forums and exchanges on best practices. We have a dedicated workshop for judges at our annual meeting, and ASEAN member states judiciaries have participated in these workshops for many years. Our goal is to nurture efficiency, consistency, cost effectiveness, and quality of decisions in trademark dispute. INTA is committed to cooperating with the judiciary to foster an effective IP jurisprudence and encourage interactive discussions between practitioners and the judiciary on cutting-edge IP topics. As such, INTA organizes workshops for judges, and this includes a judges workshop at our annual meeting and customized local workshops. These local workshops cover cutting-edge developments in IP case law and legislation. In doing so, they are helping the advanced judicial expertise on IP. And to date, judges' workshops have successfully been hosted in 13 countries across 4 continents. In 2023, we will see workshops in southern Brazil, India, Namibia, Nigeria, and Colombia in coordination with the Andean Community Tribunal. INTA and the judiciary is an important topic for us. Topics discussed during these local workshops are tailored to meet local interest and requirements. Past workshops have covered comparative review of general trademark prosecution principles, protection and treatment of well-known marks, non-traditional marks, administrative procedures such as oppositions, cancellations, and the appeals of these decisions to the courts, preliminary measures to protection such as injunctive relief, seizures before judgment, community law and the implementation by national courts in the Andean community, counterfeiting and the legal enforcement measures to address it, and international IP treaties and their implementation and execution. In several jurisdictions, our workshops were endorsed or co-hosted by local supreme courts and the official judicial academies or universities. Feedback received from these events is very encouraging, and in many cases we are asked to repeat our engagement regularly. A priority advocacy issue for INTA in recent years has been bad faith filings and the adoption of best practices to combat this abusive practice. Policy dialogues and engagement on bad faith filings and registrations have successfully been hosted in China, the Philippines, and Thailand. INTA is also taking a major role in the current discussion surrounding the EU IPO CP13 on bad faith filings. Another key issue right now is injunctions. There is a lack of harmonization regarding the availability and requirements for injunctions, and we would like to see this addressed in policy dialogues. Notably, INTA represented before the WIPO Advisory Committee on Enforcement in September, marking a major milestone towards raising awareness of the lack in harmonization. Harmonization of opposition procedures is another key focus area. A worldwide survey of opposition practices revealed harmonization deficiencies in all regions. We plan to raise this matter through policy dialogues. Potential target countries in the ASEAN region are Myanmar, Thailand, and possibly also Vietnam. Future projects include the review of policies and treatment of use of trademarks online, assessment of the importance and use of coexistence or consent agreements in IP prosecution and litigation, and local issues such as different legislative initiatives in China, India, and Indonesia. As I noted, we host a judges workshop at our annual meetings, and we're very excited to be bringing our annual meeting back to Asia next year. In 2023, our annual meeting Live Plus will take place in Singapore in person on May 16 to 20, and virtually from June 27 to 29. We hope that you will be able to join us. Once again, thank you for the opportunity to provide this video message. We wish you all a productive and enjoyable program today. Thank you.
감사합니다. I would like to thank all of them for giving us a heartfelt congratulatory remarks. 축사해 주신 모든 분들께 깊이 감사드립니다. It's time to wrap up the open ceremony of 2022 IBM PCC. Now we are going to prepare the stage for the session 1 and we will begin shortly. Please remain in your seats while the stage is set up. 이것으로 2022 국제 특허법원 컨퍼런스 개회식을 마치겠습니다. 연단을 정리하고 바로 1세션을 시작하겠습니다. 연단을 정리하는 동안 자리를 지켜주시면 감사하겠습니다. 제1세션 연사들께서는 미리 연단에 나와서 준비해 주시기 바랍니다. 연단 세팅을 먼저 하겠습니다. Before the commencement, let me briefly explain about the reference book. 세션 시작하기 앞서 오늘 받으신 자료집에 대한 설명을 잠시 드리겠습니다. There are 3 books which is prepared with great care by moderator, panelists, and members of the organizing committee, published both in Korean and English. You may find the first session and mock arbitration in book 1, while the second and third sessions as well as the material prepared by Patent Korea's Practice Study Group are brought together in Book 2. The Book 3 contains Session 4 as well as material from the Patent Korea course Practice Study Group. The reference books are edited along the sequence of the conference and presentation. Each session, except for the mock arbitration, will be proceed with the question and answer. The contents of discussion generally will not exceed the scope of Q&A. Thus, during the discussion of the session, it would be very helpful if you would refer to these books to fully understand the discussion. 각 세션의 사회자와 발표자 및 저희 법원 준비위원이 정성스레 준비한 이 자료집은 3권으로 되어 있습니다. 1세션과 모의중재가 1권, 2, 3세션 및 특허법원 실무연구의 자료가 2권, 제4세션 및 실무연구의 자료가 3권입니다. 또 모의중재 세션을 제외한 각 세션은 질문과 답변 순서로 이루어져 있습니다. 논의될 내용은 대체로 Q&A의 내용을 벗어나지 않을 것이므로 세션에서 논의가 진행되는 동안 자료집의 Q&A 부분을 참고해 주시면 논의 내용을 깊이 이해하시는 데 큰 도움이 되겠습니다. 지금부터 2022 국제특허법원 컨퍼런스 1세션을 바로 시작하겠습니다. 모두 착석해 주시면 감사하겠습니다. Now we shall begin the first session. In this session, we will take time to hear the recent IP trend in global litigations. 네, 이제 1세션을 시작하겠습니다. 네, 자리에 착석해 주시면 감사하겠습니다. 네, 자리에 앉아주시면 감사하겠습니다. Now we shall begin the first session. The moderator of the session 1 is Honorable Chief Presiding Judge 주형 Moon of the Patent Court. 1세션 진행은 문주형 특허법원 수석판사님께서 맡아주시겠습니다. Please join me in welcoming Ms. Moon. 큰 박수 부탁드리겠습니다.
반갑습니다.
Good morning,
안녕하십니까?
everyone.
오늘 제1 세션 사회를
I
맡게
will be
된
moderating the
문주형입니다.
first session. I am
제1
Ju-young Moon.
세션은
In the
해외
first
주요
session,
국가와
we will be
우리나라의
examining the
IP
recent
소송의
trends in
최근
IP litigation,
동향을 알아보는
both at home
시간으로
and abroad.
마련했습니다. 제2세션부터
Starting from
시작되는
session
특정
2, we
주제에
will be
관한
discussing
본격적인
very
토론에
specific
앞서
topics.
주요
But before
국가의
doing that,
지식재산권
I believe
관련
it will be quite
새로운
meaningful
제도와
for us to
판례의
look at the
흐름을
new
살펴볼
systems
수
and
있는
trends in court
시간이
precedents
될 것이라
related to the IP
생각합니다.
field that has emerged in recent
현장에
years.
직접 참석해 주신
Aside from
분들
those of us
외에도
here at the
지금
venue physically,
온라인으로
there are also many people
여러분들께서
joining the
함께하고
conference
계십니다.
via online.
모든 분들에게 이번
So,
세션이
I hope
국제적
this session
IP
will
소송
prove to
동향을
be fruitful
전해드리는
for
귀한
all of
시간이
us in
되기를
expanding our
기대합니다.
understanding of the international trends in IP litigation.
발표에 앞서 제1
So
세션의
before starting with the
패널들을 소개해
presentations, let me
드리겠습니다.
introduce the panels for the first session.
먼저 독일
First,
미넨
from
제1지방법원
Germany, we have
안나
with us
레나 클라인
Judge Anna Lena
판사님이십니다.
Klein from the
클라인
Munich District
판사님은
Court Number 1.
2018년 이후
Judge Klein has served in
지식재산권법
various
분야에서
positions in the IP
다양한
field
직위를
since
맡고 계시고
2018 and
제4 세션 및
also
모의
will be
중재에도
taking
참여해
part in
주실
the fourth session as
예정입니다.
well as the Moot trial.
다음으로 호주
Next,
연방법원
from
존
Sydney,
니콜라스
we have with us Judge
판사님이십니다.
Nicholas from the Australian
판사님께서는
Federal Court.
2009년부터
Judge
호주
Nicholas
연방법원
was
판사로
appointed
임명되어
as
분리된 유전 물질의 특허
Federal Court Judge in
적격성 등
Australia and has
다양한
passed judgments
지식재산
on
관련
various IP-related
판결을
cases,
선고하셨습니다.
including the patentability of
이어
separated gene
전 미국
materials.
연방
And we
순회
also have with
항소법원
us in this session Judge Caroline O'Malley, former judge of the U.S. Federal Circuit Court. Judge O'Malley has served for more than 27 years as a federal court judge in the United States and has been leading the development of the IP litigation field. And finally, we have with us Judge Park Eun-hee from the Korean Patent Court.
이제 제1 세션으로 본격적으로
We will
들어가도록
now
하겠습니다.
start the first session.
제1 세션에서는 크게 네 가지 주제를
In
다룰
the first session,
예정입니다.
we will be dealing
첫
with
번째 주제는
four
각국
topics.
지식재산권법
The first
분야
topic is the recently
최근
adopted
도입된
systems
제도
in your
소개입니다.
country's IP field.
두 번째
The second
주제는
topic
각국의
is
최근
interesting
지식재산권법
court
분야
precedents that
흥미로운
came out
판례
recently in
소개입니다.
the IP litigations.
세 번째 주제는
Third
현재
topic is
진행
the key
중이거나
issues that are
향후
underway
쟁점화
at
될
present
것으로
or
보이는
issues that may
지식재산권법 분야의
potentially
주요
become important
쟁점입니다.
going forward.
독일 개별 질문으로
And as a separate question to
유럽
Germany,
통합
we would like to
특허법원
ask about the
협정에
issues
관련된 여러
surrounding
쟁점에 관한 소개도
the
부탁드렸습니다.
United Patent
네
Court
번째
in Europe.
주제는
The
팬데믹 이후
fourth
IP 소송 및
topic is
재판 절차
changes
등에
related to the IP proceeding
생긴
and
변화
trial
소개입니다.
procedures that took place after the pandemic.
위각 주제에 대한 패널들의 자세한 답변은
The detailed
자료집에
answers
실려
of the panels
있으니
for each of these
그것으로
topics is presented
발언하기로
in the
하고
conference booklet. And so today,
오늘
the
패널들께서는
panels
각자가
can
중요하다고
talk about
생각하시는
those
점에
issues
관하여
for
13분 정도에 걸쳐
around
소개하도록
13
하겠습니다.
minutes.
먼저 첫 패널을 모셔보겠습니다.
First, I would like to
미국의
invite
캐틀린 오말리 전
our
연방
first presenter,
순회법원 순회
Judge
항소법원
O'Malley from the
판사님께
United States, to
발표를
make her
부탁드리겠습니다.
presentations.
오말리 전
Judge
판사님 연결해
O'Malley,
보겠습니다.
the floor is
오말리
yours.
전 판사님.
Thank you. I'd like to say good morning to you. It's evening for me, but I know it's morning for you. So good morning. I wish I were there in person. I still have fond memories of the last time I visited the Korean Patent Court with members of the Federal Circuit, and I look forward to doing so again at some point in the future. I'm happy to join my fellow panelists for discussion of these thoughtful questions. I'm looking forward to hearing our respective approaches to them. I refer you to my written submission for details and case citations, but in the limited time allotted to me, I'd like to approach these questions with the big picture in mind, the health of the US patent ecosystem. The US patent system dates back to the inception of our country. The grant of an exclusive right to practice one's inventions, writings, and creations appears in our Constitution. Our founding fathers believed that the promise of enforceable patent rights would encourage innovation, and that innovation would spur growth that would in turn help secure our economic and political independence. The concept was, and in my view remains, a sound one. Determining how to put the concept into practice and adapt those practices to changing technologies and increasingly global economy has not always been easy. Congress revised our patent system several times between 1790 and today as we attempted to adapt to technological changes and the concerns of stakeholders. But the most dramatic adjustment, even more dramatic than the creation of the Federal Circuit in my view, was the passage of the America Invents Act in 2011 and the creation of an inter partes review system. Before that, with few exceptions, such as reexamination proceedings, the Patent Office granted patents, and it was the province of the courts to enforce and define the rights granted in those patents, and to assess patent validity with the benefit of a more detailed record of the invention and the state of the art than available to examiners. Because our patent system consciously allowed patent owners not to practice their patents and to instead license them, sell them, or merely possess them, those wanting to make or sell products in a given space began to see patents and non-practicing patent owners as roadblocks to innovation. And because our Constitution also granted patent owners a right to a jury trial in infringement proceedings, and the invalidity challenges asserted as defense to those proceedings, litigation itself was seen as hampering innovation. That was the genesis of the IPR proceedings, designed to provide a fast, less expensive alternative for challenging patents by allowing patent challenges to proceed before administrative judges rather than district courts. While IPRs are controversial, a topic that needs to be saved for another day, No one can debate that the development and implementation of the IPR process has been impactful. Statistics show that the vast majority of the requests to institute IPRs come from only a handful of large tech companies, that the vast majorities of those requests are granted, and that a substantial majority of the claims challenged in IPRs are invalidated. In other words, many patents, especially those granted to smaller independent inventors, indeed most awarded to those inventors, are successfully challenged even after businesses have been built on the promise of those patents. The fact that there is no standing requirement for requesting IPRs, that the threshold for invalidating claims is by mere preponderance of the evidence, and that there is no presumption of validity afforded to issue patents and IPRs make patent challenges at the PTO much easier to sustain than those in district court. While legislative proposals have been floated to try to change the IPR process, it is not likely any of those will succeed. So patents will continue to fall in this system. Moving to the second and third questions, those regarding new cases and likely contested areas of law in the US. I'm going to address them together because it is the most recent changes in the law that have spurred the most debate. I'm going to mention two topics: patentable subject matter and invalidation of patents under 35 USC section 112 on enablement and written description grounds. Both developments in the law have resulted in the invalidation of broad categories of patents previously thought patentable. As for eligibility, the Bilski v. Kapos and Alice v. CLS Bank cases have rendered most computer-implemented business methods unpatentable, providing a bleak outlook for the protectability of AI-related developments in the future. Indeed, the abstract idea concept discussed in those cases has been used to invalidate many patents that involve computer-implemented improvements to technology that extend well beyond the business method systems. The Mayo and Myriad cases, for their part, render virtually all diagnostic methods and all efforts at gene editing likely unpatentable. Despite substantial confusion and controversy surrounding the tests laid out in these Supreme Court decisions and a sustained call for greater clarity, neither the Supreme Court nor our Congress have yet to respond. The changes in the 112 space are more recent, but no less concerning, at least to me, because they make it easier to invalidate patents on important developments, especially those relating to biopharma advances. As to enablement, many argue that the Federal Circuit requires more from patent specifications than the statute, especially in unpredictable sciences. Indeed, just yesterday, the Supreme Court granted certiorari in Amgen versus Sanofi to consider whether a patent specification must teach a skilled artisan precisely how to practice the full scope of an invention without undue experimentation, rather than simply allow skilled artisans to make and use the invention as the statute says. Those concerned with the Federal Circuit's use of written description requirement to invalidate claims have not had as much success in convincing the Supreme Court to step in. The Supreme Court denied cert in the Biogen and Novartis cases mentioned in my written materials in recent weeks, and just today denied cert in the Juno case. Many contend that this 112 trend at the Federal Circuit, unchecked by the Supreme Court, will mark the death of genus claims in the biopharmaceutical space and make it increasingly difficult to prosecute or maintain patents on new biopharma advances. All of these developments, in my view, bode poorly for the future of the patent system in the US and its ability to spur the creative innovation the founders hoped to encourage. It seems to me that we are headed in the wrong direction in this country, and I'm happy to hear, even from the presentations that we heard already this morning, that several other entities are proposing that we head in a different direction. While reforms were admittedly needed in the US, I fear that we have gone too far. I feel better about the question posed in question 4, however, and that is, how have we adapted to the pandemic? In the US, I believe the courts have adapted very well, while recognizing the importance of open courts and access to the courts. The Federal Circuit immediately responded to the pandemic by adopting a system for conducting patent cases virtually through live streaming of audio streaming. We had to allow for additional changes in the court system that did not normally allow cameras in the courtroom, though, to allot for to change those in order so that we could conduct trials virtually. For bench trials and for civil trials, it was a lot easier because we were able to quickly adapt to the system and allow for bench trials to be done virtually, even with witnesses from across the world. And we eventually allotted for civil trials fully to be done virtually, even with juries. The criminal trial process is more difficult because of a defendant's right to appear, and that's a question that needs to be addressed with consent. But I believe our court system responded very quickly and very aggressively to the concerns that the pandemic presented. And I believe that a lot of those practices will remain in effect going forward, especially allowing for live streaming of hearings at the appellate stage throughout the country, allowing the public to participate in proceedings that they weren't otherwise given access to. So I'm going to turn now to the next of our colleagues to allow them to address their issues.
네, 오말리 전 판사님 감사합니다.
Thank you, Judge O'Malley. Thank you very much.
판사님께서는
Judge O'Malley
미국에서
explained
2012년
how in the
9월
United States
도입된
in September
당사자의
2012, the IPR patent
제도에 관해서
invalidation
상세하게
trial
소개를
was
해주셨고요.
introduced, and
특히 의학
also about the
특허발명의
recent
특허성에
decisions
관련된
related
최근의 판결 경향에
to the
대한
medical
말씀도
drug
해주셨습니다.
patents
아울러
related decisions.
화상 배심 재판에 관한
And
소개도
also there
해주셨습니다.
was an introduction
대단히
about the
감사합니다.
virtual jury trial
다음으로 민헨
that was introduced to the United
제1지방법원
States.
안나 레나 클라인
Next, we would
판사님을
like to
연결해 보겠습니다.
invite
판사님,
Judge Klein from
네,
Munich.
판사님, 제 소리 들리나요?
Judge Klein, can you hear me?
판사님,
I can hear
반갑습니다.
you fine. Thank you very much. Can you hear me?
네네, 잘 들립니다.
Yes, we can hear you
네,
very well.
감사합니다.
Thank you
판사님,
so much.
네.
Good morning to Korea. It's indeed a very early morning today here in Munich right now. It's about 3 o'clock in the morning, so quite early. Thank you very much for organizing this really fine conference. Thank you for inviting me. And I'm really happy to participate in this very fine conference, at least if not in person, via my computer. So thank you very much for having me. As to newly adopted systems in Germany, actually our Patent Act, our German Patent Act, was amended only last year. Some provisions came into force directly in 21, and some provisions only entered into force this year. Actually, I think many of those provisions that have been amended will have a great impact on the infringement cases that we are dealing with. Most important for infringement cases is probably that courts are now allowed to refrain from ordering an injunction based on disproportionality aspects. So we see a lot of disproportionality defenses now in our infringement cases, and I will go back to that tomorrow in greater detail because it really has a lot of impact on our infringement cases. So I will deal with that in greater detail tomorrow in session 4. Secondly, the amendment tries to heighten the synchronization between validity cases and also infringement cases. You might know that in Germany, we have a bifurcation system. So my court, we only deal with infringement cases, while the validity issues are decided at the patent court. And we only decide in our infringement cases if we need to state our infringement case based on validity issues raised at my court and raised and to be decided at the patent court, so later on. Sometimes the infringement cases are decided much sooner than the validity cases. So we have a time gap, and we call this usually an injunction gap because we usually order injunctions in infringement cases. So to address this issue of injunction gap, the legislator decided that the patent court shall give out a communication after 6 months after serving of the invalidity action. So the infringement court shall have some kind of basis to decide on, some support from the patent court to decide when we decide if we're staying in the case or not. So this should help us. We do not see the effects as of yet because those provisions only entered into force this year. So it's really newly adopted. But I guess the impact might be quite high, actually. And thirdly, also very important, the issue of the protection of trade secret has been introduced into the Patents Act. And this, we do get a lot of requests for protection of trade secrets. And this is very important for both sides if they feel that they have to decide between either disclosing trade secrets or not being able to defend themselves. So in these cases where parties have to disclose trade secrets to defend themselves, this is a very, very important tool. And now we have a system how to address trade secrets in court and how to deal with those. This is very important, actually. It is especially important in friend cases, not only, but very much important in friend cases. And I will get to my next subject, precedents in IP cases. So friend has been a major issue in German litigation, and it remains to do so. We have a lot of cases dealing with friend, and it's a very important subject for us. Obviously, I cannot go into all the details of friend right now, but I will give you some aspects which I find are very interesting and hotly debated right now in Germany. So we, of course, as our legal background, we have the decision of the CJEU in Huawei versus ZTE, which he took in 2015. And in Germany, we also have 2 decisions from the Federal Court of Justice, Friend Defense 1 and 2. Those are the legal background that we all deal with in Germany. The Federal Court of Justice, in the wake of the CJEU decision, really stressed the importance of the infringer to be willing to take a license. He must be a willing licensee. And this is what the courts in Germany focus on right now when deciding friend cases. We had several decisions taken by different infringement courts, and you may go back to my written statements to see some of those. And for instance, the Higher Regional Court of Düsseldorf and the Higher Regional Court of Karlsruhe both stresses with the Federal Court of Justice the absolute importance of the infringer to be willing to take a license. Of course, we don't have a definition of this willingness. This would make our life much easier. We have to decide in each and every case anew, based on the specific circumstances of the case, if the infringer was actually willing to take a license. We can only look at case law to get some inkling of what this willingness to take a license might contain. And so I'd like to mention some of those aspects, like I said. It's very important that these declarations to take a license, a willingness to take a license, may not be just a lip service. The infringer must really act upon this declaration and must fill this declaration with life. So if we see further action or acts that would not relate to his declared willingness to take a license, the courts may deem the infringer unwilling after all, even though he declared some willingness to take a license. And this, for instance, has been stated by the Higher Regional Court of Düsseldorf, also Higher Regional Court of Karlsruhe. The Higher Regional Court of Karlsruhe, for instance, also underlined that it's very important to look at what reasonable parties would do. And what they would do is, if, for instance, the infringer gets an offer, then they would try to get a license deal done. And to get this done, they would put all the change requests they have for a certain offer onto the table at once. So what we sometimes see in litigation is that the infringer only mentions some complaints against an offer before going to court, and then during court proceedings we see several issues, several complaints being brought up peu à peu. And this is not what reasonable parties would do. They would get everything on the table at once to really get a settlement done. So the Higher Regional Court of Karlsruhe, for instance, decided that if the infringer gets an offer and then discusses several clauses with the patent holder, and then after only 2 years, or 2 years of negotiations, obviously, the infringer would like to request a totally new calculation method for a license rate, this might be deemed unwilling, deemed the unwillingness of the licensee, because usually if you really want to address the groundbreaking calculation method for license rate, you would do so in the very first beginning, for instance. Also, my court, the Regional Court of Munich 1, had several cases relating to France to decide this year, and we have several more that are coming this year, next year. And for instance, we also stressed the importance of the of getting everything on the table at once. And we, for instance, decided that if there's a counteroffer, and the counteroffer is made only 5 months after the initial offer, although the way to actually calculate the license rate is very easy, this 5-month time gap might be too high. So again, the licensee, the infringer, might be deemed an unwilling licensee. Of course, obviously, friend litigation is very complex, and those cases are very complicated. So I could only, in the limited time here, delve into some very specifics. But I guess it's a very important aspect, this willingness to take a license. It will be very interesting to see how the Unified Patent Court actually addresses friend. And with that, I come to my third topic, new systems that will be adopted. The Unified Patent Court, I guess that you are basically familiar with the fact that we will have a new court system in Europe next year, beginning as of April 23. The Unified Patent Court will be a supranational court, and it will have certain chambers in all over Europe, in up to 17 member states right now. The UPC will have jurisdiction to decide special cases, for instance, infringement cases, declaration of non-infringement cases, also validity issues. They will decide on patents with unitary effect. This is a new system of patents. I will get back to that in a second. But they will also decide on European patents if those European patents are not opted out of the UPC system. This opting out system is only available for a limited amount of time. The UPC will be bound by different sources of law, and one of the major sources of law is the Unified Patent Court Agreement, the UPCA. The UPCA addresses the organization of the court, the establishment of the court, obviously, but it also contains provisions relating to substantive law. And I will get also back on that. So we will have a whole new court system with whole new legal provisions that have never been interpreted, and they will start to be interpreted, next year, as of April 23, when the UPC will finally start working, like I said. So how will the UPC and the UPCA change the patent system and the patent litigation system? First, applications for patents. Applications for patents will still be filed with the EPO. The EPO will examine those applications, and they will also decide on the grant of a patent, or they will decide if the patent is not to be granted. Then, come April 23, the patent holder can decide if they want to have a unitary effect for those European patents that have been granted. newly granted in 23. So this would mean a patent with a unitary effect would mean that the patent would be valid in all the 17 member states of the UPCA, and would also mean that the UPC would have jurisdiction automatically, no opt-out system. But the patent holder can also decide that they want to settle and just have a normal European patent, where they can decide in which countries they want to validate the patent. And then they need to decide again if they want to opt out of the UPC system or stay within the UPC system. So I guess many patent holders right now are thinking about or have been thinking about this opting out of the UPC system. It's a very important step for patent holders to take. Concerning litigation, the most important aspect will be that a decision taken by the UPC, for instance, relating to infringement, will be valid and enforceable in all the member states. What we see right now is that we have, in international cases, a lot of parallel proceedings. So we have proceedings in Germany, in England, and in the Netherlands, maybe in Italy and France. This will be made more efficient because you just have one infringement case valid for all those member states. Same goes for validity issues. Those will be decided by the UPC on a one-time basis. Concerning the German system, like I said, we have a bifurcation system, and in the UPC system, basically the courts will be able to decide both on infringement and validity issues if they decide to do so. They have the option of giving the validity issues to another entity of the court, but they may also decide to get a technical judge as support and then decide the technical issues as well, the validity issues. And I guess in many cases, actually, the courts will decide that they will deal with both the infringement and the validity issues at once. So the bifurcation system will not be abolished at the UPC, but at least diminished. A very important aspect, I think. Now, major issues at the UPC. Of course, there will be a lot of questions arising at the UPC because, like I said, we have a totally new system, a totally new law that will be in force and has never been decided on. So a lot of issues will be raised. One very important aspect that has been debated hotly over the last year or two in Germany is the question of injunction again. And some former speakers also said injunction is a very important aspect right now. So I guess the question will be if injunctions are ordered automatically, more or less automatically by the UPC, or if injunctions will be dealt with on a discretionary basis by the court. I can only give you the sum up here, but in my opinion, this is my personal opinion, I cannot bind the UPC in any way. I would think that the UPC might have some discretion, but they will actually take this discretion as well. Automatically, they would order an injunction and only use this discretion in really exceptional cases. For instance, disproportionality issues. Like I said, we get back to that tomorrow. Very interesting discussion. So the patent court, the Unified Patent Court, took a long time to come, actually a whole decade since the UPCA was first signed by some member states. But the list of judges who will be present at the UPC, who will be UPC judges, is quite impressive. Those are very highly regarded, exceptional judges. So I guess once the UPC is actually working, it will be a very, very fine court. With that, briefly onto my last subject, adjustments after the pandemic. Actually, it's totally normal for my court right now to have digital hearings, hybrid hearings, at least every other week, usually every week. Parties adapted really well to our new systems of having video calls, video conferences, and it's very convenient, I guess, from parties from overseas, from Asia, from the US, to just dial in, have an interpreter dialed into the video call as well, so they don't have to travel to Germany and don't have to spend the time and the money. They still get all the information that they need to get from our courts. So it's very good. We actually had all the provisions to do digital hearings in place before the pandemic, but before nobody used it because it was deemed to be very uncomfortable for the judges. So it was very seldomly used, those provisions. But with the pandemic, obviously, we had to make use of those provisions, and it worked out really, really well, I say. I'm a mediator as well, and also in mediations, I've had successful digital mediation meetings with a settlement in the end. Nobody would have thought it possible before the pandemic that you could do a mediation via computer, but it's actually possible. So I think, like Judge O'Malley just said, I think this will stay with us, and this is at least something good that came of the pandemic. With that, I leave the floor to the next speaker. Thank you again very much for having me. I'm very grateful to be part of this very fine conference. Thank you so much.
네, 클라인 판사님 대단히 감사합니다.
Judge Klein, thank you so much for your presentation. She has covered the Second Amendment to the Patent Act in 2021 and the FRAND agreement, CJEU ruling, and the cases of the Federal Court of Germany, and the points about UPC that will be launched next year, and also how online proceedings are being used for a broad scope, including the arbitration proceedings. And next we have Justice John Nicholas. The floor is yours.
Thank you, Judge Mon. Can you hear and see me? Thank you.
We can hear you very well.
Thank you very much. Look, it's a great pleasure to be participating in this conference, and before I start, may I wish you a very successful and enjoyable conference. I'm sure it will be that. So let me begin, and due to limitations of time and due to the fact that I think really there have been no significant legislative changes in Australia in the IP field over the last couple of years, I'll move straight to questions 2 and 3, or topics 2 and 3, which I will deal with together. And what I wanted to do was talk about 2 or 3 significant cases in Australia that have been decided in the last 12 months, most of which are concerned with the issue of patentability. And in the case of the first matter I wanted to discuss, the question of whether an artificial intelligence can be an inventor. So earlier this year, the full court of the Federal Court of Australia delivered a judgment in a case called Thaler. The same individual involved in that case was involved in similar proceedings heard in the United Kingdom. And the court in Australia held that under the Patents Act, an inventor must be a natural person. The question in the appeal was whether an artificial intelligence machine could be considered an inventor. The judge whose decision was the subject of appeal was a very experienced judge with a very deep and long-standing understanding of science and technology. And he held that an inventor need not be a natural person. Now that decision came as a surprise to many practitioners here in Australia. His Honour analysed in detail how artificial intelligence works, or sometimes works, and in particular how it had been utilised in pharmaceutical research. And he concluded that no, and I quote, no narrow view should be taken as to the concept of inventor. And to do so would inhibit innovation, not just in the field of computer science, but all other scientific fields which may benefit from the output of an artificial intelligence system. Now, the way the question arose in that case was itself interesting. The relevant regulations required that the patent applicant nominate the inventor in the patent application. And the Commissioner of Patents was of the view that the relevant regulation could not be complied with because it was legally impossible for an artificial intelligence machine to be an inventor. Accordingly, she concluded that the requirements of the regulation had not been met and the patent application must for that reason be rejected. Now, in the full court, and I was one of the 5 members of the full court, there's considerable attention given to the terms of the relevant legislation and the regulation. But it's not my intention here to spend any time on that matter. What's important at a high level is that the court considered that the identification of the inventor was of central importance to the operation of the Patents Act, as it is closely related to concepts material to the validity of patents, and patents, including the right of an inventor to apply for a patent and the right of an inventor to be granted a patent in his or her name. The court noted that the development of patent law had not until now been confronted with the question of whether or not an inventor may be other than a natural person. But it did refer to previous authorities in Australia that proceeded on the assumption that only a natural person could be an inventor, including statements in decisions of our High Court referring to the need for an invention to have been brought about by some human action, giving rise to an artificially created state of affairs. And some of you will be familiar with one of those cases, the most important of which was the NRDC case in the High Court. The full court hearing this appeal also noted that there are important matters that may need to be considered in the context of artificial intelligence and inventions, which are not presently addressed by the Patents Act. They include, 1, whether as a matter of policy, an inventor should include an artificial intelligence. 2, whether a patent should be granted for an invention created by an to whom a patent should be granted for an invention created by an artificial intelligence. And 3, whether the inventive step requirement should be differently dealt with for an invention created by an artificial intelligence compared to a natural person. Now, as to that second matter, who's entitled to the grant of the patent, the available options could include the owner of the machine upon which the artificial intelligence software runs, the developer of the artificial intelligence software, the owner of the intellectual property in the artificial intelligence software, the person who inputs the data used by the artificial intelligence to create the invention, and there are still other possibilities or permutations of those possibilities available. So the primary judge's decision was overturned, and the full court concluded that an artificial intelligence, under the legislation that presently stands in Australia, cannot be an inventor, and therefore a patent can't be granted in respect of an invention made by an artificial intelligence. Another issue that is highly topical in Australia concerns what we often refer to as computer implemented inventions, and I know Judge O'Malley touched on this briefly in her remarks. To understand the present state of the debate in Australia concerning the patentability of computer implemented inventions, it's necessary to provide some background to the requirement under Australian law that there be a manner of manufacture. Our Act relevantly provides that for an invention to be patentable, the invention must be for a manner of manufacture. And those of you who are familiar with the older law in the United Kingdom would be well and truly familiar with that concept. There are many settled categories of invention that are not patentable because they do not constitute a manner of manufacture, as that concept has been developed in the case law. Claims to mere abstract ideas or information are not patentable. This would include claims to schemes or plans for the indexing, coding, or presentation of information, or schemes concerned with time management, production sequencing, and traffic management. Similarly, a scheme for arranging assets so as to protect them from creditors, an interesting one indeed, has been held in Australia not to be patentable on the basis that it did not give rise to the necessary artificial state of affairs or artificial effect that the authorities require of an invention if it is to satisfy the manner of manufacture requirement. Now, things have become more complicated, as you're all aware, as more and more patent applicants have sought to protect business schemes or business methods that are computer implemented. We have had a number of cases in Australia concerned with investment schemes, for example. One of those cases concerned a scheme for compiling a weighted index of publicly listed securities. If what was described in the patent specification was no more than a mere description of how to create the index, then there would be no question that the scheme would not be patentable. However, the issue was whether a requirement in the claims that the scheme be computer implemented made a difference to the result. It was held that the fact that this investment scheme was computer implemented did not render it patentable, as this was insufficient to meet the requirement that the invention produce a relevant artificial effect. Now that's some background to a recent decision of my own earlier this year in a case involving the fitness business known as F45 training or F45. Some of you may be familiar with its operations. The claims of the patents in issue in that case were directed to a computer-implemented method for configuring and operating a number of fitness studios. The essential idea was that each studio would have a series of numbered workstations arranged on the studio floor at which different exercises would be performed. Customers of the studio would perform an exercise at one station before moving to another station at which they would perform a different exercise, and so on. They were provided with instructions as to what exercise to perform and for how long. For example, how many repetitions of a certain exercise to perform, when and for how long to rest, and when to move to the next station. The invention was described as being computer implemented, and the specification of the claims described in some detail a network of computers, servers, and associated databases configured so as to enable the instructions to be transmitted from a central controller located in a centralized control room to the various fitness studios, possibly in quite remote locations, and to the exercise stations at which a monitor displayed relevant instructions and played relevant audio in those studios. Now, one of the arguments that F45 raised in support of its patents was that the patent was not to a mere scheme because the implementation of the invention in accordance with the requirements of the claim contemplated not just the use of computer technology, which I think it was accepted was fairly generic or conventional, but also the physical configuration of the various exercise stations in accordance with the scheme. However, as I said in my judgment in that case, I quote, the mere fact that the invention contemplates that exercise stations be physically configured with fitness equipment is not in itself sufficient to result in the required artificially created state of affairs, any more than would a scheme for the layout or configuration of a sports field or a children's playground, which is changed periodically to take account of the systems. It's the kind of scheme that has historically never been regarded as patentable subject matter. The scheme is not made patentable merely because it is implemented using generic computer technology. A more difficult problem that has now arisen in Australia concerns gaming technology. In Aristocrat and the Commissioner of Patents, the full court of the Federal Court was dealing with an appeal in a case allowing the grant of a patent over the objection of the Commissioner of Patents to an electronic gaming machine, or what's sometimes called a poker machine. The majority of the full court held that the substance of the invention was a computer program embodying a scheme or a set of rules for the playing of a game, which was not patentable, and which was not and was not made patentable by the fact that it was implemented using computer technology. It is apparent from the majority's reasons that they considered that the method of implementation could only confer patentability if it involved an advance in computer technology. Now, that aspect of the majority's decision caused some disquiet amongst the profession. The problem is that it may be asking too much for the patentee, or at the application stage, the patent applicant, to show that the invention involves an improvement in computer technology. There may be some advance in the field of technology to which the invention is primarily directed. In that case, the field of gaming technology, even though a computer scientist may not agree that the relevant improvement amounts to an advance in computer technology. An example given in my minority judgment was of a computer implemented scheme or idea for the running of a refrigerator in a more energy efficient way. For example, involving a new and different algorithm. It may be patentable, even though the relevant technological advance resides in the scheme or idea rather than the working of the computer with which the scheme or idea is implemented. If the result of the contribution of the refrigeration engineer who wrote the algorithm and the computer engineer who implemented using everyday computer technology is a more energy efficient refrigeration system, then the invention may well be patentable, even though the technological advance resides in the field of refrigeration technology rather than computer technology. Similarly, in the case of gaming machines, patentable subject matter may be found to exist in the way in which the gaming machine functions, even though a computer scientist may not consider that there has been any advance in the field of computer technology. In my note to the organisers of this conference, I indicated that by today, the appeal from the full court of the Federal Court of Australia in that case, the aristocrat case, would have been heard and determined by the High Court of Australia. And I expected its decision would settle the question of whether it was necessary in the case of computer implemented schemes or games to establish that the relevant invention involved an advance in computer technology. That appeal was heard by a full bench of our High Court of Australia, comprising 7 judges. I'm sorry, it was to be heard by 7 judges. As it happened, one of the judges was indisposed, so the appeal proceeded only with 6 judges sitting. The result in the High Court was that 3 judges held that the invention was not patentable, and 3 judges held that it was patentable. So it was a split decision. A division of opinion of that kind, which automatically results in the affirmation of the judgment under appeal, has only happened once or twice in the court's history. But the result is the High Court's judgment on the issues has not settled a number of important questions surrounding the patentability of these kinds of inventions. However, it does appear from what both the majority and the minority judgments, I should say, the 2 sets of reasons in the High Court, that the High Court's unlikely to adopt the majority test, the majority in the full court test requiring that there be some advance in computer technology. They're the cases I wanted to briefly talk about. In relation to the impact of the pandemic and the use of technology, I can be brief. I've said something about this, which is reported in the printed materials. We've found that the experience has been very favourable because it has really helped develop and enhance our ability to run trials and online, which we're now doing, including receiving evidence in chief and evidence in cross-examination and evidence in concurrent sessions, usually given by experts. And it's been incredibly effective and well received by the profession. And it's also led to a great reduction in costs in many cases, because once upon a time there was a lot of travel engaged in by people, and you can imagine where we are located in Australia, even internally, people are required to fly from one city to another and stay overnight very often, and they may end up spending only a very brief time in court. So that has been a great development from a range of perspectives, and the court and the profession have been very pleased with the outcome thus far. So thank you very much, Judge Munn.
존 니콜라스 판사님 대단히 감사합니다. 니콜라스 판사님께서는 AI가 특허 발명의 발명자가 될 수 있는지, 컴퓨터 구현 발명의 특허 적격성 등에 관하여 좋은 판결 소개해 주셨습니다. 마지막으로 한국의 박은희
And also the computer implemented invention case precedents have been introduced. Next, Judge Park-Eun-hee from Korea.
먼저 대한민국의 지식재산권 관련 분야에 새로 도입된 제도를 설명드리겠습니다.
First, I would like to explain about the newly adopted system in the field of IP rights in Korea. Provisions that punish a crime of infringement of a patent design or exclusive license thereof used to prescribe that such offense shall be subject to a complaint, but were revised such that a crime should not be prosecuted against objection. And also, to assist the Intellectual Property Trial and Appeal Board in better utilizing expert knowledge, the Patent Act allowed experts in the relevant fields to be engaged as technical advisors, and also the infringement of portrait and other rights of and the economic rights of other persons were protected under the amended Act.
사용자가 별도의 라이선스를 구입하지 않고
In this case, a user purchased from the plaintiff only a product key of the program at issue, whose copyright holder is the defendant, and without a license purchase, downloaded the program at issue from a website operated by the defendant, and further consented to the right to use contract while downloading and used the program at issue by obtaining authentication with a product key. The Supreme Court held that the user's act of downloading and copying the program at issue, as stated, is infringement of copyright, and the act of selling the product key constitutes aiding infringement of copyright. Article 14, Clause 2, Paragraph 2 of the Unfair Competition Prevention Act prescribes that where an infringer of operational profit is enriched with a benefit through an act of unfair competition, the amount of benefit should be presumed to be the amount of damages of a person whose operational profit has been infringed. The court ruled that using the outcomes of another person without permission compared to a case in which the outcomes of another person are used lawfully, resulting in savings in terms of manufacturing finished profits. Therefore, any profit generated by cost saving may be viewed as the infringer's benefit.
개인적으로 관심 있게 생각하는 쟁점은 출원 전에 공지된 디자인이 신규성 상실에
Personally, I am interested in whether a defense of a freely exploited design of a third party can be permitted on the ground of a publicly known design under the condition that such a design publicly known before filing an application constitutes an exception to loss of novelty. Even if a design of an author who has the right to register the design is publicly known before an application for design registration is filed, the design should not be viewed as a publicly known design. And this is called the exception to lack of novelty. Where a design is publicly known before an application was filed, falls under exception to lack of novelty, the design may be registered. However, an issue arises as to whether third party can argue that an exploited design constitutes a freely exploited design based on the design publicly known before an application was filed.
누구나 자유롭게 실시할 수 있다는 믿음을 가지고 그와 동일 유사하거나
in principle, a design already in the public domain before an application for design registration is filed is deemed to be publicly known by the applicant himself and herself and may not be subject to an exclusive
침해를
right,
인정한다면
and then thus
그
shall be
제3자는 불측에
able to be
피해를
freely
입게
practiced by
됩니다.
anyone,
또한 제3자에게 출원
and
전 공지된
by anyone.
디자인이 신규성
However, strictly
상실의
applying
예외에
such principle
해당하여
of
도입된
novelty and an
것인지
inventive step
그렇지
in creation to the design
않은지를 조사할
registration can be too
의무를
harsh for
부담시키는
those who have the right to
결과가
register the
발생한다는
design,
것을
which might lead to the degradation of the
그
principle of
근거로 하고
equity.
있습니다. 허용해서는 안 된다는 견해는 출원 전에 공지된 디자인이
Another
신규성
issue
상실의
is that
예외에 해당하여
it may be
등록이
inconsistent with the
되었음에도
purpose of the Design
불구하고 그 출원
Protection
전
Act to
공지된
contribute to the
디자인에
development of
기초한
industries.
자율 출시
In
디자인
this
확산을
regard, the Design
허용한다면
Protection Act enacted a
신규성
provision
상실의 예외에
prescribing an
해당하여
exception to
등록된
the lack of
디자인은
novelty in
사실상
determining
그와
the
동일
registration
유사한
within
디자인의
a scope
실시에
not
대하여도
harming a
디자인권
third
침해를 주장할
party's
수 없게 되고
interest.
그 결과
If an
등록
exception to lack of novelty
디자인권자로서의
precludes
독점
even a defense of
배타적인
freely
권리를
exploited design
전혀 누릴
based
수
on the
없게
publicly known
되므로
design, it would go
결국
against the intent
신규성
of the
상실의
exception provision
예외를
mentioned above,
규정한
promoting
그 법이
equity to the
유명무실하게
extent that it
된다는
does
점을
not harm
근거로 하고
a third
있습니다.
party's interest.
현재까지 이에 대하여 명시적으로 판단한 대법원
We do
판결은
not
찾기
have Supreme Court
어렵습니다.
decisions explicitly
마지막으로
explaining the
팬데믹
above
이후
issue.
대한민국의 소송 및 재판 절차
Finally,
등에 관한
any
비대면
changes
재판의
in
진행에 관하여
Korea's
소개해 드리도록 하겠습니다.
procedural system and
팬데믹으로 인하여
also the
비대면 소송이
IP-related
일상화되면서
court systems.
비대면 재판에 대한
Korea had
요구도
been allowing
증가하고 소송
pleadings through
관계인이
virtual
직접
trials
법정에
already.
출석하기
However,
어려운
the
경우
system had
쉽고
not
편하게
been used
재판
frequently before
절차에 참여할 수
COVID-19. Things have
있도록
changed due to the
2021년
pandemic.
11월
Many
18일부터
activities have become
영상
contactless and the
재판이
demand
확대
for contactless
실시되었습니다.
trials have
영상
increased.
재판은
With this
변론기일,
backdrop,
변론
virtual
준비기일,
trials have been
신문기일,
expanded from November
조정기일,
18,
증인, 감정
2021.
및 당사자
Oral
신문에서
hearing,
가능합니다.
pre-trial hearing, hearing date,
영상 재판
mediation date,
프로그램을
witness,
이용하여
appraiser,
영상
and party
법정에
hearings can be conducted
접속하여
virtually.
재판을 진행할 수 있고
And
사무실, 집, 가까운 법원에서 영상 재판에 참여할 수
so,
있습니다.
in case it is difficult for a party to appear in a
한쪽
court in person
당사자만
due to
또는 양쪽
inconvenience
당사자
of
모두
transportation or
영상
other
재판을 할 수도 있고
circumstances,
법정에서
for
재판받는 것과
witness and
동일한
parties
효력을
hearing, in
가집니다.
case it is difficult for a witness
영상
to appear in a
재판을
court in
경험해 본
person,
당사자 및
if she lives in a
소송
remote
대리인들은 그
place
편리함 등을 이유로
with poor
높은
transportation,
만족감을
they
보이고
can make
있고
use of the
영상 재판
virtual
신청 건수도 증가하는 추세입니다. 특히 한국의
trials.
서울중앙지방법원과
Parties and legal
특허법원은
counsels who have
전국의
experienced a
지식재산권
virtual
관련
trial
소송
revealed
사건의
high levels of
관할권을 가지고 있어
satisfaction, mainly
사건
because of its
관계인의 주도
convenience.
및
Further, the
거소기가
number
멀리
of
떨어져 있는 경우가
applications for
많고
virtual trials is
특허
increasing.
소송
In
사건은
particular, as
외국
legal
사건과
actions of IP rights are
고도의
across the
기술
country
관련
are under
소송에
the
증인,
jurisdiction of the Seoul Central
간장인들이
District
외국에
Court and the
거주하는
Patent Court
경우가
too often.
많아서
The courts are distant from the
여타의
addresses
소송
and the
사건에
residences
비하여
of the
영상
interested
재판의
parties.
필요성 및
In addition,
글씨시로
cases
인한
involving
편의성이
foreign
증대되는
parties
등
or about
장점이
highly
많습니다.
sophisticated
이만 발표를 마치도록
technology
하겠습니다.
often reside abroad. So this is the reason why the satisfaction level has been so high. With this, I would like to conclude my
판사님 좋은
presentation.
발표 대단히 감사합니다.
Thank you, Judge Eun-hee Park, for your wonderful remarks. I would like to thank all of our panelists for preparing their answers to important questions. Due to time difference, Judge Anna-Lena Klein is joining us very early in the morning, and Judge Kathleen O'Malley very late at night. They are with us virtually, and Justice John Nicholas joined us and shared very insightful thoughts. I would like to ask your understanding for one point. When I was introducing our panels, there was an error for the flag for Australia. I once again apologize for this error. I'd like to thank once again all our presenters for session 1. And I would like to thank all participants both online and in person. This brings us to close session 1. Thank you so much.
Thank you, everyone. This ends the session 1. Let's give a big round of applause to the moderator and speaker of this session. 큰 박수 부탁드립니다. 네, 패널과 발표자께서는 잠시 무대에서 사진을 좀 찍어주시면 감사하겠습니다. 네.
We will have a photo shoot of the panels for session 1 on stage.
참석자 여러분께서는 1시 30분까지 점심을 드시고 이후 2세션을 시작하겠습니다. 점심은 10분 후부터 제공이 되겠습니다.
The shuttle leaving to Daejeon Station will leave in front of the hotel at 1 p.m. The shuttle running to the Daejeon Station will leave from the hotel at 1 p.m.
말씀드리겠습니다. 잠시 후 5분 후부터 2022 국제 특허법원 컨퍼런스 2세션을
Word of announcement.
5분 후에 시작하겠습니다.
5 minutes, we will be beginning the second session of today's conference. Thank you. Begin session 2 shortly, so may I ask all participants to kindly enter the hall.
Welcome back, everyone. I hope you enjoyed your lunch. We are about to start the second half of today's schedule. 안녕하십니까? 즐거운 점심시간 되셨습니까? 이제 2022 국제 특허법원 컨퍼런스 2세션을 시작하겠습니다. This session is about unfair competition prevention In this session, speakers will compare each country's legal principle and case on unfair competition prevention. 이번 세션은 부정경쟁 방지법에 관한 세션으로 주요국의 법리와 사례를 중심으로 비교법적으로 살펴보겠습니다. Let me introduce the moderator of second session, Honorable Presiding Judge 태식 윤 of the 부산 District Court. 제2세션 진행은 윤태식 부산지방법원 부장판사님께서 맡아주시겠습니다. Please join me in welcoming him.
예, 안녕하십니까? 저는
Good
콘퍼런스
afternoon.
이 세션 진행을
I'm the
맡은
moderator
부산지방법원의
of the
윤태식입니다.
second session. I'm from the Busan
자리에서
District Court. My name is Yoon
그
Tae-sik.
진행을 맡게 돼서 대단히
So it is indeed a great honor for me to be
이
moderating
세션은
this session.
부정경쟁 행위를 중심으로
So
여러
in
나라의
this
그
session,
실무와 이론을
we'll be
함께 토론하는
looking at
시간이
the comparative law
먼저
examination on unfair
참석하신
competition prevention.
패널을 소개를
So let me
해드리겠습니다.
introduce the panels who are here with
먼저
us today.
미국의 데이비드
From the United States, David H. Bernstein, he's a lawyer.
네, 번슈타인 변호사님은 네베보이스 앤
Mr. Bernstein,
로펌의 지식재산권 소송 그룹을 이끌고 있으며
he is leading the IP group
미국에서
at the
지재권
Bois and Plimpton LLP,
분야의 권위자로
and he
알려져
is a
있고요.
renowned authority in this
상표법으로서는 또
field.
최고의 변호사 중 한 명으로 평가를 받고
He is
계십니다.
indeed
그
regarded
외에
as one of the
변호사님께서는
very best lawyers
대체적
in the
분쟁
field.
해결
And
분야에서도 활발히
alternative
활동을 하고
dispute
계시고요.
settlement is also
지금
an area that he
뉴욕대와
is very
UC
active in.
버클리에서
At the UC Berkeley and at the New York University, he is serving as an adjunct professor. Next,
그다음에 영국의
from
제임스
UK,
멜러
James Beller.
잉글랜드 웨일스 상급법원 판사님을
He is the High Court judge from the High Court of England and Wales.
제임스 멜러 판사님은 공학을 전공하고 세계
James
각국에서
Meller
인재로 근무한
had majored in
후에 법조계에
engineering,
입문하셨습니다.
and after serving this field,
2015년
he has
상표
become a
디자인법
court
항소심
judge.
심판관으로 임명되면서
And
법관으로서 첫 발을
he has
내딘
been
후에
appointed as a
20년
judge in the
9월
appellate
영국
court, and
부고등법원 판사님, 21년
then
2월에는 전임고등법원 판사로 임명되었고요.
he has been
런던 고등법원
appointed
상법부에서
as a high
다양한
court judge
분야의
afterwards,
재판을
and he
특허
has
재판을 집중적으로 맡고 계십니다.
experience in many different IP-related fields.
다음으로
Next,
독일의
from
사샤
Germany,
프레스 변호사님을 소개해드립니다.
Sasha Press.
사샤
She's a lawyer.
사샤 프레스
Sasha
변호사님께서는
Press
SKW 슈왈스의 파트너 변호사로
is a
활동
partner
중이시고
lawyer at SKW
지금 독일
Schwartz.
상표법 개정안
And
하에서의 전형적이지 않은 상표의 보호 적격성 및 등록 적격성을 주제로 박사 논문을
he has written
베를린
a PhD thesis on the protectability and registrability of non-conventional trademarks.
지금 상표법, 디자인법, 저작법,
So,
불공정 경쟁 관련 사건을 주로
he
맡고
is responsible for trademark and unfair competition cases.
다음으로 오늘 현장에는 참여하지 않으셨지만은 요시유키 다무라
Yoshiyuki Tamura, who is joining us via online.
다무라 교수님께서는
Professor
도쿄
Tamura
대학교에서 지식재산권을
is
가르치고 계시며
a professor teaching IP
주요 연구
law at the
분야는
University of Tokyo,
특허법부터
and
저작권법,
starting from
상표법,
patent
불공정
law
경제법 등
and the
다양한
property
지식재산권의
law,
모든 전 분야를 거쳐서
all the fields
깊이
of
있는
the intellectual
연구를 하고
property
계시고요.
rights is what
저서도 한 15권이
she is
넘는
researching
저서를
in,
출간하고
and there's about
계십니다.
5 books that he has
일본에서
written,
최고의
and he is
지식재산권
one of the leading authorities in
권위자로
Japan
지금
in terms of the
알려져 있습니다.
IP litigation field.
그다음에 한국 패널입니다.
Next is the Korean panel.
먼저 이지영 부장님을
Jiyoung Lee,
이지영 특허법원 고법판사님을
judge at the
소개해드립니다.
Patent Court, High Court.
약학사, 약학석사 및 약학 박사 과정을 수료하셨고
She has a master's degree and a PhD of pharmacy, and she has her bachelor degree of law and completed a master degree
미국
and
조지 워싱턴
is
대학교 로스쿨 방문
undertaking
연구자
PhD
과정
courses at
미국 연방사법센터
SNU.
포린 비지팅
She worked at George Washington University as a visiting scholar and was appointed as a foreign visiting fellow in the Federal Judicial Center of U.S. Federal Court. She has been serving as a judge for 3 years at the Patent Court, and she has been recently appointed to the High Court of the Patent Court.
한국 패널의 또 한 분 임경호 판사님을
And we'd
소개해드립니다.
like to introduce second
수의사 면허를 취득하셨습니다.
judge from Korea,
2011년
Im Kyung-ho.
중앙지방법원 판사로
She
임명하셔서
was appointed judge at the Seoul Central District Court and Incheon District Court and Bucheon District Court, and she has been serving as a judge starting in 2021 at the Patent Court of Korea.
패널 소개를
So that was an introduction of our
자,
panels for
이
today.
세션 주어진 시간은
The time
2시간입니다만
that has been given to us is 2
아시다시피 많은 주제와
hours,
내용을
but we
포함하고 있고
will be dealing with many
패널분들께서
topics.
정말 충실하게 답변 내용을 기재해 주셔서
Because the
모두
panels
설명하기에는
have
시간이 부족합니다.
provided really a detailed explanation
각
about the questions
질문의
that have been
중요한
posed to
내용을
them.
중심으로 자유롭게 강조하고 싶은 부분 위주로
This was
간결하게
indeed
답변해
very
주시면 진행에 도움이 되겠습니다.
elucidating
첫 번째 질문으로
answer that we have been able to
질문은
receive. So let's go into the
부정경쟁
first
행위 방지제도 개관에
question.
관한 부분입니다. 이 부분에 관해서 미국, 영국,
The system to prevent
독일,
unfair
일본,
competition.
한국의 패널
So,
순으로 발언을
US,
하시게
UK, Germany, Japan, and Korea. That will be the order of the answers that we presented. And please limit your answers to 2 minutes. First, Mr. Bernstein from United States, can you provide an answer to this question, the first question?
Thank you, Judge Yoon, and it is such an honor for me to be here with you and with all of the judges and esteemed colleagues here. So thank you for including us. The United States has an unusual legal system. Some of you may have heard of it. It's described as a federalist system. We have the federal law that governs the whole country, but we also have 50 different states, and each state has its own laws. And when it comes to unfair competition, that's generally something that is looked at the state level. We do, of course, have the Federal Lanham Act, which is what is our federal unfair competition statute. It addresses trademark rights as well as false advertising and unfair competition in general. But much of the unfair competition law is done at the state level. And so my paper provides a lot more detail about that. I don't have as much time to go through each of these, but I've put up here on this one slide some of the different types of practices that state law governs on unfair competition. So it can be, of course, trademark and trade dress infringement. We'll talk much more about trade dress and product configuration in a little bit. Passing off, which is really a concept that we've borrowed from our good friends in the United Kingdom. It's 200 years later, so we've forgotten about that little war that we fought once before. Advertising law is a type of unfair competition. It's also regulated at the federal and state levels, as well as deceptive trade practices, unjust enrichment, tortious interference, misappropriation, and really any kind of a tort that is in the business context. Any time that there's a violation of business rights, that falls generally under the unfair competition rubric. And we'll talk a little bit more about some specifics there when we get into the details with our next questions.
다음으로 멜러
Like David, I'm very pleased to be here, and I'm very glad to be participating in this very interesting conference. Now, as I'm sure you're aware, Article 10 bis of the Paris Convention obliges signatories to provide, and I quote, effective protection against unfair competition. Now, despite being a signatory for many, many decades, the UK still has a question mark against its whether it's satisfied this obligation. And like David described for the US, we effectively protect against unfair competition through a patchwork of other rights. Number one on the list is passing off, which we're going to come to very shortly. But you've got a whole range of other causes of action like malicious falsehood, some specific criminal statutory provisions, and many different pieces of EU law, which despite our exit from the European Union, we have now retained as part of our UK law. And so, despite many lobbying attempts to get the UK to implement a general law of unfair competition, that has been resisted, probably because it is very, very difficult to provide a decent definition of what constitutes unfair competition. So that's a very brief introduction from me.
네, 다음으로 프레스 변호사님. 네.
Also from my side, once again, thanks for having me, and I'm really delighted to speak at this conference here. Yes, well, leaving the EU is not what Germany has made so far, and hopefully won't do ever. And that brings me also already to the rules of the unfair competition, to the roots of the unfair competition system in Germany. Because what is the unfair competition system in Germany very much relies on directive and regulations, or mainly directives adopted by the European Union, in particular the Unfair Commercial Practices Directive, as well as the Misleading and Comparative Advertising Directive. And there are many other directives which relates to unfair competition law. In Germany, we have a complete act on unfair competition, the German Act on Unfair Competition, which provides in its section 1 a definition of its broad scope. Because unfair competition protects consumers, competitors, and other market participants in Germany, and it covers different acts of market behavior or of commercial acts. It covers misleading or aggressive practices, comparative advertising, and as well as confusion about origin, or so-called free riding, which we will focus later on. What is a hot topic at the moment in Germany is, and that's the picture on the right side, is green claims and false advertising in respect of sustainability. The EU is adopting a new directive on this green claim advertising, and I think this is the next big thing in German unfair competition issues. Possible claimants. The presentation is not working as it should be. In Germany, there are certain different claimants who can, and I think it's a little bit unusual in Germany compared to other jurisdictions, because not only competitors have unfair competition claims, but also consumers can, since very recently, ask for damages, as well as a so-called specially qualified associations who are to some extent responsible for and they have claims against someone who infringes unfair competition rules. Thanks.
예, 다음으로 일본의 온라인으로 지금 연결이 돼 있으실까요? 다문화 교수님.
Thank you very much, Chairperson, and I'm quite honored and very pleased to be given the opportunity of making the presentation of Japanese situation. So first, I would like to talk about the history. And Japan has the Unfair Competition Prevention Act, which was codified in 1934, and it aim was to join the latest Paris Convention for the protection of industrial property, and it's a kind of excuse legislation. So until 1980s, it was very simple, and it contains just 6 articles as of 1989, and it was not used so often as of those days. However, here comes the turning point. The turning point was the introduction of protection of trade secrets in 1990. And since then, the Ministry of Industry has been utilizing this Fair Competition Prevention Act as intellectual property law, and which leads to introduction of various IP protection, including the regulation against the protection of famous mark, regulation against service imitation, and technical management protection, and protection of domain name, and the recent amendment, protection of big data. And actually, this UCPA is now quite often used, and it accounts for roughly about 1/3 of IP cases in Japan. And these are the features of the UCPA, and we don't have any general quotes. And it was mainly remedies, mainly civil regulation, and criminal sanctions are sometimes used. And we don't have any administrative regulation here in the UCPA. And the administrative regulation is the realm of Anti-Monopoly Act and Unjustifiable Premiums and Misleading Representations Act. But those two acts do not contain any IP protections. Thank you.
네, 다음으로 한국의 이지영 부장님. 임경옥 판사님.
Next, Judge Im Kyung-wook from Korea.
안녕하십니까. 한국
So good
특허법원 임경
afternoon.
판사입니다.
I'm Judge Im Kyung-wook from the
한국은
Korea
부정경쟁
Patent
행위를
Court.
방지하기 위한 제도로
Korea has enacted
부정경쟁
an
방지
unfair
및
competition
영업비밀 보호에
prevention
관한
and
법률을
trade secret
규정하고
protection
있습니다.
act to prevent unfair
상표법상
competition
등록하지
even if a
못하는 상표
trademark
또는
or service mark is
하더라도
not registered under the
오랫동안
Trademark Act.
사용됨으로써
If it
거래자나
is
일반
widely known as a
소유자들에게
mark
어떤
indicating the
특정인의
business
영업을
of a certain
표시하는
person
것으로
to the
널리
public,
알려진 경우에는
then it
부정경쟁
constitutes a
방지법이
product
보호하는
mark
상품
or a
표지
business
또는
mark
영업 표지에
protected
해당하므로
under the Unfair
부정경쟁
Competition
방지법에 의하여
Prevention
보호받을 수
Act.
있습니다. 또한 신규성
Also,
유무나
novelty,
진보성 유무,
inventive
심리적
step,
가치
or
유무에 관계없이
aesthetic value,
어느
regardless
상품의
all of
형태가
these, if the
차별적 특징을
configuration
가지고 있고
of a good has
오랫동안
differentiated
사용됨으로써
features
거래자나
and by
일반
long period of use
소유자들에게
is
어떤
widely
특정인의
known as a
상품을
mark of a
표시하는
good
것으로 널리
by a
알려진
specific
경우에는
person, then it can
부정경쟁
be
방지법에
protected
의하여
under the
보호받을 수
Unfair
있습니다.
Competition Prevention
그리고
Act.
특허법,
If
상표법, 디자인
the
보호법에서
requirements
정한
under the
요건을
patent
충족하는
law and the
경우
Trademark
위
Act and the
각
Design
법과
Protection
부정경쟁 방지법에
Act is
의하여
fulfilled, then
중점적으로
multiple
보호받을 수도
layers of
있습니다.
protection can be conferred upon the goods or services.
네, 끝나셨습니까? 예. 자, 그러면 두 번째 질문으로
Now we will move
들어가겠습니다. 두
on
번째
to our
질문은
second
좀 포괄적인
question.
것으로
It
상품
is rather
주체,
broad
영업 주체
question, act of
혼동행위입니다.
causing confusion about product
이
source or
부분은
business entity.
이 부분은 두 부분으로 또 나눠서
This
첫 번째
question
부분
is divided
먼저
into two
해당
parts.
요건과
So
유형 및
first is
사례를 중심으로
about
먼저
cases on types
4분씩
and requirements, and
미국,
please give us
영국,
4-minute
독일, 일본, 한국 패널
answers.
순으로 발언을 하시게 되겠습니다.
Starting with
먼저
the
번스타인
US.
교수님 부탁드립니다.
So, Professor Bernstein.
Thank you very much. So the key question is always going to be one of confusion in trademark law as well as advertising law. And the case law in the United States makes it clear that what we're looking at is whether there's a likelihood of confusion. So confusion doesn't have to be proven. You don't need to come into court with actual evidence that there's real confusion. You just need to show that there's a likelihood of confusion, that confusion is probable. It's not enough that it's possible or that it might be speculative, but you need some kind of evidence to establish that there's really going to be confusion. And the case law talks about confusion of an appreciable number of reasonably prudent purchasers. So what does that mean? On an appreciable number, we generally are thinking, will 15 or 20% of the population for that product or service be confused? And that confusion has to actually be of people who are reasonably prudent. If there's someone who is being careless or is not devoting sufficient attention to being careful in the purchase, we don't really worry as much about the careless or the stupid consumers, I'll say. We really want to look at people who are likely to be reasonable purchasers. And that confusion can be not only about source, so does this product come from them, but it can be about whether there's some other type of relationship. Is there an affiliation relationship or a licensing relationship? And we even have something known as reverse confusion, which I'll talk a little bit about later when we talk about some survey issues. That is that you might be a junior user who was the first, but you have a small product, and then a giant company comes in, and people might actually confuse your products with the giant companies, even though you were first. And we do treat that as actionable confusion. Not only do we have a federalist system where there's the states and the federal government, but within our state, in the federal system, we have multiple different circuit courts. And the courts of appeals have set slightly different standards. Here I've laid out the standards from the Second Circuit in a very famous case involving the trademark Polarad, which was found to be confusing with the trademark Polaroid. And I won't go through all these factors, but these are among the factors that courts will think about when assessing how likely is there to be confusion in this situation. So we certainly want to look at the mark. How similar are the marks? And it's very interesting when we're talking about brands that might be in Asia, for example, because you have a different alphabet. And at lunch, we were talking about the differences between the Korean characters and the Japanese characters. And so we look not only at the sound, but also the meaning. So we might consider, is it confusing when you translate it or when you transliterate it, for example? We look at how close are the products. We look at whether it's likely that you would introduce a product in that category. We want to consider your good or bad faith. Did the defendant adopt that name to take advantage of the plaintiff's trademark rights? Or did they do it in total good faith, believing they had the right to? And those issues all go into the assessment of whether confusion is likely. Of course, if there's been actual confusion, that can be very relevant as well, and that's evidence that we will consider. But it's always important to remember that you can still win a trademark case showing that confusion is likely, even if it hasn't developed yet, especially in the context, for example, of a preliminary injunction. So that's a very quick overview of some of the factors that we consider when we're looking at the question of a likelihood of confusion.
네, 빌라 판사님.
Yes, our German
Thank you,
presenter.
David. It's very interesting to see how the law of passing off has traveled around the world. Passing off as a cause of action in the UK is entirely judge-made law, so it's part of the common law of England and Wales. And it traces its origins back to some cases in the 16th century. So it's a very ancient jurisdiction. Fortunately, I don't have to go back to all these old cases in the 16th century because of a decision of the House of Lords. You'll probably be aware of it, the Jiff Lemon case. That was a case involving the House of Lords in the UK, I think decided in about 1990. And Jiff Lemon is the modern statement of the law of passing off in the UK. And it's got three elements. One, you have to establish reputation. Two, you have to establish a misrepresentation. And three, you have to establish damage to goodwill. Now, it sounds very simple, and a lot of non-IP lawyers, they get their hands on what they think is a passing off case, and they say, oh, three elements, dead easy. And they don't understand all the subtleties behind those three elements, because they're all interrelated. So, for example, reputation. You've got to have a reputation amongst a relevant public. And in most cases, that's generated by trading. And in most cases, the trading also generates goodwill. And goodwill is the positive force that brings in custom. And the reputation is the foundation for the misrepresentation. And the misrepresentation has to cause the damage to the goodwill. And there are many cases where the links between the three elements aren't made out properly. And those are the difficult cases. But it's very interesting that David was talking about a likelihood of confusion, because in passing off, we have a distinction between what you would call mere confusion and an actual likelihood of deception. Passing off requires a likelihood of deception. In other words, people have actually got to be caused by the defendant's mark or trade dress or whatever to believe that it's either the same as, or it comes from the same source as the plaintiff, or that it's linked in some material way in the course of trade. And perhaps the best example of the difference between these two concepts is an old case, again in the House of Lords, Office Cleaning Services against Office Cleaning Association. And they were both involved in cleaning offices. And in a famous case, the House of Lords decided, well, if you want to use a descriptive mark as your trading name, you're going to have to put up with small differences. In that case, the difference between services and association. And in that case, there were people who were confused between the two, but those were treated as mere confusion and not establishing a likelihood of deception. So that's a brief introduction to the wonderful law of passing off.
예, 프레스 변호사님.
Now moving on to Lawyer Press.
Thanks so much. Well, so what I've learned now from the US and from the UK is that it's always 3 requirements, and that applies to Germany as well. And actually, the principles which are double checked by the court, which are checked by the courts within these kinds of proceedings, are always are pretty much the same or are at least comparable. In Germany, as a general rule, we will come to later to this again, we have this freedom of imitation unless it is there are some specific IP rights existing, or unless the imitation of a product is would constitute an act of unfair competition. So the main regulation or the main provision in Germany in the German Act of Unfair Competition is Section 4, number 3, which has mentioned 3 requirements. So the product needs a certain amount of distinctiveness, or the original product at least needs a certain amount of distinctiveness. This requirement is actually a little bit comparable to the originality of a design right, or maybe also comparable to the distinctiveness of a trademark. Of course, in unfair competition cases, the threshold is much lower for the distinctiveness according to Section 4, number 3, because and what courts are doing and what lawyers, what we are doing in these infringement cases, we show the courts how the market situation in this fields of product looks like, and try to explain why this allegedly original product may not be distinctive enough to stand out from the perspective of the average consumer. The second requirement is the question of imitation. The German courts divided in identical, nearly identical, or what I describe here as I needed to say it in German, nachschaffende Nachahmung. It's a difference in details. So there are differences in details between the copy product and the original products, but the original product would be still recognizable. So I didn't find a proper English translation, so that's why I needed to quote the German word. And the third requirement is the requirement of unfairness, and that's where the likelihood of confusion, exploitation of reputation issues pops in, because under Section 4, number 3 is divided into 2 parts, A and B, and under A, the German courts apply the situation of avoidable deception about the product's origin, and under number B, there are the cases, or number B covers cases where reputation is exploited unreasonably. So these are the requirements under German law. Thanks.
다음으로 다무라 교수님 부탁드리겠습니다.
Now, Professor Tamura.
Yeah, and Japan also have 3 requirements, and the active confusion regulates under the Unfair Competition Prevention Act, Article 211, and which has the 3 requirements. The first is the well-knownness. So the mark should be known to customers to identify source of goods or services. And second, similarities. So alleged infringer's mark should be similar to well-known mark. And the third, likelihood of confusion. And here comes the types of marks and UPCA's Article 211, and any indications can be qualified for protection, including names, trademarks, container and package of goods, and trade dresses. And here comes the case. So the 3D signs, 3D 3D big cup-shaped signs for a club restaurant chain was adjudicated as protectable under this clause by Osaka District Court in 1987. And also animation characters like such as Mickey Mouse or Popeye or Peter Rabbit was adjudicated again as protectable under these court decisions in lower instance cases. Also, it's a bit brief introduction, but I would like to spare my time for explanation of next issue to address. Thank you.
네, 임기용 판사님 부탁드립니다.
한국 부정경쟁방지법은 2조 1호 감옥에서
subparagraph
상품 주체 혼동행위를
1A of Article 2 of the
부정경쟁행위로
Unfair
정의하고
Competition
있습니다.
Profession and Trade Secret Protection
상품
Act
주체
of Korea
혼동행위에
stipulates an
해당하기
act
위한
of unfair
요건으로는
competition,
타인의 성명, 상호,
and the
상표,
requirements
상품의 용기,
include
포장, 그
any mark
밖에
indicating
타인의
another
상품임을
person's
표시한 표지에
goods,
해당해야
such
하고
as name,
그
trademark,
상품 표시가
container,
국내에
or
널리
package.
인식되어야
The
하며
mark should be widely
타인의
known in
상품
Korea,
표지와
and it should be an
동일하거나
act of
유사한
selling,
것을
distributing,
사용하거나 이러한 것을
importing, or
사용한 상품을
exporting
판매,
goods bearing
반품
such
또는
marks,
수출하여야 하고
or
타인의
an
상품과
act of causing
혼동하게 하는
confusion with
행위여야
another
합니다.
person's product.
또한 한국 부정경쟁방지법은 남옥에서 영업주체
Under
혼동행위를
subparagraph
부정경쟁행위로
1b,
정의하고 있는데
the act of
상품 주체
causing confusion
혼동행위에
about a
해당하기 위한
business
요건과
entity is
영업주체
also
혼동행위에
stipulated,
해당하기
but
위한 요건은
the
상품
requirements
표지와 영업
are
표지의 차이일 뿐
all
나머지 요건은
else the same,
공통됩니다.
except that
상품 주체
B
혼동행위,
refers to the marks
영업주체
indicating another
혼동행위에
person's
해당하기 위한
business.
주관적 요건으로
And as for the
부정경쟁행위를
subjective
한다는
requirement, there
인식이
should be
있어야
an
하나
awareness of conducting an
부정경쟁행위를
unfair
한다는
competition
인식
act,
외에
but
부정경쟁행위자의
malicious
악의
intention
또는
or an
부정경쟁행위자의
anti-competitive purpose on the part of
부정경쟁방지법은
the actor
필요하지
is not
않습니다.
required.
부정경쟁방지법 2조 1호 감옥의 상품 표지에는
And under the business marks, smell, taste, movement, 3D trademarks, domain names, characters, and trade dress are applicable as long as they have a function of indicating the origin of the product. And business signs are also all signs that indicate the source of business, and trade dresses are included as long as there is identification as a business sign that shows the business of a specific person. The plaintiff have registered the mark on the left, and the defendant used the mark on the right. So generally, although the mark doesn't work as a source of business, if it is distinctive and has distinguishing quality for the business of the plaintiff and has been used exclusively to the extent where the consumers perceive the mark in relation to the source of the mark, the business entity, then this will be recognized as a mark of business. Also, the musical Cats was also recognized as a business mark, since the musical is a work that is used for the business of its production performance, a musical performance using the same script, music, lyrics, choreography, stage art, etc. And as it is continuously performed over and over. 3D shapes are also protected. Domain name by itself cannot be said to function directly as an indication of origin for a product, but when it functions as an indication of the source of the product, it is a product label or business label. In case the source of the product could be indicated according to the prevailing trade convention, and it is also protected under Article 12(1) of the Internet Address Resources Act. And if commercialization of character is carried out, the character is seen as a product marked of a person who has the right to commercialize the character through continuous publicity, advertisement, and quality control. Trade dress also falls under the product cover or sales cover if it functions as an indication of the source of the product or sales. Trade dresses are also protected by the Trademark Act, Design Protection Act, Copyright Act. And the rest of the question is about trade dress and the meaning of confusion. So please give 3-minute responses in the same order as the previous part of the question, starting with Lawyer Bernstein.
Okay. So it's interesting to hear. No.
Trade dress.
Trade dress, yes. Okay. So in the United States, we do protect trade dress very broadly as well, as John Lynn mentioned. And it can be all of the things that you discussed. So certainly taste and smell and sound can be 3D marks, domain marks. And I've put up here some of the trademarks that have been subject to trade dress claims in the United States. For example, you can see the shape of the Toblerone packaging, that very distinguished triangular shape, which of course looks like the Matterhorn mountain, and so it's very appropriate for Swiss chocolate. The dripping red wax seal on that bottle of Maker's Mark bourbon, that itself has been found to be protected. And there was a famous case involving a tequila product called Jose Cuervo, where they also had a dripping red wax seal, and the court found that it violated its rights. I won't go through all of these. I think the Coca-Cola bottle is probably one of the most famous shapes and trade dress that have been protected. And in the United States, these can also be registered. And so, for example, you can see I have an image there of the US registration number 4277913. That's actually the configuration of the Apple store. So if you walk into an Apple store, many Apple stores have this exact same look with a certain way that the tables are presented, the way that the products are presented on the table. And the Trademark Office has allowed that to serve as a trademark. And then on the very bottom right, you can see that we have the shape of the building for a taco restaurant. And this case actually went to the United States Supreme Court, which ruled that the whole shape and product configuration of a restaurant itself can serve as a trademark. And there was a competing Mexican restaurant that had a similar concept in the way that the restaurant was designed. And that product configuration, that trade dress, was found to be protected too. I won't play the video, but under United Airlines, some of you may have been familiar with Gershwin's Rhapsody in Blue, which is, of course, a very beautiful piece and a famous musical piece, but that also serves as a trademark for United Airlines. And they use the Rhapsody in Blue sound as an indicator of its source.
네, 멜러 판사님.
Judge Miller?
Well, passing off certainly applies to trade dress. And in your reference book, there are some illustrations of two cases I want to talk about. So in the Korean, you need to turn to pages 23 and 24. And in the English version, it's 243 to 244. So on page 23, you'll see that the Jif Lemon case was indeed a trade dress case. And one of the things about trade dress in relation to products that is a key issue is what happens to labeling. And the reason why the Jif Lemon case succeeded is because people took the labels off the claimant's product, and on the defendant's product, the labels were assumed to be just descriptive. They just said real lemon. Now, by contrast, over the page, the AU vodka case, which I decided in September, it was an application for an interim injunction. Very interesting shape of bottle. The bottles are almost identical in shape. And on the one on the left is AU vodka, set up by 3 people in Swansea in Wales about 3 years ago. It's been an immensely successful brand. So within 3 years, they have a turnover of £40 million. All the bottles are that shape. They're all metallized in a gold color, and they all have the same labeling. So you have a badge at the top, AU vodka. What you perhaps can't see is AU with 79 just up to the right. In other words, for the chemists amongst us, that's a reference to the periodic table and the atomic number of gold. And on the bottom, you've got another label. Look, I mean, both labels are designed to look like metal plates applied to the bottle. Now, the defendant's product created by two brothers also from Swansea in South Wales, has a virtually identical bottle, differently coloured. It's not gold. They have 3 flavours, I think. The one in your pack is the plain vodka. The claimants have about 6 different flavours. They've got very similar labelling. NE10, again for the chemists amongst us, is a reference to neon, whose atomic number is 10. But the one distinguishing feature of the defendant's bottle is it's got a little light in the bottom. So you can switch on the light and it illuminates the whole bottle. Anyway, why did I decide not to grant an injunction, an interim injunction? It's partly because the claimant's evidence of deception all came from social media. And none of the people on social media actually were deceived. They saw it as a knockoff product. They weren't confused. They could see the similarities, but they weren't actually deceived into thinking it was from the same source. So in fact, I refused to grant an interim injunction and made an order for a speedy trial, so that if the claimant wants to pursue the case, they will be able to do so probably early in January next year. And that by then they will see if they've managed to gather enough deceived people to maintain their cause of action.
네, 프레스 변호사님.
Moving on to lawyer press.
That's a very interesting case, James, but it pretty much looks like in Germany we would cover this case by number 3B as an unreasonable exploitation of reputation, because if there is evidence in the internet and on social media, then this could be an option. As David mentioned already, trade dress could also be protected in the EU under the or like in the US, we protect trade dresses with EU-wide trademarks and also in a national trademark system. So potentially any signs can be protected as trademarks. And funny enough, the Apple Store trademark which David presented was a quite famous ECJ case and could have been protected in the EU just after the ECJ decided about it. It is a very unusual mark, actually, and always when I'm passing by an Apple Store, I'm thinking about this case. That's funny enough. Trade dresses in Germany or actual trademark cases. You see this Christmas star. This is actually one of the cases we have won before the German Supreme Court. It was a very famous product and very old product, and therefore we were able to prove that it has been used for decades, and decades meaning really, I think it was 90 or even over 100 years where the original star was created, and the red and white star you see on the right side was a clear knockoff and was actually an obvious imitation. The sausages on the right side, which you see, is also a landmark case called garlic sausages case in Germany. Everybody knows about it because the Supreme Court decided. So these sausages went up to the Supreme Court. The Supreme Court decided at least that and this is where the circumstances of the market pops in, that the cow and the landscape used on the product packaging was so unique that this would be able to create distinctiveness. Another very recent case is about these two guitars. On the left side, you see the Gibson guitar, and on the right side, the alleged knockoff flying V guitar from a competitor. The famous Gibson guitar producer, they lost the case before the German Supreme Court because they were not able to establish an exploitation of reputation, because the German Supreme Court held that because the other guitar was as expensive as the original one, that the average consumer does not see a difference in these two products, and that therefore the likeliness of, or the similarity of both products does not play a major role for them. That was the reasoning, at least. Yeah.
We both look incredulous.
Yeah. Other landmark cases at the moment, or a very recent case, was about this coffee, this French presses. It was very important for the Supreme Court to decide on whether selling the original product under a different sign could also interfere with creating reputation for the original product, because the original producer has sold his original product for a couple of years under different signs and under different names. So the defendant tried to explain that the consumer is not only looking on the getup of the product, but is used to see the signs and therefore distinguish the product, and that their product is not infringing. So, and the other cases about this, about these shoes. So these are quite famous Crocs shoes, which are, I think, also sold here in Korea and internationally. This was also a case which went up to the Supreme Court and was to be decided. Thanks.
네, 일본의 다무라 교수님 부탁합니다.
Okay, so in Japan, the Unfair Competition Prevention Act, Article 221, explicitly includes containers or packages of goods as an example of marks to be protected. And also, courts has been recognizing the product configurations themselves are eligible for protection since 1960s. And here is the notable recent case, Tokyo District Court. And in the litigation, actually, often the degree of well-knownness is at issue. And Tokyo District Court I'm sorry. Oh, no. Okay. Tokyo District Court in Levi Stitch case says 80.6% is enough for protection. And however, on the contrary, Osaka District Court in 2000 in the Human case said from 3 to 6% not enough. So probably or possibly the threshold will be 10%. And there are recent cases held that product configurations need to have distinctive characteristics in shapes and needs to be well known among consumers for the protection of UCPA Article 2111. But however, no case has been reported that denied protection solely on the ground of the first requirement, that lack of distinctive characteristics, while recognizing second requirement, well-knownness. So some commentators, including me, argue that distinctive characteristics requirement is unnecessary. And here comes the problem of the functionality. Tokyo District Court in 1966 excluded the protection of technical features from UCPA because it would otherwise compromise the purpose of the Patent Act and Utility Model Act. However, Tokyo High Court in 1983 denied the theory, saying there was no clause that required such an adjustment, and there was no reason why UCPA should be refrained. In 1991, I myself advocated a new theory that even if the adjustment of industrial property system is unnecessary, a mark inevitably to be similar in order to compete in the market should be excluded from the protection of UCPA Article 2111. Because this article stands on the premise, I think, that there exists competition among multiple sources and this act just regulates the acts of confusion among them. So therefore, the protection of inevitably similar marks would probably go beyond the aim of this act. And several cases followed this my theory and once became a trend. However, recently the old theory that considers the adjustment from the perspective of industrial property laws were revived and recently became a new norm. Thank you.
Trade dress is protected in Korea under provisions in Article 2 of 3D Trademark Design Protection Act of Unfair Competition Prevention Act after its amendment in 2018 April. And trade dress includes the overall appearance of the business, such as interior and exterior decorations of stores. To be protected as trade dress, first, it must be distinguishable by nature or by secondary meaning. Second, it should not have a 3D shape that is indispensable to secure the function. And third, there must be a risk of confusion with another person's product or business facilities. The Act does not explicitly stipulate non-functionality as a requirement, but for a harmonized interpretation with patent and utility design system, it is, in fact, being applied as a requirement. Whether a trademark in a three-dimensional shape falls under the above regulations, whether there's an alternative shape circulating or available in the market where the product is traded, is considered, and it should be judged by comprehensively considering whether the same or less cost is required, and whether the three-dimensional shape does not demonstrate technological superiority beyond the original function of the product. Here, the service table was registered by the plaintiff and ran a beef brisket restaurant with the following mark, and the defendant used the mark that appears on the slide in the same business. And the patent court did recognize infringement of trademark according to the registered service table. However, it was ruled that such marks did not constitute business marks protected under the Act because the discriminatory features of the defendant's store appearance, excluding the blatant service marks, were not deemed to be widely known in Korea enough for traders or consumers to associate it with the plaintiff's store. Along with the narrow sense of confusion where an act causes confusion with another's product leads to mistaking that the source of the product is the same, the broader sense of confusion, which is confusion of affiliation, connection, association, or sponsorship, is also included. Seoul's High Court ruled that the plaintiff, Louis Vuitton, that uses the mark on the left, when they sued the defendant who uses the mark of the right, this is in fact an infringement of trademark because the consumers may confuse that they're mistakenly believe that there is some sort of relationship between the plaintiff and the defendant. And this is a patent court's case. Jung Kwan-chang registered the mark on the left, and the ban of infringement was filed to the defendant who sells products on the right, and this was a case where the broad sense of confusion was also recognized. And post-sale confusion is also included. If post-sale confusion is not included in the scope of confusion under the Act, there is no way to regulate counterfeit goods with well-known signs under the Act, which would be unfair. The Supreme Court ruled that the case where marks similar to Vivienne Westwood trademark, as on the left, and service mark was used on bags or handbags falls under the scope of post-sale confusion, even if the buyer did not confuse the source of product at the time of the purchase due to circumstances at the time. If a third party confuses the source, and thus there is a risk of confusion on the part of general consumers, then this act falls under the definition of act causing confusion. So High Court ruled similarly for the case of Birkin bag, which is sold by the plaintiff Hermes, and in a case where they sued the defendant on the right, even if the quality, price, and other qualities of the product is very different, so there may be no potential confusion at the point of purchase. If a third party confuses the source after the purchase has taken place, and thus there is a risk of confusion on the part of general consumers, this act falls under the definition of act causing confusion in Article 2 of the UFC Act. Reverse confusion is also included in confusion in product subject confusion. If the later user has a business of a bigger scale than the first user, this may cause to damages of reverse confusion. Thank you. Yes, so that closes section 2. We will move on to section 3.
So section 3 is on act of tarnishing distinctiveness and reputation of a famous mark, act of misleading the public. So we will give 3 minutes each to our panel. So first, Mr. Bernstein from United States.
Thank you. It's quite interesting to hear where I think we have some lack of harmonization. I think I've always thought trademark law is fairly well harmonized, but one of the areas that we really differ, at least from what I heard in Japan and Korea, is whether you need to have a well-known mark in order to take advantage of some of these trademark rights. Because in the United States, you just need the barest trademark rights. If your trademark is inherently distinctive, even if it's not very well known, you have trademark rights that you can use in a passing off case or a likelihood of confusion case. The one place that's not true is what we call dilution in the United States, or tarnishing. And in our Lanham Act, in the federal trademark law, a claim for dilution is only available to a famous mark. So even more than well known, it has to be famous, something that is known generally by the whole consuming public. At one point, we looked at trademarks that had niche fame. For example, if you were in the funeral home business, is there a particular urn shape that funeral home owners know about coming from a particular source? Believe it or not, there was a case like that in the United States. But now that we look at general fame, being famous among funeral home owners would not be enough. It has to be a mark as famous as Coca-Cola or Nike, something that is very well known. And our dilution law looks at 2 different aspects. One is tarnishing the distinctiveness, or blurring, we call it, the distinctiveness of a trademark. So here were 2 examples, both cases brought by Nike. In one case against a company called Nike Securities, which was in the stock buying and selling business. And the other one, the Nike Pal International case, that was a company that made laboratory equipments. Now, Nike didn't make up the word Nike. It's actually it's a Greek term. And yet, they've become so famous, it's become such a famous brand, that they were able to stop these other uses of Nike in industries wholly unrelated. No one would ever think, when they found out there was a company called Nike Securities, that Nike, the sportswear brand company, was behind the securities company or the laboratory. And so it's only the most famous marks that get this kind of protection. The second approach that we have to tarnishment in the United States goes to this question of tarnishing the reputation. And that's where you're using a famous trademark in a way that may harm that trademark. An old example is the Enjoy Cocaine case. So it looks just like Enjoy Coca-Cola. If you looked at it quickly, you might have just thought it said Enjoy Coca-Cola. It uses the distinctive script and color and trade dress. And yet somebody made this joke poster, Enjoy Cocaine. It's actually quite ironic because Coca-Cola got its name because it originally was made with cocaine 100 years ago, which is why it really did pick you up. Today, of course, it is not, and Coca-Cola was offended that cocaine was being associated with its famous mark. On the bottom is a condom that was being sold under the trademark "Never Leave Home Without It," and that was making fun of the famous American Express line, "Don't leave home without it. Always travel with your American Express card." And so American Express did not want its slogan associated with condoms. And then finally, the case in the upper right corner is a case that went to our United States Supreme Court. It involved the Victoria's Secret brand, and they were offended that somebody opened a shop that sold sex toys called Victor's Secret. And the guy who opened Victor's Secret clearly had Victoria's Secret in mind. He clearly was thinking about Victoria's Secret. As the father of 3 girls, I must say I'm fairly offended at some of the advertising for Victoria's Secret, so I thought it was ironic that they were offended by this. But the US Supreme Court did say that if you have a dilution claim like this, under the old law, you had to show that it actually harmed your mark. And here they didn't have evidence of that. The case was remanded to the lower court, and while it was still pending, Congress changed the law to say that you only have to show an a likelihood that it would cause harm. And because the case was still pending, they were able to win on a likelihood of dilution theory, but they still had to show that their trademark was a famous trademark.
네, 멜라 판사님.
Well, dilution of distinctiveness or tarnishing of reputation in the UK it's really the extended form of trademark infringement provided in Section 3 of our Act, which itself derives from Article 5.2 of the EU Trademark Directive. And the origin of the EU law, I think it comes from Dutch law, and there's a famous case in Holland where Clarin was the name of a gin, and somebody started using a word that sounded very similar, Clarin, but spelt differently, for toilet cleaner, and that is the case which established tarnishing of reputation. I'll mention 2 other cases because under EU law it took a bit of time before cases about this extended form of protection started to come through to the European Court of Justice. Now, a very early case was brought by General Motors regarding the mark Chevy, and that case established that this form of protection for marks with a reputation, the threshold for establishing reputation was actually quite low. So that was one issue ticked off. Now, what this extended form of protection protects against is taking unfair advantage of a mark with a reputation or causing detriment to the distinctive character or repute of this mark with a reputation. And one of the, I think it was the first case on the damage side of the cause of action was the Intel case. And at that time, Intel was, I think, one of the top 5 brands in the world. And we brought the case against Intel Mark. Well, Intel Mark had applied to register Intel Mark as a registered trademark for, I think, recruitment services or something like that. Anyway, we thought we'd win, but unfortunately, the Court of Justice of the European Union had other ideas. And what they did, they used that case to establish one of the key ingredients of this extended form of protection, that you have to show that the public would form a link between the mark with the reputation and the mark of the defendant. Since then, there's been a large number of cases dealing with unfair advantage, detriment to distinctive character or repute. But that is really the way in which you can protect against dilution of distinctiveness or tarnishing of reputation in the UK.
Okay, press.
Now moving on to lawyer press.
Oh, that's too much. So when it comes to tarnishing and misappropriation from a German law perspective, James mentioned already the EU the EU regulation and the EU the findings by the ECJ. These are of course very much affecting also our law, which is based on the EU trademark regulation as well as the trademark directive, which is implemented into German law. But if we look into this aspect of tarnishing trade dresses or tarnishing exploiting reputation, then I've brought you 3 cases which has been decided by German courts. There are only a few cases which comes up on this exploitation of reputation track, actually, under section 4, number 3b. One of the oldest cases is Rolex versus Chibo. This is actually a landmark case from the beginning of the 90s from the German Supreme Court, where the German Supreme Court held that also this post-sale confusion issue might be relevant in the aspect of 3b, because what happened in this case was that Chibo, which is a retailer which usually sells coffee and some additional non-food product, brought to market the watches on the right side, which pretty much looked like Rolex watches. And the court held that even though it is unlikely that the average consumer would be confused about the origin of the product, it is possible that if one wear this this imitation product, that other people might know that you're wearing a Rolex watch, and this was regarded by the Supreme Court as an unreasonable exploitation of reputation. I've been to a seminar a couple of weeks ago where some German Supreme Court judges were referring new cases, and they had explicitly mentioned that this post-sale confusion issue is regarded so that the actual German Supreme Court has very much doubts about this post-sale confusion institute. They did not decide it in this guitar cases, in this guitar case which I showed you on the other slide, because it was not relevant. But they mentioned in the seminar that they have very much doubt whether this post-sale confusion will be covered in the future in Germany. And on the left side, you see, I think this little golden rabbit has made an international appearance in the recent, or at least in the IP field in the recent years. This is one of the cases I won against this rabbit before the Regional Court of Hamburg. Also, the case was just about exploitation of reputation of the Lind rabbit. What has been now decided by the Swiss court was the question whether this golden rabbit in the middle is infringing their Swiss trademarks. This was decided very recently, and I got some news from Munich from last week, where a German court held that the color mark of these, so the golden color mark, is protected for Lind. So they now own a golden color mark in respect of sitting chocolate rabbits. Thanks so much.
네, 다무라 교수님 부탁합니다.
Yeah. So regarding the protection of well-known mark, Unfair Competition Prevention Act Article 212 codifies protection of famous mark. And this legislation was introduced in 1993 again. And there are just two requirements: famousness of the mark and similarity of two marks. And there are no other requirements. So therefore, it can be utilized against dilution or tarnishment. However, there existed some criticism. And this UCPA Article 212 can lead to overprotection, especially for weak mark, such as Jun in Japanese, which means pure or genuineness, or Asahi in Japanese, which means the morning sun. So I myself advocate to introduce some kind of balancing interest test via standing requirements of UCPA Article 3.1 or Article 4, which codifies some business interests should be harmed or likely to be harmed to get injunctions or damages. But whether case law will adopt this new theory, and it has yet to be seen. Okay, thank you very much.
네, 임경호 판사님 간략하게 좀 정리해 주실까요?
In the case of famous marks with a strong distinctiveness, because of the high level of awareness, it is difficult to recognize concerns for confusion. Therefore, the Korean Act on Prevention of Unfair Competition, Article 2, Clause 1c, does not require the risk of confusion to regulate unauthorized use of famous marks. But the level of wide perception has been raised from well-known to famous to strictly regulate the act of tarnishing reputation. The Supreme Court, in a case where injunction against infringement was sought against the defendant who sold on the internet health supplements through a website opened under the domain name of viagra.co.kr, the court ruled that by using a similar mark to a famous mark, the plaintiff had damaged the functionality of the source indication of the product mark. The Korean Unfair Competition Prevention Act regulates as an act of unfair competition under Article 2, Clause 1d, acts of misleading the place of origin, and in the same clause, paragraph F, the passing off of product quality-related misleading acts and acts misleading the place of origin. However, concerning acts on misleading a source, both direct false indications of the product and the indirect and suggestive marks concerning the product are regulated as well. In the case of false mark, place of origin, it is not constrained to the place of origin of finished products alone, but the concept includes falsely marking the place of origin of the raw materials of the product as well. And for acts, yes, that is all.
네. 네 번째 질문도 약간 포괄적인.
Section 4 has quite a broad question about the act of copying product configuration. We will look at this question in two parts. So first, requirements and cases on dead copy will be the first part with 4-minute responses. And please try to keep to the time. Thank you. Let's first look at the requirements for dead copy for 4 minutes, starting from Professor Bernstein.
So let me start with the requirements, and we've touched on the functionality point as well, but when we're talking about product configuration, a key requirement in the United States is that you prove that it is not functional. This does go a little bit to the well-knownness or reputation point that we were touching on before, because when it comes to a traditional trademark, a word mark, or a logo, they can be inherently distinctive. But when it comes to product configuration, our court recognizes that those are never inherently distinctive. You need to show that there's an element of secondary meaning, that people recognize it as being source identifying. And we actually will talk a bit more about that in the third section later this afternoon. So I'll skip on that just for now, and we'll circle back to that when we talk about distinctiveness of trademarks later today. But with product configuration, the other thing that we need to be very careful about is functionality, which has already been mentioned. And this case, the Traffic's design case, was one in our Supreme Court about 20 years ago, which was a very important case in this area. And we've all known for quite some time that if something is functional, we should be protecting that under the patent system, not through the trademark system. And so we exclude trademark rights for elements that are functional. This case dealt with a road sign, which had this unique double spring mechanism at the bottom, and I've shown a close-up photo of that double spring, and they had a utility patent on that. So during the then 18 years of its utility patent protection, they also, of course, built up a trade dress. People in the industry of road signs, of highways, recognized that if it looked like that with that double spring, it must come from traffics. Well, when the patent expired, someone else started making those same designs to have a sign that would be able to blow in the wind and not blow over. And of course, traffic sued, relying on their trade dress rights. But the Supreme Court said, because you had a utility patent, there's a presumption that it was functional, and therefore that's not something that you'd be able to protect. Very briefly, I want to talk about two other functionality cases which touch upon products that are well known here in Korea. So one is the Pocky line of chocolate-dipped biscuits, and Lot, since we're in a Lot hotel, I thought it would be inappropriate to talk about this, has their own version of this kind of a biscuit or a candy. And the makers of Pocky, Azaki Glico, brought a trade dress action. But the court ruled that it was functional, that because the way the product is partially dipped in chocolate, it allowed you to hold the biscuit in your hand without getting chocolate on your hand. And therefore, because it was functional, even though they had a registered trademark in the United States, the court found that it was not a protectable trade dress, and they allowed the Lot product to be sold. And I think everyone knows the very famous Apple and Samsung case, so I won't take more time to talk about that, other than to say that the design of the icons was found to be functional from a perspective of trade dress law, and the shape of the phone, the rounded edges so it doesn't tear your pocket when you put it in your pocket, for example. But quite unusually, Apple was able to succeed under design patent law. And I actually think that suggests that there's a real disconnect in the way that we think about design rights in the United States and trade dress rights, something that the Academy is very focused on. I think we lawyers and judges need to get focused on that as well.
멜러 판사님.
Well, you'll see from your reference book that when talking about UK law in this area, I've said twice that the position is complicated. Why is it complicated? Well, two reasons. One is related to functionality that David just mentioned, and the other is Brexit. So functionality, need to wind back a little bit more. Under the Copyright Act 1956, people started to use copyright to protect purely functional items. In other words, a simple nut, bolt, washer, components like that. They were being given copyright protection, which is life of the author plus 50 in those days, 50 years. Plus, under the Copyright Act 1956, we had a thing called conversion damages. What that meant was, if the defendant's product was an infringement of the claimant's work, that product belonged to the claimant, which meant you didn't just get loss of profits, you got the entire defendant's turnover in the product. So, due to those excesses in the new Copyright Act, which was passed in 1988, what they did was they continued registered design right. They introduced an unregistered design right, giving a maximum protection of 15 years. And then copyright was drastically cut down for functional items by a combination of sections 51 and 52. So far, so good. Then we have harmonization of copyright law, or at least it started from the EU. And the CJU managed to decide that our sections 51 and 52 were contrary to EU law. So then, this is more recent, but we had to start reversing the process of cutting down protection of functional items. Now, the The second complication is Brexit, of course. And we have retained in UK law all of the design protection that was afforded under EU law. So now we have 5 different forms of protection. We've got UK registered design right. We've got community registered design. We've got UK unregistered design right. And we've got community unregistered design, as well as a 5th version. So we've got a fairly crazy situation in the UK at the moment. And indeed, there is quite a significant push to simplify design law, certainly in the UK.
네, 프레스 변호사님.
I'm always pushing too much on the button. Sorry for that. Yeah, actually, we have the comparable situation in Germany. We are also, as EU design law applies in, or EU design regulation applies in Germany, we have registered designs as well as non-registered designs, and the German courts are taking up the Cofemel judgments and the Brompton judgments by the European Court of Justice. And there are several cases pending currently before German courts where copyright is to be used to provide protection for products. I'm a little bit skeptical about this because the scope, and in particular the time scope or the duration of this protection is quite long. In Germany, we have copyright protection for 70 years after the post-mortem auctores, so to say, and that gives that's a strong weapon actually. But I need to get back to the requirements of the German system, because speaking about protection of products under German unfair competition law also raises this question of functionality. And obviously, different from the US, if a product would be covered or has been covered by a patent or by a utility model, it wouldn't be a problem for a German court to find that a imitation product, that the original product can be protected under Section 4, number 3. The German court would then just ask, is this technical issue in this product so crucial that you can't make the same product without using this technical issue? And here I have another picture of these, I don't know the English word for this, Gartenliege? This
lounge chair.
Yeah, right, sorry. Thanks, gentlemen. This was quite a famous case in Germany, also decided by the Supreme Court for this lounge chair, or this, it's a garden chair actually. It was for some reason protected by a patent for 20 years, and then was able to obtain protection under Section 4, number 3 of the German Unfair Competition Act, because the functionality which was covered by the patent could be was not so crucial for the form, for the design, and for the get-up of this lounge garden or lounge chair. And the lounge chair was so successful in the market that even the argument which was brought by the defendant that the claimant could be successful only because of the patent, that this argument did not succeed. So functionality is not a strong weapon actually in German unfair competition cases. Thank you.
다무라 교수님 부탁합니다.
Thank you.
Professor Damura.
Yep. So in Japan, the Unfair Competition Prevention Act Article 213 actually regulates explicitly slavish imitation or dead copy of product shape. And this codification was introduced in, again, 1993, and actually based on my proposal to secure lead time advantage, which functions as one of major incentives for innovations. However, when I advocated this new legislation, I referred to several European laws, including UK Unregistered Design Right of 1988, which has just been introduced, and also the Section 5C of the Swiss Unfair Competition Act, which regulates the so-called direct copying. And also, theoretically, I referred to a theory of market-oriented approach for US software protection as of those days in 1980s, like which was advocated by the Professor Kaja or Professor Samuelson, Pamela Samuelson. And these theories, or this theory, found a reason to regulate the act of imitation of computer programs in securing for market lead time. And these are the requirements of Unfair Competition Prevention Act, Article 213, and imitation is a key issue. And imitation is defined in the UCPA Article 215, and which says imitation is to make the shape of goods substantially similar to that of others. And the term of protection of this Article 213 is very short, just 3 years after the first sale. And the creative value is not required at all. Because regulation just covers substantially similar goods for only 3 years. And the courts will be not so qualified as patent office to evaluate the creative value. And slavish imitators do that because they feel there exists values worth imitating. So probably in 99% of the cases there would be some value. And subjective purposes of imitators are not required because real-time advantage would be harmed even without subjective purposes. Thank you.
Now moving on to Judge Lee Ji-young. Yes, under the UFC Act, Article 2, dead copy is banned. And as for the requirement, copying the shape of goods is applicable. As Professor Tamura said, also in Korea, the shapes that have been created within 3 years are subject to the protection, and goods with general shape is not protected. So the shape is not necessarily in question. It only protects tangible things and does not apply to abstract ideas. Also, it has to be subject to be traded independently. And the Supreme Court ruled that consistent generality is required. When it comes to the degree of copying, it has to be a dead copy, which is a perfect copying and making almost the equivalent of the original. And whether it refers to dead copy or not, the following factors are comprehensively taken into consideration. If I explain cases, I think it will be more evident. There aren't that many dead copy cases, so I am just going to touch upon the most major cases in Korea. The lace dress seems to have been perfectly copied, but if you look at the motifs, the flower motifs and the patterns, they are almost the same, and the cuffs and the neckline have all been copied, so that copy was recognized. And as for the chiffonier, the overall structure is the same. Maybe the ventilation area number is different. This is a soft tree case which is interesting. The transparent plastic cup has ice cream inside, and the bee honeycomb is put on top. This is the soft tree product. The idea was the same in the defendant's product, but in order to be eligible for dead copy, it has to be consistent general element. But every time the staff or employee makes this product, the exact shape of the ice cream would differ, so it was not a dead copy. Thank you.
So imitation of copying of the product configuration, the scope is quite expensive. Why don't we talk about the configuration usually seen or the duration of the production? So we'll give you 3 more minutes. We'll start with Mr. Bernstein from the United States.
Thank you. So it's quite interesting because the U.S. law is very different in this respect as well. We would never protect a lace dress or ice cream like that, even if it was a dead copy, unless there were trademark rights to begin with, unless the design of the dress itself was seen as source identifying, as opposed to just being a beautiful lace dress. And so when I think about this question, we always have to start from the perspective that you still need trademark rights at the inception. And I come back to that list of some of the elements I began my talk with, because they really help inform this question of, well, what kind of copying is enough? So we look at how weak is the trademark or how strong is the trademark. That lace dress or the configuration of the way the ice cream is served, that would generally not be seen as something that's source identifying in the United States. And so even a so-called dead copy, we don't use that term in the US, but even a dead copy would not be seen as a violation. The fashion industry is very upset about this. There's no protection under copyright law for something like that, and there's no protection under trademark law. And so in the US, some people think there's a gap in the law. Although in academic circles, we think it's actually quite appropriate, that not everything should be protected. And it brings me back to the very functionality discussion we were having before, which is to say, if an element of a product, if its design, if its configuration, is designed that way to make it work better, or because it's cheaper to make it, then those are things that, for fair competition, should be allowed. And so we generally would not extend our law to that. The last point I'd make here is, if there is exact copying, sometimes some courts will say, oh, there's a presumption that if you copied it, you intended to cause confusion. But I believe that that's too broad a statement. You have to look and say, well, why are they copying? If they're copying something for the purpose of confusing consumers, then a presumption might be appropriate. That might be the kind of bad faith that would support a presumption that there's infringement here. But if they're copying it because it's just an effective way to make, let's say, this candy product, because if you dipped it with chocolate all the way, you'd get chocolate on your hands. And the way the sticks are designed, you can fit a certain number of them in the box, or the design of a telephone. If you've designed it that way to make it work better, then we're not generally going to protect it, at least under U.S. legal principles.
네, 빌라판타님. 버튼.
Thank you. Please press your button.
Let's continue with the lace dress. So under UK law, that would be protected by copyright of a drawing of the dress. It could be protected if they'd registered as a design, and it would also be protected by unregistered design right. Now let's go back to the complications and the 5 different forms of protection that I mentioned earlier. Generally, registered design provides a monopoly right. In other words, you don't need to prove copying. For all the other forms of design protection, you do need to prove copying. And the lace dress, although it differed in immaterial details, and that's the best translation I have of Sasha's phrase that he mentioned earlier, although it approaches it from a slightly different angle. But if it differs only in immaterial details, then it will be an infringement. I think that's probably all I need to say.
So then let me also say some words to the lay stress, because we have the same situation in Germany. This would be, as far as I can see the pictures here, this would be a clear-cut infringement of a non-registered right, which is very limited in time. So the German law provides for 3 years once it is publicated, or once the design is published, or the dress is came to the market. So it is quite limited, and I think the German court would possibly also apply or at least discuss copyright, but it depends what has been existing before, of course. The German courts has nevertheless, or the German Supreme Court has a couple of years ago expressly carved out protection for trade dresses under unfair competition. It was formerly like a way of getting protection for fashion stuff, to bring claims under unfair competition under Section 4, Number 3, or the prior provisions. But the German Supreme Court expressly stated, no, since we have this non-registered design rights, there's no need for protection anymore. I want to mention just one aspect, which is also crucial from a German perspective, because the unfair competition, or the protection under the German Unfair Competition Act for products as such, or for the get-up of a product, is not limited in time. So as long as the consumer is aware of the, let's say, reputation, or of the has an idea about the product, and may think, or may be confused about the origin of the product, as long as this situation exists, there may be a claim. So there were cases before the German Supreme Court, or for the German higher regional courts, where products has not been on the market anymore, but as they were so famous before, they could still bring in claims under unfair competition against imitation products. So this is also an aspect which is to be discussed under German law. Thanks again.
네, 다무라 교수님 부탁합니다.
Professor Damura.
Thank you. So I'd like to talk about the limitation of UCPA, say Article 213. So the shape of goods under this article needs to be entirely imitated. So partial imitation is not enough. So if partial imitation were to be regulated, the scope of protection could become so broad that justification for not reviewing creative values would be lost. However, if the part of a plaintiff's entire goods, such as mirror in the bike, can be marketable by itself, I advocate the theory that then that part itself is to be considered as an entire goods and becomes eligible for protection. And this theory was adopted by the several court decisions, including this Tokyo District Court in 2005 in manhole steps. And just note, a part of goods can be protected as trade dress under UCPA Article 211 if it is well known. And second limitations of UCPA Article 213 I would like to talk about is that shape of goods needs to be concretized enough to be marketable. So abstract ideas or concepts of goods cannot be protected. And because, again, it's to avoid too broad protection that could not be justified without reviewing the creative values. Okay, thank you very much.
네, 이지영 부장님.
Yes, the lace dress, I think, became the most exemplary case in Korea. it drew a lot of attention. I'd like to add a couple points. The dead copy provision is for products with a short life cycle. So the term of protection is 3 years since the creation of the design and after the shape, and afterwards the protection is no longer valid. And let's move on to another case. It's the iPhone 5 holder case. The design was copied, but 3 years has passed, so the plaintiff's claim was rejected. And here, a woman's suit case, this shows a dead copy, but 3 years have elapsed, so protection was not applied. So to exercise rights for a long time, it should be registered. If it's not registered, then the term of protection is very short. So I guess this is to encourage rights to be registered and to protect free competition and to prevent monopoly. Counterfeiting the common shape of goods is not protected. So that is the proviso that you can see in the article of our Unfair Competition Act. Then what constitutes a common shape of goods? This is a controversial question, and the Supreme Court rules as you can see on the slide when it comes to the definition of the common shape. Let's look at some cases. The Louis Vuitton bag case. It is very popular in Korea, and you can see the defendant almost copied it perfectly. And the defendant claimed this is a common shape of goods, and it was rejected. And the wrap dress case, the defendant copied the metallic material wrap dress of the plaintiff, and the sleeveless T-shirt was copied in the case on the right. And the defendant said that, this is a very common design that is widely known from the DVF design. And the sleeveless dress, the defendant said this is the only way we can make a sleeveless dress, but the defendant's argument was not accepted. And this is the couch case. The defendant once again said that such design is the only way, the essential part of the design for such couches, but that was once again rejected. And this is another Supreme Court case about handy fire extinguisher. It was recognized as a copy, but the Supreme Court ruled that this is, in fact, a common shape that is required for such extinguisher, and it does not apply as an unfair act. And this is a car tent. The defendants claim that this is a common shape, and the Court of First Instance said it is, in fact, a common shape, and the plaintiff's claims were rejected.
We'll go over to the next question. This is on the act of using outcomes without lawful authority. So in the case of Korea, we do have a separate regulation on this. In the case of other countries, I do believe there are countries without any corresponding regulation on this point. So in those cases, if you don't have such measures, you can, I think, talk about the legal principles. In the same order, you'll be given 2 minutes each. So Mr. Bernstein, you go first.
Thank you. So hearing you talk about the dead copy, I think that highlights why we don't have the same protection, and we also don't have this protection of using outcomes without lawful authority. And the reason is that if we protect a design like that under trademark law, the trademark could last forever. There's no limited time. And even under our design patent system, you would get 20 years, which is a very long time. And so it's an area of the law that we don't protect in the same way, which is why, to encourage fair competition and discourage monopoly, it's just not an area of law that we protect in the US. And similarly, we don't have in the United States any kind of an analog to this idea of using outcomes without lawful authority. And there was one Supreme Court case that had struck me as on point. It was a copyright case involving someone who had a directory, and someone else just copied that whole directory. And the claim of the plaintiff was, I went to so much effort to put this directory together, but it was just a compilation of facts. And so the Supreme Court said, look, you don't get protection under US law for effort. You only get protection if you've actually created something that fits within one of our frameworks, whether it's copyright, trademark, or patent. The one area where there's a little bit of an analog, I'd say, brings us right back to the very beginning of this session on unfair competition, which is if you've copied someone's trade secret, if there's a misappropriation of trade secret, or if you've interfered with someone's business in an unfair way, then we could find that there's been a different violation that wouldn't be under a trademark remedy, it would be under one of these more general state law unfair competition remedies.
Switched it off again. There we go. Yeah, use of outcomes without lawful authority. We don't have anything, any specific provision, but the law of passing off has shown itself to be adaptable. And I'll illustrate that with 3 cases. The first one is BT against 1 in a million. You may recognize this case because it was all about merely registering a domain name. So the domain names in issue were of famous brands in the UK, marksandspencers.com, vodafone.com, and there were 1 or 2 others as well. So the judge at first instance said, merely registering a domain name and not using it is not an act of passing off. Unfortunately, the Court of Appeal agreed that passing off should extend to that. The second case I mention in the materials is the Eddie Irvine case. He was a Formula One driver, and a radio station in London called Talk Radio published a leaflet with Eddie Irvine with a radio to his ear, and there was a label on the radio saying Talk Radio. So that was a case of false endorsement, and Eddie Irvine succeeded in that. The third case I'd mention is Alan Clark against the Evening Standard. Alan Clark was quite a controversial MP in the UK. And what the Evening Standard did was they started publishing a column called Alan Clark's Secret Diary by Peter Bradshaw, who's the guy who wrote it. And, you know, the idea of a secret diary being published in a daily newspaper, you'd think they'd get the joke. And it was a very funny diary. Unfortunately, the judge lost his sense of humor in that case, and it was held to be passing off, and also false attribution of authorship. So I was acting for the Evening Standard, so that's one of the scars that I bear.
Well, in Germany, we don't have such a principle of law either. I would possibly compare it at least with one general provision, which can be found in the German Act of Unfair Competition. There's a provision in Section 3, Para 1, which works as a general clause if a commercial practice is to be held unfair, and there are only a few cases where the Supreme Court applies this principle and factually grants protection for not products but for things which were successful in the market. So I'm remembering one case where a big database which was not able to be protected under copyright law, which also protects databases, could be protected or was protected against imitation under this general principle. But actually, this is one of the only cases which fits in this framework from a German perspective.
네, 다무라 교수님 부탁합니다.
Professor Tamura, please.
Thank you. So we, Japan, again, don't have the comparable regulation, and also neither do we have the general clause in the Unfair Competition Prevention Act. However, I'm sorry. Therefore, if it is not specifically codified, protection under Unfair Competition Prevention Act cannot be obtained. However, there is a slight, if I may say so, a possibility resorting to remedy of torts of General Civil Code, Article 719. And the Civil Code in Japan, Article 709 says, a person that has intentionally or negligently infringed the rights of or legally protected interests of another person is liable to compensate for damages resulting in consequence, and remedies damages only, no injunctions at all. And here, a few cases acknowledged damages under this Civil Code, Article 709, against exploiting results of others' endeavors. So the Tokyo High Court in 1991, in the wood grain pattern decorative paper case, ruled that photocopying competitors' blah, blah, blah paper and selling it cheaply was liable under Civil Code Article 709 before the introduction of regulation against the dead copy of Unfair Competition Prevention Act Article 213. And Tokyo District Court in 2001 in the Super Frontman case, in that case, a comprehensive database of automobile parts that is not eligible for copyright protection was protected against substantial copy under Civil Code Article 709. But however, here comes the Supreme Court decision in 2011 in the Super News case. And this court decision denied Civil Code 709 remedy for a work of a North Korean legal person, which was considered uncopyrighted due to the court's interpretation of Berne Treaty. And it says, an act of exploiting a work that does not constitute a copyrighted work under Copyright Act, it's not to be considered as illegal torts, unless there are exceptional circumstances that will infringe other interests than that of the exploitation of a copyrighted work. Therefore, if specific IP legislation regulates requirements and scopes of protection, the court's intervention under Civil Act or Civil Code Article 709 should be restrained, because such intervention by courts would definitely compromise the purpose of the legislation. However, if there are no related specific IP regulations, and this is my theory, and if it is clear enough for the court that allowing the alleged infringer's exploitation would lead to underinvestment for innovation, the intervention should be justified. But the court would recognize such type of the remedy even after that Supreme Court case, actually, which has to be seen, which has yet to be seen. Thank you.
예, 데드카피의 경우에는 아까 말씀드린 것처럼 요건이 엄격하기 때문에
In the case of dead copy, the requirements are very strict. But, however, acts that infringe upon the economic interest of others by unauthorized use of the outcome produced through substantial investment and effort of another person in Korea in the past deemed such acts as a general tort under the Civil Code, but through the revision in 2013 of the Act on Prevention of Unfair Competition, it is regulated as a type of unfair competition. This is how the unauthorized use of others' outcome is seen as unfair competition. And so you see the actual provision here. However, paragraph 1 is being strictly applied as a supplemental provision, as can be seen in the Supreme Court decision. And so only when other provisions do not apply can you apply this paragraph 1 according to Supreme Court decisions. The requirements are as follows. The key is unauthorized use of the outcome of others. Here, outcome is of utmost importance. So these outcome includes both intangible and tangible assets, but it must not belong to the public domain. It has to be strictly applied, and so that is why such regulation is in place. There are many different cases. Most of the unfair competition acts there are some outcome-related cases that were recognized by the Court of Korea. So this was a case where a golf zone was involved. The plaintiffs had this golf range, and the same image was misappropriated by the defendant, and this was used as a screen image of the defendant's business, and then so the overall image does indeed constitute an outcome according to court. And another case involves the Birkin bag of Hermes. So the very same shaped cartoon is used, but it's not exactly identical, so it's not a dead copy. However, the efforts made by Hermes and their investment has led to this outcome, and this outcome was deemed to have been misappropriated as well. And likewise, the Limoire luggage bag. And the defendant used this very shape to create a cell phone case. It's not identical imitation. However, this also constitutes unauthorized use in it, so it was deemed as an uncompetitive act. And here, the sign and the interior decoration was very similar to the original store. So the atmosphere, the getup of the store was recognized as outcome. And in this case, this is a very famous barbecue rib restaurant. And you can see that the signboards are almost the same as the original. And this is the fry pan on which you would, the grill which you would use to cook the ribs. And then these are side dishes, and they were imitated as it was in the original. And so this was also seen as an outcome that was misappropriated. Recently, a very interesting case came out without the permission from the agency of BTS. The defendants used the photos of BTS members, and they created a photo collection, and they sold it. And so the Supreme Court ruled that the effort and the investment was what enabled this outcome to be produced, and that this outcome was deemed to have been the subject of unauthorized use. And there was a restaurant, and the menu composition of this Mexican restaurant was very similar, but there was a court ruling that said, this is a common usage of the menus, and you can't really regard it as unauthorized use. And in this case, this was a pumping case, and the defendant used the pumping instrument of the plaintiff, and even the marketing methods were claimed to have been used. But the court ruled that this pumping method was commonly well known, and you can't really deem this as an outcome. That is all.
Now we will move on to section 6, which is about publicity and remedies. For this question, let's start with Korea. There is no regulation in Korea, and it is not really recognized, but it is widely recognized abroad, and it is a hot topic for discussion as far as I know. So let's start with Professor Bernstein on this topic.
Excellent. So to talk about right of publicity, I chose another case that has a Korean connection. This involves a Samsung advertisement for a VCR machine. Now, it tells you how old this case is. That what the case says is it shows a picture of someone who looks like she's on a television show called Wheel of Fortune. There was a very famous show in America where you would guess letters and you would turn them around if you guessed them. And it says, this is going to be the longest running TV show in 2012, which was far in the future, way back in the past. And then underneath it said the VCR that you'll watch it on, and it was a Samsung VCR. Of course, VCRs are completely obsolete now, so no one watches anything on a VCR. But the woman who was actually the actress on this television show, Vanna White, sued for violation of her right of publicity, and actually, under the law of California, she lost the case under the statute, but she won the case under the common law of California. And this gets back to a point that James made before, which is a lot of our law in this area is very much judge-made. And the idea that there'd be a common law under the state of right of publicity is something that is a bit controversial in the United States, because it is quite a new right compared to the ancient trademark rights that go back to the 1500s or 1600s in the United Kingdom. So this is just an example, I think somewhat of an extreme one, because that robot doesn't really look like her, except for the fact that she appears on the set design, and yet she had no trademark rights in the set design. And there was a very powerful dissent from Judge Kaczynski making the point that if anybody had rights here, it was the owner of the show, not Vanna White, because she doesn't have the right to, for example, wear a red dress. There's so little time to talk about remedies, so I just put in the materials some slides that will reference the types of remedies that are available under US law for trademark infringement. It's very broad. Courts have a lot of discretion. Of course, you can get injunctive relief. Our Supreme Court has set forth these 4 standards that are important if you're going to consider injunctive relief. You can have items seized and destroyed. Trademark registrations can be canceled if they were inappropriately issued. And of course, there are monetary damages available as well. So you can get compensated for the harm to you. In appropriate cases, you might actually be able to force the defendant to disgorge the defendant's profits. For counterfeiting, we have treble damages to create sort of a disincentive on counterfeiting. We have some other opportunities for damages as well, but I'll refer you to the materials in the book for more detail on those remedies.
Like David, I'll be brief due to the lack of time. In the UK, most IP cases are decided in 2 phases. So we decide liability first, and then if the claimant wins on liability, then damages are done separately. What that means is that once a defendant has lost on liability, they tend to lose the will to fight. And so there are very few damages decisions in the UK, because after a defendant has lost on liability, they usually settle. However, I will mention one example, which again derives from the Eddie Irvine case. Now, at first instance, Mr. Justice Laddie awarded Eddie Irvine £2,000 in damages. And there was evidence in that case about the sort of fees that a Formula One driver could command in order to sponsor a product or endorse a product. And Eddie Irvine took this case to the Court of Appeal, and there's an infamous submission that was made on the basis of this evidence that Mr. Irvine wouldn't get out of bed for less than £50,000. So the Court of Appeal didn't award him £50,000, they awarded him £25,000. Rights of publicity. There is a right to have a successful judgment published. It depends on the circumstances. So, for example, in the Samsung and Apple litigation, because Apple had advertised their infringement claims so much against Samsung, when the case was lost by Apple in the Court of Appeal, the Court of Appeal ordered Apple to make reference to the fact that the claim had been brought and they'd lost it. So it depends on what the publicity before the case is tried has been, and whether there is a need to publicize the result.
The situation in respect of remedies are pretty much the same in Germany as in the UK, because we formally rely on the same directive, namely the Enforcement Directive, which sets the remedies in respect of damages, claim on information, the publication of the decision, etc. So the Enforcement Directive is applicable to all IP rights, and for unfair competition, the German legislator has put in at least damages for at least claims for injunctive relief, damages, as well as information into the German Act on Unfair Competition. Actually, we also have the same situation, or the same situation in Germany when it comes to damages. Most of the cases, most of the IP cases, not only unfair competition, but also the strict IP cases are decided mainly in preliminary injunction proceedings. So the German courts are quite quick. It's not an issue actually to get an if you have a EU trademark or an EU design, you can get quite quick an EU-wide injunction within, let's say, 1 or 2 weeks from the court, which then puts the other party pretty much under pressure intenses, let's say, let me put it like this, intenses the negotiation efforts of the parties very much. Coming to the right of publicity, also this is regulated in Germany by the so-called Art Copyright Act. This is a very old act from, I think, from the 20s already, and the German legislator just put this in place again after the Second World War, and it has it established a right for the likeness of a person or of its picture, and the right of publicity is also protected under German constitutional law, and the German courts combine these rights resulting from the constitutional law with German tort law to form claims against usage of your likeness or of your picture, let's say in advertisings, or I think this case which David referred to would have been done also under German publicity right.
네, 다무라 교수님, 오네가이시마스.
Professor Damura, you're on the floor.
Thank you. So about the right of publicity, we don't have any specific legislation. However, lower instance courts started recognizing this right since 1970s, and remedies are injunction and damages. And Supreme Court in 2012 in the Pink Lady case acknowledged rights of publicity as a kind of Persönlichkeitsrecht. I'm very sorry to that I cannot pronounce it German correctly. And requirements about the requirements and case law. Infringement of rights of publicity has been typically recognized in the case of, first, commercialization of a portrait or a name, such as character goods or photo books. And second, exploitation of a portrait or a name as identification of goods or services. Third, exploitation of a portrait or a name for advertisement. And the problem is, if and when pictures in magazines infringe right of publicity, and which has been debated for a quite long time. And the Supreme Court in the Pink Lady case denied the protection in black and white photos in an article of a magazine, but however, recently, several cases in lower instances recognized infringements of this right of publicity when pictures of someone's portrait were used in the magazines with no or very short of additional sentences. Thank you.
As for Korea, there is no legal regulation that protects publicity rights. Sometimes it was recognized at the court of first trial, but in fact, portrait of subjects are protected as a moral right, and compensations were paid. This is a well-known case in Korea. This is a picture of a very famous child actor in Korea. And the defendant used his picture to advertise his acting school to mislead people to think that this actor was trained at their academy, and the parents sued the defendant and claimed damages. But the court did not recognize the publicity right. However, did rule that compensation should be made for the violation of name and portrait right. And going back to the BTS case, this was recognized as exploitation of outcome under the Unfair Competition Protection Act of Korea. And last year in 2021, finally, this was included under the UCP Act. It might be a little different from what is in practice in the Western countries, but still, the damages were recognized. Thank you. Thank you for all of your rich answers about the precedents. This closes our discussion for the 6 sections of this session. I would like to thank all of our panels for their very enlightening explanation by joining us today despite their busy schedules. In the reference book, we have the very insightful and detailed responses submitted from our panels, so please refer to them. And do we have any questions from the floor? In fact, we used up all the time allotted for the session, so I believe we would have to close the session. I would like to once again thank our panels for all of the insights that they have shared with us.
Thank you, everyone. This ends the session 2. Let's give a big round of applause to the moderator and speaker of this session. Panelists will take a photo on the stage. 사진 찍게 포즈 좀 찍어주십시오. 4시까지 휴식 시간을 갖겠습니다. Ladies and gentlemen, we'll begin in a few minutes. All participants, please come in and be seated. The topics of third session are key issues in trademark cases dealing with descriptive mark, distinctiveness through use, trademark survey evidence. I am delighted to present the session's moderator, Honorable High Court Judge Hyung-gun Lee of Patent Korea. 3세션 주제는 상표권의 주요 쟁점으로서 기술적 표장, 사용에 의한 식별력, 설문조사의 활용에 대해 다룹니다. 진행은 이형근 특허법원 고법판사님께서 맡아주시겠습니다. Please join me in welcoming him. 큰 박수 부탁드립니다.
Good afternoon. I am Lee Hyung-gun, judge at the Patent Court. During this session, we will discuss about descriptive mark acquisition and of distinctiveness through use and the use of survey. I will introduce our panels. Please refer to the reference book for their detailed CV. We first have Attorney David H. Bernstein from the U.S., who is an adjunct professor at New York University and a trademark lawyer. And we have Judge James Miller from the High Court of Wales, England, of the UK. And we have Judge Kumiko Katsumata from the Intellectual Property High Court of Japan. Next, we have with us online Judge Hui Su from China. Thank you, welcome. And we have Judge Christian Schmaltz with us through the video recorded presentation due to a schedule conflict. Now we have Judge Young-gi Kim from the Patent Court High Court. And we have Judge Kwon Bo-won from the Hongsong branch of Daejeon District Court. Now we will dive into the first topic, which is descriptive marks. Based on the material that you have prepared, we will hear presentations from the panels, and Judge Kim Hyung-gi will pose questions to individual panels. Please keep your responses to the time, 5 minutes, and response to the questions to 2 minutes. Let's start with Attorney Bernstein.
Excellent. So it's good to be back. And as I mentioned earlier this afternoon, we're going to focus on some of the issues that come up with distinctive trademarks and descriptive trademarks. So we'll start by looking at descriptive marks. So in the United States, we would say that a trademark is descriptive if it immediately communicates something about the goods or the services. This is from the Trademark Manual of Examining Procedure, which is the document used by the United States Patent and Trademark Office to educate the trademark examiners on what they should be looking for. So in the context of applying for a trademark, the Trademark Office will look at this unique, this document to see, does the trademark itself immediately tell you something about the goods? And one of the common tests that we use is known as the imagination test. The question is, how much do you have to imagine something that goes beyond just the mere words of the mark? If you use, for example, the term apple, obviously for the fruit, it would be generic. There's no imagination at all. If you're thinking about it for computers or for music, because the Beatles' music company was called Apple Music, there there's no amount of imagination that you would need, because it just is completely fanciful or arbitrary compared to those goods. The really hard distinction is between suggestive marks and descriptive marks. And in the United States, we use a spectrum, and I'll be quite curious to hear how similar the laws are in other parts of the world. So the very strongest trademarks in the United States system are arbitrary or fanciful marks. So, for example, the word Apple has nothing at all to do with computers, and therefore that would be arbitrary. And the word Kodak is a completely made-up word. And so these are the strongest trademarks that we have in the United States system. Just below that are marks that we think of as suggestive. Here, it does take some imagination to understand what's at issue. So, for example, we have a brand of tuna fish in the United States called chicken of the sea. So there's no chicken that lives in the ocean. So you really have to imagine what might that be for you to understand, oh, maybe it's tuna fish. So that still is, it's suggestive. It doesn't describe tuna fish. But if you think about it, if you apply some imagination, you can understand, oh, I guess this is a white meat that comes from the ocean. Similarly, we have a brand of suntan oil or sunblock called Coppertone. And you can see the famous image from their advertising of the little girl with the dog pulling down her bathing suit. This is probably not politically correct anymore today, but this was their classic logo for many years. And the idea was that if you use Coppertone, it will give your skin a nice copper tone. Again, it doesn't immediately describe anything about the sunblock. You really have to use some imagination to see, oh, what does this have to do with sunblock? When we move to descriptive trademarks, now we get into the area where the trademarks really describe something about the goods or the services. So there's a very famous brand of mayonnaise in the United States called Best Foods. That's just a laudatory trademark. That's something that we would consider descriptive in the United States. Vitamin water. It's a water beverage that's flavored and includes vitamins and minerals in it. That's a descriptive trademark because it tells you something immediately about the goods or services. It doesn't take a lot of imagination to wonder what vitamin water might be. Even my law firm name, Debevoise and Plimpton, it was based on the names of the two founders of our law firm, Eli Whitney Debevoise and Francis Plimpton. And so people's surnames can never be inherently distinctive. They're always descriptive. It's descriptive of a law firm founded by Mr. Debevoise and Mr. Plimpton. At the very end, of course, we have generic terms. Terms like apple for the fruit or facial tissue for a brand that some people think of as Kleenex. The key thing about this is that if a trademark is arbitrary or fanciful or suggestive, under the US system, it's inherently distinctive. It's automatically protectable. You don't need any secondary meaning at all. We'll talk about how that works with product configuration in a little bit, but I'll start by saying if you can get up to being suggestive, you're going to have trademark rights right away. But if your trademark is descriptive, then you need to show some secondary meaning in order for it to be protected. Happily, our law firm is very well known now as Debevoise and Plimpton. It's not just some law firm that was founded by a Debevoise person and a Plimpton, but it's actually a unique law firm. Vitamin water has become a very well-known brand. Even though it is a water product that has vitamins, today it's very well known. And of course, with a generic mark, it can never be protected. So those are the key ways that we look at descriptive marks and how we can try to distinguish them from a generic term and from a term that's inherently distinctive. And I will talk a little later about how survey evidence can help make the distinction of whether a mark is descriptive or suggestive, whether it has secondary meaning. And a lot of those issues came up in the famous Booking.com case that I litigated at the Supreme Court. But we'll turn to those survey questions a little later this afternoon.
네, 제임스 멜러 판사님.
Moving on, Judge Meller.
There we go.
So why are we so worried about descriptive marks? Well, there are two main reasons. One is because a descriptive mark simply doesn't act as a trademark should. It doesn't perform the essential function of a trademark. The second reason is much more practical, because if you give a large corporation a descriptive trademark, they can then use that as a weapon against smaller traders. And often the smaller trader can't afford to fight a big corporation. And as an example, I'll mention one of the first cases on Article 7.1c, as it was, in the EU trademark regulation that came before the Court of Justice of the European Union. It was the mark baby dry for nappies, okay? Now, a full court, I think then it was about 9 or 12 judges, all elderly men, decided that baby dry was distinctive for nappies. And you can just imagine another trader saying, my nappy will keep your baby dry. Now, that is a perfectly descriptive use, but could the owner of the trademark go after that small trader? Well, possibly, possibly not. But could they afford to fight it? Anyway, this is a long way of saying that there are two aspects to descriptive marks. One is whether they get on the register at all, and I've set out in the booklet all the case law of the Court of Justice, and indeed what they've done over a series of cases is to lay down very similar rules to that David talked about from the US, so that in EU law, I suppose the descriptiveness has to be easily recognizable, and similarly, using some imagination, if the mark is elusive or suggestive, it's then properly registrable. But the other aspect that we have to consider is the defense, a defense to using a descriptive term. As long as you use it in accordance with honest practices, then even if a mark has got on the register, then you don't infringe, because, for example, if you say, my nappy will keep your baby dry, that's a perfectly innocent use in accordance with honest practices. So just like David, I always think about descriptive marks along the spectrum, because you do have the highly distinctive marks, you have the elusive and suggestive, and then there's this very difficult dividing line before you get to completely generic descriptive marks. And of course, I mean, Kodak is a very good example, because Kodak originates for a time when you could establish a mark, make it distinctive through lots of trading. And since then, the product cycle has got very much shorter, which is why so many corporations now like to try and adopt descriptive marks, because it gets the message across very quickly. And that's why when the new trademark directive was introduced in 1989, we had hundreds and hundreds of cases about non-distinctive descriptive marks coming through. And there were various respects in which the Court of First Instance of the Court of Justice went wrong and had to be corrected by the full court. So those are just some of the issues from a UK perspective about descriptive marks.
Yes, my name is Kumiko Kazumata. I'm a judge of Intellectual Property High Court of Japan, and thank you for inviting the conference. It's really my pleasure. And yes, let's start my presentation. And I'd like to see how the legislation of Japan defines. And Article 3, Paragraph 1 of Trademark Act defines what kind of marks cannot be registered. And let's see item 3. It says consists solely of a mark indicating in a common manner, in the case of goods, the place of origin, place of sale, quality, raw materials, efficacy, intended purpose, shape, the method of features, including time of production or use, quantity, price, or I omit the following, and it is thought the item 3 of the paragraph defines the descriptive mark. And descriptive mark may not be registered, and the examiner must render a decision to the effect that the application involving descriptive marks is to be refused, according to Article 15, Item 1 of Trademark Act. And the Supreme Court ruled in Waikiki case in 1978 that there are two grounds. One ground is public interest, and another one is lack of distinctiveness. And if the descriptive mark was inappropriately registered, what shall we do? At first, an interested person may file a request for a trial on the invalidation of the trademark registration. But there is a time limit. The request for trial can be filed within only 5 years of the date of registration. And second, in the litigation, an alleged infringer can assert invalidity defense. Next, I will explain how the court determines whether a certain mark is descriptive or not. The mark is deemed as descriptive when the consumers or traders of the designated goods or services generally recognize that the trademark describes the goods or services with which the trademark uses at the point of an examiner's decision or at the point of trial decision. And this condition relates to the lack of distinctiveness of the mark. And the court also takes into consider whether business operators want to use the said mark freely for the designated goods or services in the light of the public interest. When the mark merely suggests or indirectly describes the features of the goods or services, the mark is not descriptive. When the determine whether the mark is descriptive or only suggestive, the recognition of the consumers and traders is very important. For example, in Honnama case, the word Honnama does not have any meanings, describes the nature of goods according to the dictionaries, but the court found that Honnama is descriptive because the consumers understood that it means genuine and not pasteurized when it is used with alcohol. And by examining many articles and commercials in magazines and newspapers. And yes, with regard to 3D mark, in Japan, 3D mark is entitled to trademark right by itself. However, it is thought that if the 3D mark consists solely of a three-dimensional shape of goods or their packaging, which is indispensable for such goods or their packaging to properly function, it cannot be registered. And in addition to that, even when the shape is not indispensable, if the 3D shapes are within a scope where it is predictable that the product of the same type would adapt the same for reasons of functionality or aesthetics of the product, and there are no special circumstances to say the shapes are beyond the scope, that this 3D mark may not be registered. Thank you.
다음은 후이수 판사님께 발표를 부탁드리겠습니다.
Now, Judge Huisu.
판사님.
Judge Huisu, the floor is yours.
Hello, please wait a moment. There's something wrong with my PPT. Sorry. Okay, and good afternoon.
Good afternoon.
Good afternoon.
Sorry. 在哪点呢？
수판사님, 그 자료가 잘 띄워지지 않으면 우리 쪽에서
If you have difficulty
자료를
pulling
치우면
up the
어떻겠습니까?
PPT, we can help you out with that.
Can you see my screen? 이거吗？直接点一下吧。没有，这个。
It's connected.
Yes, you can proceed now. We can see your PPT well.
Okay, okay. I'm so sorry. And good afternoon, ladies and gentlemen. My name is Zhu Hui. I'm a Chief Judge from Hainan Free Trade Court Intellectual Property Court. First of all, allow me to thank you for inviting us to participate in the 2022 International IP Court Conference. I really appreciate this opportunity to communicate with participants from other countries on our specific practices in descriptive mark distinctiveness through use and trademark surveyed evidence. I believe that we can learn from each other and achieve greater progress. As to today's topic, I should say that China has already constructed a sound legal system in which judicial practices have been well implemented so far. As for descriptive mark, Article 11 of China's trademark law stipulates that the following sites should not be used as trademarks. Here is the whole article. And besides this, in the trademark examination and review guidelines, enumerates several common types of signs that do not possess distinctiveness. The above-mentioned marks lack the distinctiveness of a trademark because they directly indicate the common name, finger, or model of the goods used in the mark, or directly indicate the quality, raw material, function, use, weight, quantity, and other characteristics of the goods, or contain the name of a place, which usually cannot distinguish the source of the goods or services. Moreover, such marks are often used by producers and operators in the relevant industry to describe their goods or services, and should be used by the industry for common use, which is a public resource, and should not be allowed to be used exclusively by a single company.
Did you finish?
Not yet.
Sorry.
Are you finished with your response, Judge Huisu?
No, sorry. I will continue. And to determine whether a work mark is a descriptive term for a particular good, the court will usually need to consider the following factors. 1. The dictionary meaning of the term. 2. The actual use in which the term is used to describe the goods in question. 3. The ease with which the average consumer can associate the term with the attributes or characteristics of the goods in question. And 4. The necessity for competitors to use the term to describe the goods in question. In practice, there are several points that require special attention. 1. The term should be required to describe the attributes or characteristics of the goods to a certain level of commonness, generally based on the common understanding of the public of the particular goods. That's to say, the term should be a general expression of the attributes or characteristics of the goods. 2. The scope of descriptive marks should be limited to the goods or services for which the mark is actually used and should not be arbitrarily extended, as descriptive marks directly describe the characteristics of the goods for which they are used and lack distinctiveness. For example, just like Ms. Bernstein said just now, we think the word apple is a descriptive term for a fruit, but when associated with a mobile phone, it is distinctive and may be approved for registration. 3. If the applicant submits evidence that the term has been used for a long time, that consumers have actually associated it with a particular source, and that the term objectively served as a distinguishing function, then the mark can be registered and protected. In the following, I will use a case study to illustrate in detail that descriptive marks can also be granted registration by gaining distinctiveness through use. And also, I need to mention that according to Article 59, the trademark owner cannot prohibit the legitimate use of such marks by others. That's all. Thank you.
네, 발표 감사합니다. 다음은
Thank you very much for
대한민국
that
사례에
presentation.
관해서
Now, the Korean
고원
case will
판사님께서
be
영어로
presented
발표를
by Judge
하시겠습니다.
Gonbo-eun. She will be speaking in English.
Thank you. I'd like to begin with an episode concerning the Korean translation of the term descriptive mark. Descriptive mark is generally translated into 기술적 표장 in Korean, and the term, without further explanation, meanings like technical or technological directly comes up to ordinary Korean's mind. After seeing the poster for this conference, one of my colleagues asked me if this session was about technology. But 기술적 here means describing or narrative. Not all brands are created equal, but some brand names are inherently stronger than others. Borrowing the spectrum that David mentioned, we can assort some Korean brand names like this. From the bottom, generic terms like cafe latte for cafe latte cannot be trademarked. Although it might not make sense for non-Korean speakers, Hyundai in the name of the multinational automobile manufacturer means modern. So the name can be classified as a descriptive term in Korea, just like 제일 in CJ, meaning the first or the best. Suggestive marks evoke the consumer's imagination, and 참이슬, meaning pure dew or genuine dew for Korean distilled liquor soju, is a perfect example. The names of the two major Korean internet giants are good illustrations for the remaining two categories. Kakao, pronounced and written the same as can be said as an arbitrary mark. Meanwhile, naver is a coined term combining the words navigate and the suffix er. We can call it a fanciful mark. Some marks step up the hierarchy by Englishnizing or acronymizing the original name. For descriptive marks, I found out that this is very similar to that of Japan. Korean Trademark Act stipulates that a trademark consisting solely of marks indicating the feature of the goods in a common manner is excluded from trademark registration. The provision enumerates representative examples of signifiers. Hongsong in Hongseong-han우, Korean traditional beef, is an example of a place of production, but the mark shown on the slide successfully was registered. It could be because of other graphical elements, such as the cartoon character, making the mark rather distinctive overall. Other examples are like this. Quality as in 큰글 성경, Great Text Bible. 키높이, meaning height elevating for shoes. 수족침, hand-foot acupuncture. If a trademark only describes the feature of the product, the application for registration might be rejected, challenged, or invalidated. The Supreme Court ruled that unlike when applying for registration, if a descriptive mark is already registered, only such designated goods with reasons to be invalidated would be erased from the registration. I guess our distinguished guest explained much of why we bar the registration of descriptive mark. Let's skip some of the slides. On how to determine whether a mark is merely descriptive or descriptive in a common manner, the Supreme Court presented a rule that if ordinary consumers can intuitively perceive the meaning or instinctively perceive that it's somehow describing the quality of the goods, can be deemed descriptive. But if the mark's meaning can only be understood after much consideration, we can tell that it's not descriptive. There are some examples. I will be brief on explaining this. So the court is carrying out a case-by-case analysis. In a case, the Supreme Court ruled that tomatillo, known as Mexican green tomato, was at least familiar among the traders dealing with Mexican food and not eligible for registration, even though the raw material was not very well known to ordinary Korean consumers. A 3D shape can also be regarded as descriptive if it is not perceived as a source identifier. Thank you.
네, 다음은 독일의 실무에 관해서 크리스티안 슈마츠 판사님의 동영상을 시청하겠습니다.
About the case in Germany through the record of presentation.
Ladies and gentlemen, I am very glad to add the German perspective to this first section on descriptive marks. Please allow me one preliminary remark. German trademark law is very much European trademark law. Hence, this field of the law is characterized not only by the jurisprudence of the Federal Court of Justice of Germany, but also by the Court of Justice of the European Union. As to the purpose of trademark-related laws, I would like to cite from a judgment of the European Court. The essential function of the trademark is to guarantee the identity of the origin of the marked product to the consumer or end user by enabling him or her, without any possibility of confusion, to distinguish the product or service from others which have another origin. For the trademark to be able to fulfill its essential role in the system of undistorted competition, it must offer a guarantee that all the goods or services bearing it have originated under the control of a single undertaking which is responsible for their quality. In Germany, according to the relevant section of the Trademark Act, the following trademarks, descriptive trademarks, shall not be registered. Trademarks which consist exclusively of signs or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, or the time of production of the goods or of rendering of the services, or other characteristics of the goods or services. Let me add, the question of whether a mark is descriptive must be distinguished from the question of whether the mark serves as a distinctive mark. A lack of distinctiveness constitutes a different absolute ground for refusal, namely, a trademark which is devoid of any distinctive character for the goods or services shall not be registered. Back to descriptive signs. Signs and indications which may serve in trade to designate characteristics of the goods or services in respect of which registration is sought are, by their very nature, deemed unsuitable to fulfill the function performed by trademarks of an indication of origin. But this is without prejudice to the possibility provided for in another section of the Trademark Act that they may become distinctive through use. But we will get to this question in a later section. The refusal to register descriptive signs also pursues an aim which is in the public interest, namely that descriptive signs or indications relating to the categories of goods or services in respect of which registration is applied for may be freely used by all, including as collective marks or as part of complex or graphic marks. Whether a sign or indication is descriptive shall be determined on the basis of the understanding of the relevant class of consumers, being the intended customers or prospective customers of the goods or services for which the trademark is protected. This relevant public is composed of the trade and/or the average consumer who is reasonably well informed and reasonably observant and circumspect. The view of the relevant public at the time of the application of the trademark is decisive. However, a future descriptive character of a sign has to be taken into account. The required prognosis is to be made on the basis of the understanding of the relevant consumer at the time of the application. An application must therefore be refused if it is already foreseeable at the time of the application that the sign will acquire a descriptive meaning for the goods or services in question in the future. As regards the standards for the determination of the descriptive character of a sign, the description must be sufficiently direct. The evocation of mere associations or presumptions is not enough. In the Rheinpark Center Noise case decided by the Federal Court of Justice of Germany in 2011, the court stated that a sign is also descriptive if the indication establishes a close descriptive relationship to the goods or services claimed and therefore justifies the assumption that the public will grasp the descriptive content of the term as such without further ado and without ambiguities. Let me now introduce you to a recent decision of the Federal Court of Justice, namely the decision Black Friday, decided on 27 March 2021. This case concerned the trademark Black Friday, which had been registered in 2013 for a variety of goods and services in classes 9, 35, and 41. Invalidity proceedings were filed. The German Patent and Trademark Office ordered the complete cancellation of the trademark for lack of distinctiveness at the time of application for registration, as well as at the time of the decision. The Federal Patent Court partly dismissed the invalidity proceedings. Regarding a number of services in class 35, inter alia, wholesale services via the internet in the areas of electrical and electronic goods. However, the appeal of the trademark owner was dismissed. This decision was upheld by the Federal Court of Justice. The Federal Patent Court rightly assumed that it is sufficient for the ground for refusal to be upheld if the sign in question has no descriptive meaning at the time of filing, but it is already foreseeable at the time of filing that the sign will acquire a descriptive meaning for the goods or services in question in the future. There were sufficient indications at the time of filing that the designation Black Friday would in the future become a catchword for a discount campaign in the trade in electrical and electronic goods in Germany. So far for descriptive marks. Thank you very much for your attention.
네, 지금까지 기술적 표장에 관한 각국의 실무를 들었습니다. 김영기 판사님께서 실무를 바탕으로 해서 영어로 질의를 하겠습니다.
I appreciate all the great presentation from the speakers. Before I start my question, I have a statement for the audience. When I refer to a reference book, it means this book, 표지법에 관한 비교법적 연구. I'll try to let you know the relevant pages about the question. Okay, now I'd like to begin the question with Professor Bernstein. Is it okay for you? Yes. Thank you. Okay, the first question is about the descriptive fair use defense. As you mentioned, the US Lanham Act allows a descriptive mark that has acquired distinctiveness or secondary meaning to be registered. Meanwhile, the users of the mark may still attempt the descriptive fair use defense in the litigation as well. I have two questions about this one. Why does the US law allow the descriptive fair use defense even after the registration of descriptive marks? Second, would you address the descriptive mark fair use defense that the defendant bears the burden of proof in more detail, particularly about how to determine whether the defendant used descriptive words fairly and in good faith to describe their goods, but not as a trademark? Could you?
Well, thank you for those perceptive questions, which show that you spent quite some time reading the materials I submitted. I think that James actually gave the perfect example for the first question with the Baby Dry case. And we do recognize that some brand names can become extremely well known over time. I had the pleasure of flying Korean Air to come to Korea just yesterday, which is hard to believe. And you know, if you start with the trademark Korean Air, well, it just could be any airline that serves the Korea, just like European airline. It could be any airline that serves Europe. But over time, we've come to recognize that when I say Korean Air, I actually don't mean any airline that operates in Korea. I mean a specific brand name. However, that should not give the trademark owner the right to stop other people from using that term fairly to describe what they're doing. Otherwise, you would be giving a monopoly on language. And that's why I agree with James that if another trader wants to say our nappies, or as we'd say in America, our diapers will keep your baby dry, that should be permitted. However, we do recognize, to get to the second question, that we don't want to allow people in bad faith to try to undermine a competitor by purposefully undermining their trademark rights. And so for that reason, when we do allow someone to make a fair use reference of something like Baby Dry, we would require that they do it in good faith. For example, we wouldn't want an ad that says in very tiny letters, our nappies will keep your, and then have giant letters, Baby Dry. Because that could be confusing. We wouldn't want that trader to use the logo of the plaintiff in presenting the words Baby Dry. So we want to make sure that they're using those terms fairly, in good faith, just to describe what they're doing, and not in a bad faith effort to try to cause confusion or cause harm to the brand. The very last part of that is that you can't be using it yourself as a trademark. So you couldn't yourself then try to register Baby Dry as a brand name. You have to be using it in sort of plain language in the text of the copy and not in a way that's trying to designate the source of your own goods. Those are the reasons why we still have the descriptive fair use defense in the United States.
I appreciate your great explanation. Now I can move to Judge James Miller, just next to you. Okay. This question is very just simple but general. This question is about protection of shape of goods in IP field. The reference book, page number 146. How does it differ in terms of requirement and the effect from where a shape of goods is protected by the trademark law or under copyright, design right, etc.? I think you handled this question in the prior session, but please explain it in more detail.
Okay. Maybe I'll give you an example, because I once acted for KitchenAid. They have a famous shape of food mixer. It's quite old-fashioned, but very well known. And what they tried to do was to protect this shape with a trademark. So the trademark consisted of the shape of the food mixer with small letters KitchenAid across the front. And of course, the distinctive part of the trademark was the name KitchenAid. Unfortunately, we failed to stop a rival manufacturer producing quite a similar shape of food mixer because that shape wasn't distinctive. So that's a way of illustrating that trademark protection and design protection have different purposes. So if you try and protect a shape as a trademark, it's got to be distinctive. Whereas if you try and protect a shape of a product through a design right, you're protecting the shape of the product. I think I'll just mention perhaps one other example. No, we probably haven't got time, so I'll stop.
Thank you. Thank you for your considered answer. Now I think the audience can guess who will be the next. Okay, Japan. Yeah, this question is about sources for barbecued meat case. Reference book, page number 148. I want to ask some questions about the interesting trademark case, the sources for barbecued meat case. In this case, IP High Court of Japan stipulated that the three-dimensional shapes constituting the applied trademark are within a scope where it is predictable that a product of the same type would adopt the same for reasons of functionality or aesthetics of the product. And there are no special circumstances for sufficiently acknowledging that the shapes are beyond such scope. Here the question goes, could you elaborate on the meaning of this decision? The statements by the court reminds me of the so-called doctrine of aesthetic functionality in the US. That is, if exclusive use of the feature would put competitors at a significant non-reputation related disadvantage, then the aesthetic feature is functional and the trade dress cannot be protected. May be understood that the IP High Court of Japan decided in the case that the distinctiveness of three-dimensional mark shall be determined strictly under a legal principle similar to the doctrine of aesthetic principle. Judge Katsumata?
Thank you for your question. And unfortunately, I'm not familiar with the doctrine of aesthetics. I have to learn from the
aesthetic functionality.
I understand that the way of thinking is similar to those criteria of the Japanese court. And the criteria used in the sources for barbecue meat case is widely adopted when the judges examine the shape from the perspective of functionality and aesthetics of the product. And but in Japan, the court does not see if the exclusive use puts competitors at a significant non-reputation-related disadvantage or not, but just see whether the competitors normally wants to use the shape from the view of functionality and aesthetics. So in my point of view, maybe it is easier to find 3D mark descriptive in Japan than the US, but I'm not sure. And yes, that's all.
Thank you. Professor Bernstein, could you add something?
Well, I'll start by saying that many judges in the United States don't understand the doctrine of aesthetic functionality either. And it's a very controversial doctrine. The Court of Appeals for the Ninth Circuit, which covers California and some of the other Western states, had a controversial decision involving Redbubble. And we had hoped the U.S. Supreme Court would take that case to provide some clarity, but they did not. And so we still have some ways to go to understand the doctrine better. But the idea is that if you are designing a product in a way or using a trademark not for its source identifying qualities, but rather because aesthetically you want to present it, that should be allowed. So for example, there was a case involving patterns of china, and one court said that another trader can make the same pattern because in a hotel they might need to replace some broken pieces of china and they don't want to have to go back to the original manufacturer to have a set that would look nice on the table. I myself actually think that that's problematic because you may very well be passing those off as coming from the first manufacturer if it was a distinctive look, if it was a distinctive pattern. So the doctrine of aesthetic functionality is, as I said, controversial. And we could do an entire day just on that, but we don't have time for it.
Okay. Thank you. That's it.
네, 이상으로 기술적 표장에 관한 논의를 마치고 두 번째
brings
토픽인
us to the
사용에
end
의한
of the descriptive marks, and let's move on to section 2 on distinctiveness through use. We will follow the same method as the first section. We will start with Professor Bernstein and hear responses from the panel.
Excellent. Okay, so now we're getting to the question, let me just advance these slides, of distinctiveness. And here we're going to start with the notion that you have a descriptive trademark. And to Judge Katsumoto's point, it can be 3D as well that's descriptive. Indeed, the US Supreme Court has said that a product configuration is never inherently distinctive. You must show a secondary meaning. You must show that it has a source identifying element. So I'll start by focusing on acquisition of distinctiveness rights. And one of the leading treatises in the United States on trademark law is by Professor McCarthy. So this is from his book on the elements of how you would acquire distinctiveness. And we do look at two types of evidence. We look at direct evidence of distinctiveness, and we look at circumstantial evidence. So direct evidence could be, for example, statements by consumers, and we can measure that through surveys, or we can measure it by actually having consumers come in and testify or provide declarations. So for example, it could be people saying, I know Korean Airlines is a brand. It's not just any Korean airline. Whereas if we were talking about European airlines, well, there's no one European airline. There's Air France, there's British Airways, there's KLM. They are all European airlines. There, consumers don't see the term European airlines as being a source identifier. Rather, it's just a descriptive term for a variety of different airlines. And then we can look at circumstantial evidence as well. And as Professor McCarthy points out, that could be evidence of how long you've used that trademark. What have your sales been? What is the advertising that you do of that trademark? It's very powerful, for example, to put in evidence showing that a manufacturer calls out the element. For example, we have a brand of fiberglass insulation in the United States made by Owens Corning, and it's unusually pink. There's no reason that fiberglass has to be pink. A single color in the United States can never be inherently distinctive. There was a Federal Circuit case just last year that said a combination of two colors might be inherently distinctive, but a single color is never. So what does Owens Corning do? To advertise their fiberglass, they use the cartoon character, the Pink Panther, and they tell people, look for the pink fiberglass. In their advertising, they highlight the color, they highlight that element of their product, and that helps show that there's secondary meaning. So courts can look at all of those different elements in deciding whether or not you've shown that you've acquired distinctiveness. So here's just an example. If I say something is a Best Buy, that's on its own descriptive. But after a certain manufacturer has advertised it a lot, here it's a retail store in the United States called Best Buy, people have come to recognize that's a place where you can go to buy electronics, for example. This is the case in the US Supreme Court that deals with product configuration and trade dress. And here the Supreme Court said that you must show secondary meaning. So this dealt with these appliques, these patches put on babies' dresses. Walmart copied the look of a dress that was produced by Samara Brothers. Samara Brothers challenged them. Here, Walmart went to court for a declaration that their dress wasn't infringing, and the Supreme Court said that the burden was on Samara Brothers to actually, come forward with evidence showing that they had acquired secondary meaning, that people didn't see those appliques as just being a nice ornamental element to the dress, but rather that they actually signified source. Now, just like you can acquire distinctiveness, so can you lose it. Of course, one way to lose trademark rights is just to abandon your trademark, but that's losing trademark rights in the entire trademark. But there are ways of still having your trademark and losing the distinctiveness of it. And one way of doing that is through naked licensing. I'm not sure if that's a term that's used in other countries, but in the United States, naked licensing is when you license the trademark and you have no quality control at all. You can let them do whatever they want with that trademark. And the reason that can lead to loss of distinctiveness is that we no longer have the very promise of a trademark. The promise of a trademark is that there's one source behind it, and that you know that the quality will be consistent. It might not be good quality. I don't think a McDonald's hamburger is very good at all, but if you walk into a McDonald's anywhere in the world, you know what you'll be getting. You're getting a consistent quality. If you practice naked licensing, and in this case, the court found that this video store had allowed other stores to use the exact same name without having any oversight or quality control, that can lose to the loss of distinctiveness. And then the other major topic I'll cover before I pass it on is that you can lose distinctiveness if your trademark becomes generic. This is actually an advertisement that was run by Xerox back when Xerox was a powerful trademark for photocopy machines. And Xerox wanted to make sure that people didn't allow its trademark to become generic. And so they have this graveyard of other trademarks like escalator and linoleum and trampoline that once were trademarks, but over time, the brand owners didn't protect those names and other people started using them. And so it got to the point where anybody who made a bouncing device for their children to jump on in the backyard would call it a trampoline. It no longer meant it came from a particular brand. And so Xerox ran these ads saying, please don't use our word as a generic term. Say you want to make a photocopier, Xerox is our brand name. Most recently, there was a very amusing video by the in-house lawyers for the company that makes Velcro. And they sang a whole song about how Velcro is their trademark, and please don't use Velcro as a generic term. We don't have time, though, to see that video today.
Judge Guan prepared.
Actually, I've included that in my slide.
Oh, excellent. Then we'll get to see it.
Yeah, okay. So we talked a little earlier about passing off and the use of a descriptive term. And of course, David referred to a secondary meaning. In other words, the meaning has changed from a purely descriptive meaning to one which indicates trade origin. And indeed, in passing off, the notion of a secondary meaning was laid down as long ago as 1896 in a case called camel hair belting, because although the plaintiff's belting was made of camel hair, people had come to associate the term with products of the claimant's manufacture. Now, what has this got to do with acquired distinctiveness? Well, it's the same concept. It's just a different term. So how do you demonstrate you've got acquired distinctiveness? Now, for some marks, simple word mark, it's relatively easy because you put forward lots of evidence of your massive turnover, lots of evidence of advertising, and provided you've used the term as a trademark, that's probably going to be enough to persuade people, or a court, that you have acquired distinctiveness. And one other thing that David mentioned, which I also think is important, for some marks, the trademark owner actually uses the mark, continues to use the mark in a descriptive way, in which case you're not going to be able to prove acquired distinctiveness. So one of the key questions, and this is particularly important when you've got a whole series of marks on a product. So you may have a house mark like Kellogg's, then you may have the name of the product. And if they've trademarked the name of the product, you've got to look to see, are they using it as a trademark? Or do they have the confidence to use that term as a trademark without the house mark? And sometimes people don't have the confidence to use the term as a trademark on its own. And again, that's a key indicator that it hasn't acquired distinctiveness. Now, in the reference book, I've set out all the materials based on our Trademarks Act, which is, and all of those matters are derived from the Trademark Directive. Moving on to loss, David talked about naked licensing. That's quite a controversial way to lose trademark rights in the UK. If you don't exercise any quality control at all, then you're likely to lose your trademark. The other way that David mentioned is also part of EU law, genericide. There are lots of examples even in the old cases of marks that were once proper registered trademarks, and because the trademark owner failed to police infringements, they lost the trademark right. Now, that doesn't mean you've got to go after everybody, but it does mean that, in a sense, you couldn't call it a death by 1,000 cuts. If you don't stop the main infringers and you just let people continue to use your mark, it will eventually lose its source origin message, and it'll just become the name of the goods. I mean, for example, shredded wheat. You may not know this as a breakfast cereal. It's quite well known in the UK. But shredded wheat was originally produced under a patent. And after the patent expired, it continued as a trademark. But eventually, it became generic, at least in the UK, because so many people produced the same type of breakfast cereal after the patent had expired. So that's a lesson for trademark owners. If you have a monopoly, either through a patent or a design, which relates to your trademark, you've got to be very careful once the monopoly right expires to stop the name of the patented or registered design protected product becoming generic.
일본의 쿠비코 가스마트 판사님.
Judge Kumiko Katsumata, the floor is yours.
Yes. Okay. I'd like to explain about distinctiveness through use. In Japan, the Trademark Act adopts first-to-file system, so the applicant can file an application before it starts to use the mark. Actually, it is generally recommended to file an application for trademark before you start the business in Japan in general. However, there is an exception. A mark without distinctiveness may be registered if customers are able to recognize the goods or services as those pertaining to a business of a particular person as a result of the use of the trademark. So if you want to register in distinctive mark as a trademark, you have to start use the mark and obtain the recognition of consumers before you file an application. And here in distinctive marks includes descriptive marks. And what is the requirement to obtain distinctiveness through use? According to Article 3, Paragraph 2 of Trademark Act, the mark should be well known to the extent that consumers can recognize it as marks representing certain products or services relating to a business of a particular person. In addition to that, according to the precedents, the mark should be well known throughout Japan. Here is a case involving 3D mark named Jean-Paul Gaultier Classic case. You can see the designated 3D mark on the slide. It is the shape of a bottle for perfume. And IP High Court held that whether or not a trademark consisting of a three-dimensional shape has acquired the capability to distinguish one goods from others should be determined by comprehensively taking into consideration whether or not there are other goods whose shape is identical or similar to the shape of the trademark and the circumstances concerning the use of the trademark, such as the period of time when the trademark has been in use, the volume of sales of the goods, and the period of time and scale of the advertisement of the goods. This criteria also applies when the court determines whether a mark gained distinctiveness irrespectively of the type of the mark. In this case, the court admitted that the distinctiveness of the mark, taking into account the fact that the plaintiff has used the mark more than 15 years, and it has been frequently appeared in magazines. Next topic is succession of acquired distinctiveness. In my point of view, it seems to be difficult to succeed the acquired distinctiveness because the mark should be well known to the extent that consumers can recognize it as marks representing certain products or services relating to a business of a particular person according to the provision of Trademark Act. And about the scope of recognition. When the mark acquired distinctiveness, the same mark or substantially same mark can be registered. Please note that if a mark constitutes the shape, the color, or the sound, which is indispensable to guarantee the technical functionality of the designated goods or packaging thereof, it cannot be registered, even when the consumer recognizes the goods or services as those pertaining to a business of a particular person as a result of the use of the trademark. It is exception of distinctiveness through use. Next, effect of distinctiveness acquisition. Once it is registered, it can exercise the trademark right in its entirety. Next, loss of distinctiveness through use. In some cases, the mark may lose its distinctiveness. In precedence, the court seems to determine whether the mark has lost the distinctiveness, taking into consideration the practical situation and where the mark used by the third parties, how long the third parties used the mark, the explanation of the set word in these dictionaries, how the mark described in the books or magazines, whether the trader and consumers recognize the mark as a common word. When you think the registered trademark have already lost its distinctiveness, you can request for trial on the invalidation before JPO. And in the trademark infringement case, a infringer can assert the invalidity defense or abuse of rights. That's all.
네, 다음은 중국의 후이수 판사님께 발표를
Next is Judge Huisu from
부탁드리겠습니다.
China.
연결 부탁합니다.
So, please.
elaborated in the trademark law by countries. It's stipulated in Article 8 and Article 9 of Chinese trademark law. In our opinion, the distinctiveness of trademark is dynamic, take acquisition and loss, and should be objectively determined case by case. I will use Xiaoguancha trademark as a typical example to illustrate how to acquire distinctiveness through use. A company filed an invalidation action against this trademark holder, claiming that in this mark, Cha is the abbreviation of teeth. Xiaoguan usually refers to the package of products, and Xiaoguancha does literally means tea package in small cans. Such a mark, while not inherently distinctive, usually cannot be registered on the ground that it merely directly indicates the main raw materials, the package of products, and incapable of identifying the corresponding goods or services. National Intellectual Property Administration, hereinafter referred to as CNIPA, held that there is sufficient evidence proving that consumers have come to recognize the Xiaoguancha as an indicator of goods after long-term publicity and use. Therefore, in this scenario, CNIPA made the decision to maintain the registration of the disputed mark. Then the company filed a lawsuit to Beijing Intellectual Property Court against CNIPA's decision. Beijing IP Court determined that, based on public information, Xiaoguancha Company has invested 260 million yuan in advertising for the trademark and set up more than 600 stores in many provinces and cities across the country. In combination with the evidence submitted by Xiaoguancha, such as the authorized distribution agreements, the order lists, the sales statistical sheets, the product waybills, the advertisement production contracts, invoices, and the relevant advertisements served on various media, the library search report issued by the China National Library, the planning of large-scale publicity activities, the audit reports, and various owner certificates, which include the evidence regarding protection of Xiaoguancha trademark rights. The court held that the trademark has enjoyed a relatively high reputation and has established a relatively stable connection with Xiaoguancha Company through extensive publicity and use, and could obtain distinctiveness, so the disputed mark could be registered as a trademark. In this judgment, which is now in effect, the court elaborated that the following factors should be taken into consideration when judging whether the trademark has achieved distinctiveness through use. 1. The way the mark is actually used, its effect, its law. In other words, whether it is used in the manner of trademark. 2. The time, region, and scope of consecutive use of the mark, as well as the sales score and other business information of the makeholder. 3. The recognition of the trademark by the relevant public. 4. Other significant factors of the trademark through use. In general, the examination and judgment of whether the trademark have obtained distinctiveness through use should be based on the actual scenario where the trademark submitted for registration. However, if the parties have sufficient evidence to prove that the trademark has indeed obtained distinctiveness through actual and effective use after the application date, from the perspective of saving judicial resources and protecting the legitimate rights and interests of the parties, the evidence after the application date of trademark registration in dispute should also be considered. That's all. Thank you.
네, 감사합니다. 다음은 권보은 판사님께서 발표.
Moving on to Judge Boon Kwon.
전체적으로 시간이 10분 이상 지체되고
We are 10 minutes delayed in our schedule, so please keep to the time. 5 minutes for your responses. Thank you.
Thank you. It doesn't allow me to monopolize the mic. Basically, Korean trademark system can be considered as a first-to-file system, but some provisions are based on the first-to-use principle, and acquisition and loss by use can be included in that category. The Korean Trademark Act prescribes that a descriptive mark, a conspicuous geographical name, or a common surname or name may be registered if it is perceived to indicate the source of good as a result of using the trademark. And in a recent case on Seoul National American University case, the Supreme Court in an Ang Bank case explained that Seoul National University can be trademarked because it's acquired secondary meaning of conspicuous geographical name. The Supreme Court enumerated factors to be considered when determining distinctiveness: duration of use, the frequency and continuity of use, quantity of production and sales, market share, the method, frequency, period for its advertisement and promotion, etc. Acquisition and loss of distinctiveness is a question of fact. The more abundant the evidence are submitted, the more likely acquired distinctiveness would be recognized. And the enforcement regulation of the Trademark Act and the KIPO manual provides a helpful list of possible evidence. Here are some exemplary decisions by the Supreme Court. In the Viagra case, a Supreme Court ruled that Pfizer's trademark of shape of the pill consisted solely of a mark indicating the shape, but acquired distinctiveness through use. The acquisition of distinctiveness is not recognized for similar marks or similar goods or services, and the trademark which acquired distinctiveness can fully enjoy the right. That is, it can prevail over similar marks or similar goods or services. Let's now move on to the loss of distinctiveness. The Trademark Act says that if a trademark becomes a generic term or a commonly used mark, it cannot claim its right and may be invalidated. Bayer's trademark aspirin was declared generic in 1977, as in the United States. And Jeep was declared generic in 1992. Note that aspirin is still a trademark name in about 80 countries. So it can differ from country to country. Because it's to deprive a right from the holder, careful consideration should be given, and the course of trade at the relevant market at the time of decision is considered. Here's an example of loss of distinctiveness. Trademarks once thought to have lost distinctiveness through use can regain their distinctiveness over time. For example, in Korea, Dailband has been used as a common name for a bandage, just like Band-Aid in the United States. However, with competitors coming up with other fancy versions and Dailband losing its market share, the trademark took back its function as a source indicator. Sadly and ironically enough, young people like my daughter, soon to be 5-year-old, even didn't have a chance to hear the name. When determining distinctiveness, the right holder's efforts are considered critical, such as demanding competitors stop using the mark or requesting corrections to how the mark is mentioned in media. And now it's the time to watch the video clip that David mentioned. This is an excerpt from a YouTube video by the legal team of Velcro.
Asking you not to say her name. We took 60 plus years to build. But if you keep calling these Velcro shoes, our trademark will get killed. Yeah!
We aren't just doing this for us. We're doing it for all the successful brands that got so popular, people started using the brand names the wrong way. So please, remember.
If you need something to clean up your socks, do it with bleach and not with
Clorox.
If you have blood from a boo-boo you made, this is a bandage and not a
Band-Aid.
If you're exercising with someone you're dating, it's in life skating and not
Rollerblade.
I know that bleach stuff is more fun to say, but if you keep doing it, our trademarks go away.
Isn't it hilarious? I recommend you to watch the full version of it, and there are the behind the scene videos and other the epilogue to that, so that they are all worth watching.
네.
Series of patent court cases, Allergan, famous for Botox, a drug which reduces skin wrinkles, could successfully invalidate the registered trademark Bonotox thanks to its effort to manage its trademark. Thanks. That's all.
네. 다음은 독일의
Moving on,
크리스티안 슈말츠
we will
판사님의
watch the
동영상을
recorded
시청하겠습니다.
presentation
약
of Judge
7분간
Christian
정도
Schmaltz. It will
시청하겠습니다.
be 7 minutes.
Ladies and gentlemen, I will now cover some aspects of the second section regarding the issue of distinctiveness through use, and will for this purpose, first of all, refer to the famous 1999 Chiemsee judgment of the Court of Justice of the European Union. The European Court held that in determining whether a mark has acquired distinctive character following the use made of it, the competent authority must make an overall assessment of the evidence that the mark has come to identify the product concerned as originating from a particular undertaking, and thus to distinguish that product from goods of other undertakings. In assessing the distinctive character of a mark, the following may be taken into account: the so-called famous Chiemsee criteria. The market share held by the mark, how intensive, geographically widespread, and long-standing the use of the mark has been, the amount invested by the undertaking in promoting the mark, the proportion of the relevant class of persons who, because of the mark, identify goods as originating from a particular undertaking, and statements from chambers of commerce and industry or other trade and professional associations. I will come back to these Chiemsee criteria later on. If, on the basis of those factors, the competent authority finds that the relevant class of persons, or at least a significant proportion thereof, identify goods as originating from a particular undertaking because of the trademark, it must hold that the requirement for registering the mark is satisfied. However, the circumstances in which that requirement may be regarded as satisfied cannot be shown to exist solely by reference to general abstract data such as predetermined percentages. As regards the method to be used to assess the distinctive character of a mark in respect of which registration is applied for, the competent authority may, where it has particularly difficulty in that connection, have recourse to an opinion poll as guidance for its judgment. The point in time for determining whether such requirements are met is the time of application for registration of the sign. Only if the trademark at issue has acquired a distinctive character before the date of filing may it escape the application of one or more of the grounds of invalidity. However, account may be taken of evidence which, although subsequent to the date of filing, enables the drawing of conclusions on the situation as it was on that date. In order to be able to take into account an assertion of distinctiveness which occurred after the date of filing, the seniority of the application must be deferred. If the trademark did not meet the requirements for registration at the time of filing, but the ground for refusal no longer applies subsequent to the date of filing, the application may not be refused if the applicant declares his agreement that, regardless of the original date of filing and of any priority claimed, the date on which the ground for refusal ceased to apply is deemed to be the date of filing and is relevant for the purpose of establishing seniority. It follows that the registration of a descriptive sign with the priority of the filing date requires a distinctiveness through use at that time. Once the distinctiveness through use has been proven and thus been established, the obstacle to protection is overcome and the sign is registered. There are no special regulations as regards the scope of protection of such signs. Rather, the protection which the registration by virtue of acquired distinctiveness confers on the trademark proprietor is no weaker than that of a trademark which was registered on the basis of original distinctiveness. In assessing the distinctive character of a mark in respect of which registration has been applied for, the so-called and already mentioned Chiemsee criteria should be taken into account. Since an overall assessment of the particular circumstances of the case must always take place, it cannot be said that any particular evidence is more important than the other. However, opinion polls or consumer surveys will usually provide the simplest and most reliable evidence of an acquisition of distinctiveness through use. Therefore, according to the established case law of the Federal Court of Justice, consumer surveys are regularly to be considered for determining the consumer's expectations, at least in complex factual situations. I would now like to refer to one recent case of the Federal Court of Justice regarding the acquisition of distinctiveness through use, namely the case Gold Bunny 3 of July 2021. This case concerned infringement proceedings in which the plaintiffs claimed that the golden color of the wrapping of their chocolate Easter bunny had acquired public recognition as a trademark through its use in trade. The Court of Appeal had dismissed the infringement claim. The appeal on points of law was successful. Taking into account the consumer survey submitted by the plaintiffs, they have proven that the shade of gold of the gold bunny claimed by them has acquired public recognition as a trademark for chocolate bunnies within the relevant public within the meaning of Section 4, Number 2 Trademark Act. For this, a degree of assignment of more than 50% is sufficient. Let me now say a few words regarding the loss of distinctiveness through use. The later loss of distinctiveness does not in itself lead to the loss of the trademark right. The mere loss of distinctiveness does not justify the assumption of a transformation of the trademark into a generic designation. However, if the sign has actually become the common name in the trade of goods or services in respect of which it is registered, the registration shall be revoked and cancelled upon application. There are several statutory provisions which address the situation in which the trademark is no longer capable of fulfilling its function as an indication of origin. The provisions relate to the situation where the trademark has become the common name and has therefore lost its distinctive character, with the result that it no longer fulfills that function. The perception of the relevant public is decisive for the development of a trademark into a common term. The determination of such development is subject to strict requirements and is to be affirmed only if a completely insignificant part of the target public still sees an indication of origin in the sign. The mere fact that the trademark is also used with a certain frequency in a descriptive manner does not justify the assumption that it has become a common term. Thank you very much for your attention.
네, 다음은 김영기 판사님께서
Now,
질의하십니다.
Judge Kim Young-gi will pose his questions to individual panelists.
This time the question goes to Judge Katsumata again. Sorry, Judge Kwon. Most audiences are familiar with Korean practices. Okay, Judge Katsumata, in the question, this question is about succession of acquired distinctiveness. Reference book, page number 165. In the question and response, you answered if the assignee succeeds the whole business relating to the products or service for which the original user used the mark and gained distinctiveness of the mark, the judge can consider the actual use of the mark by the original user in deciding whether the said mark has acquired distinctiveness through use. However, if the assignee obtained only the mark but the business, the judge cannot take into account of the use of the mark by the original user in deciding the distinctiveness. I think this part is very interesting because it seems a little different from other countries' practice. So could you elaborate on the last part, which seems different from other countries' practice? So, I mean, why do you in Japan treat the case differently between the succession of whole business and obtaining only the mark in deciding the distinctiveness? Your Honor?
Okay. Thank you for your question, and I would like to explain from the trademark law. According to the Article 3, Paragraph 2 of Trademark Act in Japan, in order to obtain the distinctiveness through use, it should be well known to the extent that the consumers can recognize it as marks representing certain products and services relating to a business of a particular person. So it means the distinctiveness should connect with a certain business of a particular person. So when the assignee obtained only the trademark right, but the business, including the products or services which the trademark uses, the distinctiveness of the mark is tied to a particular person. So, I mean the original user. So, and it does not have any relation with the assignee. So thus it is not appropriate to take into account of the use of the mark by the original user in deciding the distinctiveness of the mark after succession.
Okay, because of lack of time, I'll stop here. Thank you.
네, 이제 마지막 토픽인 설문조사의
And we will move on to the last topic on surveys. Please keep your responses to 5 minutes and responses to questions to 2 minutes. We will start with Professor Bernstein.
Thank you. So we could spend 5 hours on surveys, so I'm going to just introduce the topic very briefly, but there's much more material in the book. So first I'll start with what the standards are for surveys. Surveys are used in trademark cases very extensively in the United States, and they have been for over 50 years. So I think we have a very well-developed jurisprudence around surveys. And we've learned a lot from the statisticians in the world about how to conduct surveys in a way that will be relevant evidence that we can rely on. These are 7 of the factors that courts often look to. This is published by the U.S. Federal Judicial Center to help educate judges who may not be as familiar with statistics to understand what they should be looking at. You want to make sure that you've got the right population of people in the survey, that the people in the survey are representative of that population. For example, if you're doing a survey about yogurt, you want to make sure that the people you're surveying actually eat yogurt. If you're doing surveys about beef sauces for beef, you don't want to have vegetarians in your survey because they're not likely to buy sauces for beef, for example. So these are those factors courts look at. And what I'd like to do is very briefly talk about some of the different types of surveys that have been done. So one type of survey that we look at very frequently deals with whether or not a trademark is generic. And we've talked about that today because if a trademark is generic, or if a term is generic, it can never be a trademark. On the other hand, if it's perceived as an identifier of source, as not being the genus of the thing, then it can be protected. And the very famous case is the Booking.com case, which I mentioned we litigated 2 years ago in the U.S. Supreme Court. And here there was a survey, and the results showed that when you asked people about different names, is it a brand name or is it a common name, the brand name for Booking.com was 75% of consumers identified Booking.com as being a brand name. And they identified these other terms, Pepsi and E-Trade and Shutterfly, as being brand names as well. In contrast, When you look at some other things like supermarket or sporting goods, they recognize that those are common names. And to try to make sure that we were not confusing people by having a .com, the survey included washingmachine.com, and 33% of people thought it was a brand name, 67% thought it was a common name. And so the court found this persuasive to show that consumers could fairly understand the difference between brand names and common names. And this evidence, the Supreme Court said, was very important evidence in showing that Booking.com is not generic. We also can look at secondary meaning or acquired distinctiveness. This was a case we handled for vitamin water some years ago. And here the question is, do consumers think that products with this name come from one company or more than one company? For example, if I use the Korean Air example that I talked about before, if I said, do you associate Korean Air with airline services from one company or more than one company, I think the vast majority of people would say one company. That would show its acquired secondary meaning. If I asked, do you associate European Air or European Airlines with one company or more than one company, I think most people would recognize that there's more than one company with whom they identify the term European Air, and therefore it would not have secondary meaning. Finally, we look at likelihood of confusion, and surveys are used to show confusion quite a lot. Some of you may be familiar with this logo that I have next to the name Grubhub. Grubhub is a US company, but it's owned by a Dutch company called Jet, just Eat Takeout, I think. And they use the same logo in many of their brands around the world. Here, we did a survey to show that it did not cause confusion with the logo for Home Chef. And the questions that were in the survey are shown here. This is so-called the Everready survey. It's based on a case involving the trademark Everready, where you only show one mark. You just show the Grubhub mark and say, who do you think this comes from? And no one said Home Chef. A second type of confusion survey is from a case called Squirt. Here you show the products. We show it in an array, and then you show the one product that you're testing and say, was this one of the products you saw before? And the idea is to see whether or not people recognize the similarity. So I could go into more detail. If you're interested in the actual survey report in the Booking.com case or the Grubhub case, we've actually provided that to the patent court, or I can send it to you as well. And there's much more detail about the surveys in those cases.
네, 다음은 영국의 제임스 멜로 판사님.
Judge Nunno from the
Okay.
UK.
We in the UK also have a very long history of surveys in trademark cases. And it's fair to say our law has developed in a different way to it has in America and indeed many other countries. And you may think that the law on surveys, so far as the UK is concerned, is out of step with many other jurisdictions. Now, to explain UK law, it will help if you look at the relevant case law in the booklet. So it's page 495 to 6 in the English version or page 202 in Korean. Because what I need to explain to you is some of the history. So we started off in the 1970s. Essentially, plaintiffs were trying to prove a likelihood of confusion or deception using a statistically significant result from a survey. And judges have always been somewhat suspicious of results from survey evidence in the UK. And those suspicions led to the first group of requirements that I've set out on page 202. They're from the Imperial and Philip Morris group in 1984. And you can see from these 7 requirements, you can see what was concerning the judges at the time. So the first 2, all surveys conducted, their methodology and results must be disclosed, and the totality of all answers must be disclosed. That arose from a suspicion that basically the court wasn't being given the full picture. So you could go out and do a survey, and as the claimant, you don't like the results, so you do it again, but slightly differently. And then you only present the latter survey to the court, so the courts were suspicious of that. 3 and 4, questions must not be leading, and the questions must not lead the interviewee into a field of speculation upon which they would not otherwise have embarked. Now, a lot of the questions that have been cited in the reference book from other jurisdictions wouldn't be allowed in the UK because they're too leading. And that creates a difficulty for the claimant, because if you don't have some sort of leading element in the question, you don't get the answer you want. So, for example, in a case about the Levi's arcuate stitching mark, they showed respondents a picture of somebody wearing jeans, the Levi 501s, for example, and the picture extended from the waist down to the knees. And they asked a very general, non-leading question: what can you tell me about this photograph? And they got loads of answers like, the jeans are a bit baggy. And that illustrates the problem. If you don't ask a leading question, you don't get the answer that you want. Whereas if you ask a leading question, often it carries no weight with an English judge. So those were the guidelines laid down in 1984. And that led claimants away from trying to establish a statistically significant survey. And we moved on to a second stage where we used surveys to try and identify good witnesses to bring to court. So we were using surveys not for a statistically significant result, but as a witness collection exercise. And so then you'd pick your 5 or 10 best witnesses, bring them to court, and you present them as you're trying to persuade the judge that these people were normal members of the public, ordinarily careful, and their reactions should be paid attention to. And for quite some time, those witness collection exercises did work. Now, then we moved to the third stage, because a particular judge in the Court of Appeal, Lord Justice Lewison, he wasn't an IP judge, but he had done a few IP cases as a judge at first instance. And he thought these surveys cost too much money and were often kicked out as being of no use. So he thought he'd do something about it in the Interflora litigation. And he established this cost-benefit test, which has resulted in a whole new area of case management of surveys in the UK. And so essentially, there is an initial stage where you have to go to a judge and say, look, these are the questions we want to ask. And the judge won't give advice on them, but he'll say, well, okay, how much is it going to cost? Do I think it's worth asking these questions? And even if you are given permission to adduce a survey and evidence, once you've done the survey, you still have to demonstrate the results are, well, they pass, the cost-benefit analysis. Now, what that has done is it has led to a significant reduction in the amount of survey evidence that can be brought in UK cases. Now, one thing to point out, not everybody agrees with what Lord Justice Lewison did in Interflora. In fact, as a judge now, I know that some of these trademark cases, when you don't have any survey evidence, are very much more difficult to decide, because you never get to hear what an ordinary member of the public actually thinks. But be that as it may, we're stuck with the Interflora guidelines. Now, the other thing to note about the Interflora guidelines, they were primarily directed at questions which were seeking to establish a likelihood of confusion. Lord Justice Lewison was very suspicious of these types of questions. He left an exception if you were doing a survey to try and establish distinctiveness. Now, you may think those two notions of trademark law are very closely connected, and that there shouldn't be a real distinction between the two. But there is a distinction, at least in our law.
네, 구미코 가스마트 판사님.
Yes. It's my turn. In Japan, the survey result is used to support the distinctiveness of a trademark and public recognition. But generally speaking, in civil litigation in Japan, there are no requirement for the evidence to be examined by the court. So, survey result may be submitted as evidence in a trademark litigation. However, it is said that the result of the survey is not deemed quite concrete and reliable by the court in many cases, because as the court itself does not execute the survey, and the survey is usually executed by one side party. Thus, it seems that the said party tries to lead a favorable outcome from the survey by means of using deliberate questions and deliberately selected samples. So basically, the court in Japan does not attach importance to the survey. In addition to that, as far as I know, there is no precedence in which the court presented the preferable way to conduct the survey specifically and precisely. So my presentation of this section is based on the opinion of scholars and attorneys. So according to the paper written by the Professor Inoue, in these days, the survey through the internet is most popular. According to that survey, about 61.7% of consumer survey is done through the internet, and 8.3% is done by face-to-face questionnaire. It is said that in order to make the survey reliable, the survey is preferably conducted before the trial decision, and a non-inductive question is preferable, and at least leading questions. And at least leading questions should be avoided. Questions relate to legal issues such as similarity of marks and the likelihood of confusion should be avoided. It is because such kind of questions is determined by the court, not determined by the recognition of the consumers. And population should be consist of consumers of the product for which the mark uses. And samples must be chosen throughout Japan. I will show you some cases in which the survey result was submitted as an evidence and the court mentioned the result in the reasoning. The first case is Yakult case. 98 or more % of consumers responded that they would be reminded of Yakult when they saw the container in question. So the court ruled that this 3D mark has distinctiveness and should be registered as a trademark. And second one is Louis Vuitton AP case. In this case, about 75% of women recognize that AP mark or AP line as a mark used for the product of Louis Vuitton. So the court held that the mark acquired distinctiveness through use. And third one is a very famous Levi's case, and Professor Tamura also explained that case in the previous session. And bow type stitch has been recognized as a mark of Levi's by 16.6% of consumers, and the court determined that bow type stitch is well known but not famous. And Professor Tamura said that the threshold is about 10%, but in my opinion, it's very too small, and the 16% is also too small to be determined well known, but it's only my personal opinion. And At last, I will introduce one example of the question used in the practical case called Rose-O'Neill-QP case. In Japan, there is a famous company named QP which sold food, especially mayonnaise, requested a trial on the invalidation for the trademark of Rose-O'Neill-QP. And they wanted to prove the Rose-O'Neill-QP reminds consumers of the name of QP, so they conducted the survey with these questions. They asked with, any answer is okay. Please feel free to let us know your answer to avoid leading them on. So it seems to be neutral questions. However, unfortunately, they failed to prove it and lost the case. It is the last. I wanted you to see our brand new business code. It's called business code, and we had launched it in October. So that's all.
That's very good. Congratulations.
네, 감사합니다. 다음은 중국의 후이스 판사님께 발표를 부탁드리겠습니다.
Judge Huisu, the floor is yours. Judge Huisu, I believe you're on mute.
소리.
Can you hear me?
Yes.
Hello?
Yes, we can hear you well.
Okay, thank you. And in China, the types of evidence include material evidence, documentary evidence, audiovisual material, testimony of witnesses, statements of the parties, expert conclusions, records of inspection, etc. The court will examine the legality, authenticity, and the relevance of various evidences in accordance with legal procedures. The questionnaire will also be adopted by Chinese courts when they try cases. Qiaodan case is a typical example. Qiaodan Sport Limited Company, a Chinese sportswear and shoes manufacturer, hereinafter referred to as Qiaodan Sports, registered the trademark Qiaodan. This is its trademark. For clothing, shoes, hats, etc., U.S. baseball legend Michael Jeffrey Jordan filed a request to cancel the trademark. Knipper and two courts did not support Michael Jordan's claim, for the reason is that Qiaodan is an American common surname. The evidence is inefficient to prove that Qiaodan in the disputed mark definitely points to Michael Jordan. And here is the whole case. Michael Jordan filed an application for retrial. On December 8, 2016, the Supreme People's Court delivered a verdict that the trademark Qiaodan in Chinese characters has infringed upon the prior rights of personnel name of Michael Jordan and ordered Knipper to remake the decision. In this case, Michael Jordan's attorney collected strong evidence showing a stable link between the Chinese character Qiaodan and the name of Michael Jordan, as well as the high personnel reputation of Michael Jordan amongst Chinese consumers. The most critical pieces of evidence are two notarized investigation reports, Michael Jordan and Qiaodan Sports Association survey reports, nationwide and Shanghai. The two reports, this is its criteria, and this is the question and conclusion. I will not repeat. The Supreme Court found that the process of investigation and evidence collection is much standardized and authenticity, and the proof of the investigation conclusion was relatively high, which together with other evidence could prove the relevant facts of the case. In the above-mentioned cases, the trial court did not address the survey plan with the litigants in advance. Questionnaire survey was a kind of evidence submitted to the court by litigants. Generally speaking, the probative value of such evidence is relatively high. In China's judicial practice, litigants usually apply for notarizing the questionnaire survey before submitting it to the court, or apply to the notary agency to participate in investigation, act as evidence preservation, and issue a notarial certificate. When deciding whether to adopt the conclusion of the questionnaire survey, the court will generally consider the following facts: whether the purpose of the survey is reasonable and clear, whether the survey group designation is accurate, whether the questionnaire design is scientific, reasonable, and not misleading, whether the execution method and data statistical analysis are correct and objective. In a word, judicial adjudication is a comprehensive work. The court should combine the questionnaire survey, other identification factors, and specific facts in accordance with the provisions of the law to make a fair verdict. That's all. Thank you.
네, 감사합니다. 다음은 권봉 판사님.
So thank you very much. Next, Judge Wong.
A prominent Indian statistician, Rao, wrote in his book that all judgments are in their rationale statistics. I sometimes think that our law, including statutes and precedents, is the accumulated sum of solutions throughout history that were more likely to solve the given problems better. Furthermore, people today, including judges, seem to believe in numerical data more than wordy logic. I'm a pro-statistics judge. The spirit of this epoch forms the setting of the emergence of survey evidence in trademark case. The only statute that explicitly mentions survey evidence is the enforcement regulation of the trademark Article 28, which states that consumer awareness surveys may be submitted as evidence to prove the acquisition of distinctiveness through use. According to a study in 2020, survey evidence is submitted to prove or disprove consumer awareness, distinctiveness, similarity, or likelihood of confusion. And among them, consumer awareness surveys to investigate whether a mark is well known to consumers are most frequently conducted. With its high-speed internet connectivity, more and more surveys are conducted online in Korea. However, the survey method per se does not affect its probative power. Occasionally, both parties submit survey evidence and contest each other's survey, which is sometimes time and cost-consuming. To avoid that kind of situation, the patent court once took on a leading role in commissioning a survey. These days, the court sometimes involves in preparing the questionnaire before the parties commission their own survey. To guarantee the objectivity and reliability of survey evidence, the survey should conform to state-of-the-art survey methodology. I guess this is not very different among countries, so I'll advance to the conclusion. The court and the Korean IP office are trying to refine their standards and rules to embrace survey evidence as a new practice. I hope this conference will provide the opportunity to understand better and further invite discussions on this issue. Thank you for your attention.
네, 다음은 독일의 실무에 관해서 크리스티안 슈마츠 판사님의 동영상을 5분간 시청하겠습니다.
Ladies and gentlemen, I will now cover a very few aspects regarding the third and final section, trademark survey evidence. This part, however, will be a lot shorter because I was not able to find a lot of data regarding this topic. First of all, there are no special rules of evidence for trademark litigation in Germany. As regards consumer surveys, They are in particular used to address the question of whether a mark has acquired distinctiveness through use. These surveys are usually not used with regard to the perception of the relevant public, the similarity of signs, and finally, the likelihood of confusion. Rather, the specialized court establishing the facts may, especially if its members are part of the relevant public, consider these questions on its own. If the members of the court themselves belong to the relevant public, it is generally not necessary to take recourse to an expert opinion, supported by an opinion poll, in order to determine the understanding of the public. Even if the members of the court establishing the facts do not belong to the relevant public, they may assess the view of the relevant circles of experts on the basis of their own expertise, if no special knowledge or experience is required. Courts which are constantly involved in competition and trademark cases may, moreover, have acquired the necessary expertise to be able to independently assess how circles of experts or the public, which they do not belong to, perceive a certain sign. However, a taking of evidence is required if the court lacks the necessary expertise or if, despite of its own expertise, it must have doubts about the result. There are no general restrictions imposed on the types and methods of admissible surveys. However, the survey must be methodologically sound. There are no methods which are obligatory, and several different ways of conducting surveys can be distinguished, each with their advantages and disadvantages. Common interview modes are face-to-face interviews, by telephone, and online interfaces, mostly in the form of so-called online access panels. The appropriate method of conducting a survey should be chosen by a survey expert on a case-by-case basis. There are no specific types of surveys used for different issues. As to the question on how to overcome the time difference between the relevant date of examination and the time of survey, I would like to point out the following. For the assessment of the protectability of a trademark, the time of filing is decisive. Therefore, the acquired distinctiveness must also be present at the time of filing and still exist at the time of the decision on the application. In this regard, the Federal Court of Justice has held that longer periods of time between the filing date and the date on which a survey is conducted preclude the assumption that the result of the survey can be related back to the filing date. However, this depends on the particular circumstances of the case. The court further stated, at least in product areas in which the period of time between the filing of the application and the preparation of the survey may lead to a change in the market and the products, and thus to a change in the use of the sign in question, a retroactive relationship over a longer period of time is out of the question. Something else can only apply in special cases subject to strict conditions. This is to be assumed if the products in question do not change rapidly in special product areas and the market development can be reliably assessed over a longer period of time. Finally, I would like to introduce the guidelines issued by the German Patent and Trademark Office, which also contain advice on consumer surveys. Regarding the survey questions, these guidelines recommend the following approach. The first step in questioning is to determine whether the interviewee is a member of the relevant public. Then it is to be asked whether the respondent has already perceived the sign in question in connection with the goods or services claimed, so-called degree of awareness. Only then can the group of persons who know the sign or to whom it appears spontaneously familiar be asked whether they see it as an indication of a specific company or several companies, so-called degree of identification. The public who assessed the mark applied for as an indication of business origin for one or more companies must then be asked whether they can name them, so-called degree of attribution. The correct names do not have to be mentioned here, but the public that expressly assigns the trademark to another company is deducted. Care must be taken to ensure that the question about the degree of recognition in particular does not already suggest the origin indicating character of the sign. Once again, thank you very much for your attention.
네, 감사합니다. 김영기 판사님 질의 부탁드립니다.
So thank you very much, Judge Kim. You can ask your questions
We are
now.
over 6 p.m. already.
저희가 이미
Somebody
6시가
might feel
지났습니다.
starving. We are almost
다
done.
배고프시죠?
At this time, I want to call Professor Bernstein again. Professor, we know you are well known for leading the Booking.com case in the United States Supreme Court and win the big battle, right? Could you please briefly share your special experience through the case, especially what knowledge about using survey evidence in the U.S. court can we get from that case?
So we were engaged actually to represent Booking.com only in the Supreme Court. Another law firm handled the case below. But what was interesting was that the U.S. Patent and Trademark Office, in challenging the registration of Booking.com, never challenged the survey because they felt that the name legally was generic. That if you took a generic term and the case accepts that booking is a generic term for a website on which you can make bookings, and just append a top-level domain to it, booking.com, the position of the Trademark Office was, as a matter of law, that could never be a trademark. And so because the Patent and Trademark Office never challenged the survey, the Supreme Court didn't have the opportunity to really dig into whether the survey was properly done or not. It was just accepted that the survey was appropriate. We now have 2 other cases against the Trademark Office, and because they recognize that they lost that approach, they're being much more rigorous in attacking surveys and really looking at whether the surveys are appropriate. So I think we'll see a lot more litigation in the United States about the particular ways in which the survey is done. One other just interesting tidbit about the Booking.com case is that it was the very first case argued in the United States Supreme Court after the pandemic began. We actually had our argument date, and the Supreme Court went on lockdown and closed the court, and our argument was canceled. But a few weeks later, the Supreme Court decided to hear cases by telephone. And so our case was the first case ever argued in the United States by telephone. And then the last little tidbit is you probably have read that our Supreme Court can be very split on many issues. A lot of important cases are decided on a 5-4 basis. But we were quite pleased that we won this case 8-1, which I do think sends the message that there was a very broad consensus in the court for recognizing that trademarks like Booking.com, if they are perceived by consumers as being a brand name, should be protected.
Thank you. Thank you again. The last question goes to Your Honor, James Meller. You are the hero of this section. Okay, you mentioned, yes, this question is about requirements of trademark survey, reference book, page number 191. You mentioned in the questionnaire answer, through experience, courts have learned to distrust surveys conducted for the purpose of litigation. In particular, surveys to establish a likelihood of confusion or deception was subject to strict requirements laid down in the case law. Interflora case, like. They are required to pass a cost-benefit assessment, and generally such surveys are discouraged. You mentioned like that. Could you elaborate on this part? Why are stricter requirements imposed on the survey to establish a likelihood of confusion or deception? And with respect to cost-benefit assessment, what if party intends to prove the likelihood of confusion or deception through a survey evidence, irrespective of cost? In that case, would cost not permit such proof through a survey unless the strict requirements are met?
Yeah. Okay, we need to go back into the Interflora case a little bit because in Interflora number 1, what Lord Justice Lewis did, he reviewed every trademark case in which surveys were mentioned over the last, 40 years. And what he noted from his review is that very often surveys were not relied on by a judge. So he decided these were very costly pieces of evidence and they required a justification. That's why he established the cost-benefit test. Now, to understand these trademark cases, you need to understand that the likelihood of confusion is a question for the judge. In the UK, we call it a jury-type question, which means it's like you've got to make your mind up on it, but there aren't any guidelines to guide you. And what judges often did in these trademark cases is they would say, well, I think, leaving the survey aside, I think this mark would be confused with the other one, and my conclusion is confirmed by the survey evidence. That's in the few cases where survey evidence was relied upon. So Lord Justice Lewison concluded that actually surveys were generally they didn't work, but they were also very expensive. But going back to the question, a trademark trial in the UK generally costs a lot of money. And if say 10% of those costs relate to the survey and the parties are willing to spend that money, one might say, well, why shouldn't they? And so, there are many questions about the Interflora case, because although Lord Justice Lewison was clearly trying to reduce the cost of the litigation, I don't think he actually succeeded at all. Because quite often these surveys, they do cost a lot to undertake, and they cost even more for the lawyers to pore all over them and then to present them in court. But nonetheless, the cost of a survey generally quite a small percentage of the total cost of a trademark case. So it's another respect in which I think Lord Justice Lewison didn't really understand what was going on in survey cases and trademark cases. But nonetheless, we're stuck with the cost-benefit test.
Okay, thank you, Your Honor. Actually, I prepared more questions for Judge Su from China, but I cannot but skip the question. But finally, I want to take this opportunity to express my great appreciation for all the speakers' sincere answers to our long and in-depth questionnaire. It was really long, right? But not wrong. Right? Thank you.
자, 이상으로 모든 토픽에 관한
With
논의를
that,
마쳤습니다.
we
다만
finished
예정
all
시간을 크게
sessions
초과하진
that
않았기
have
때문에
been
현장에
planned,
계신
and since
참가자
we are
중
not
한두 가지
too over
질의가 있으시면
the
받겠습니다.
designated time, we will entertain one or two questions
없으시네요.
from the floor. Oh, do we have any questions from the floor? Yes, we do.
Booking.com, the court accept the 75% of survey as a token of distinctiveness. My question is kind of asking your personal question. If some surveys show above what percentage, there can be a sign of distinctiveness.
That's a very good question. So generally, because we're asking consumers, do you perceive this as a brand name or do you perceive it as a common name? We look to the majority. And so to show that a trademark is not generic, the number that courts generally are looking for is above 50%. And so here with Booking.com being at 75%, it was very high above the 50% threshold. If it gets very close to the threshold, then the courts may start to look at in more detail at the survey. For example, were the other terms that you used in the survey fair? One of the questions that came up here is how do we treat the 33% who said they thought washingmachine.com was a brand name? There was one expert who proposed that should be subtracted from the 75%. And if you subtracted that, it would bring it below 50. ultimately, as I mentioned in response to Judge Kim's question before, the U.S. Patent and Trademark Office didn't really challenge the methodology of the survey. They made the case more about the legal argument. But that is a question that we might have to face in cases in the future. Should we deduct, as Justice Schmaltz mentioned in the German situation, should we deduct the sort of wrong answers about washingmachine.com? When it comes to secondary meaning, so when it comes, this is whether or not the trademark is generic. When it comes to secondary meaning, courts typically look for 35% or more to establish secondary meaning. And when it comes to likelihood of confusion, courts typically say it's about 15% or higher, as I mentioned in one of my earlier slides. There's very good reasons to think that's wrong, that the number should be lower because of the way it was developed historically at a time before we had controls. But nevertheless, that is what the expected threshold is in the United States today.
네, 시간 관계상
Due
더
to
이상의
the time,
질의를 받지
we
못함을
won't be
양해해
able to
주셨습니다.
entertain any more questions.
주제에 관한
Please
자세한 내용을
kindly understand.
자료들을
You
참고해
can
주시기
refer to the reference book with
이번
regards to
세션에
details about
참여해
the
주신
topics that were discussed, and I extend my deep gratitude to all of our panelists once again. And also, my thanks goes out to all the participants online and in person. This closes our session 3. Thank you.
Thank you. That was a very fruitful session. Please join me in giving a big round of applause to the moderator and speakers of this session. 패널들께서는 그 무대에서 사진을 찍고 퇴장하시면 되겠습니다. Panelists will take a photo on the stage. Thank you all for a great session, and I also thank the audience for your attention. 오늘 참석해 주신 모든 분들께 대단히 감사드리며 청중석에 계신 분들께도 경청해 주셔서 깊이 감사드립니다. We will arrive at the end of our first day of the conference. I hope you enjoy pleasant evening and look forward to seeing you tomorrow. Thank you. 이것으로 2022 특허법원 컨퍼런스 1일차 행사를 모두 마치겠습니다. 편안한 저녁 보내시고 내일 뵙겠습니다. As the seats are pre-arranged during a banquet, please check your seat and be seated. Please stay on here for banquet. The banquet will begin at 6:40. 만찬 때는 좌석 배치가 변경됩니다. 참석 인원께서는 좌석을 확인해 주시기 바랍니다. 만찬은 18시 40분에 시작합니다. 그리고 대전역으로